Proceeding of the GST Moot Tribunal, I request SV sir to come on the dais. SV sir, please don't mind, please. आ जाइए sir. Sir, please. जब तक आप नहीं बैठेंगे सर कोई नहीं बैठेगा. We have the General Secretary of Association of Tax Lawyer, Mr. Advocate Rajnikant Verma ji. I request him to join SV sir, please. अभी सबके लिए कराते हैं. तो on the request of Dr. Rakesh Kumar ji, I request everyone to please give him a standing ovation. Now I request Advocate Vinod Raghav ji, please join us on the stage, please. I also request our senior member advocate SP Makkad ji to please come on the dais, please. I request CK Gupta ji to please come on the dais. एक चेयर और लगवा देना. एक चेयर और लगवा. मेरी चेयर है. आप बैठ जाओ ना यार. एक चेयर और लगाओ. किसी को बोलना. तनिष्क एक चेयर लगवा देना. Now I request our Deputy Convener CA Rashimi Jain ji, please join us on the dais. So friends, you are waiting for the last 1 month for this GST Moot Tribunal. Before we start the proceedings of this GST Moot Tribunal, we will take some time for our inaugural session. So let's start with presenting a Tulsi plant to our guests. So I request BV Diwan ji to present a Tulsi plant to our mentor Shri Sushil Verma ji. सर तुलसी प्लांट है, ले लो. पैसे दे दिया करो ना, 10 बेटा. मैम को देना. I request Kumar ji Bhatt to present a Tulsi plant to Shri Rajnikant Verma ji. I request Rajmani Jindal ji to present a Tulsi plant to SP Makkad ji. So I take the privilege to present a Tulsi plant to Gupta ji. Aye Gupta ji, please. I request Dr. Rakesh Kumar ji to present a Tulsi plant to Vinod Raghav ji. तो बाद में उनको बाद में दे देंगे. I request Varsha Jain ji to present a Tulsi plant to Rashimi Jain ji, her friends. Madam. Thank you all of you for such a beautiful gestures. Friends, मैं आज की अपनी deliberation को यहाँ से start करूँगा. When we watch a picture, we recognize the role of main lead actors like hero, heroine, and the villain. But we forget the role of the persons who work behind the camera. We in the past also recognize the role of these persons, and today also we are recognizing the role of two such personalities who are working behind the camera for us for the last many days. First one is CA Vineet Singhal. Vineet Singhal is a leading chartered accountant who is doing wonderful job for all of us for the arrangement of YouTube Live. And he did not charge any single penny from us. He is doing free of cost for all of us. So, and the second one is Mr. Pankaj. Mr. Pankaj Jha is the family friend of Mrs. and Mr. C.A. Rajiv Jain ji. Hanji, hanji. Whenever he ordered him for the manufacturing of mementos, at the 11th hour, he did not shy away and give it early morning. So I request SV sir and Rajnikant Verma ji to present a memento. Vineet ji unfortunately नहीं है हमारे बीच अभी, तो उनकी जगह रश्मि जी को दे सकते हैं memento.
We are grateful, sir. Thank you so much. We are grateful.
ठीक, तो विनीत सिंघल जी अभी हमारे बीच में नहीं है, तो उनका मोमेंटो हम बाद में दे देंगे. Friends, generally I don't speak much on the sessions, on the academic sessions, but today I will express my feeling for about all of you for the journey of this group. And I will start my deliberation with a share. मैं अकेला ही चला था जानिबे मंजिल मगर लोग आते गए कारवां बनता गया. This journey perfectly reflects the inspiring journey of that began 3.5 years ago with a vision nurtured by Shri SV Sir, who started the initiative with only 40 members and countless dreams in his eyes. At this time, many criticized it as a publical, professional, or you can say the professional stunt, you can say. But SV Sir stayed focused in his mission, a mission to spread education and knowledge among all, specifically the young professionals. I have been associated with this group since the inception. Initially, even I thought the journey would last till the completion of basic knowledge of the GST. But SV Sir had a much broader vision. After completing of the foundation course, he quickly shifted focus to more advanced areas, where he started teaching us how to interpret law and analyze the judgments. Under his guidance, we went on to study nearly 40 landmark judgments that have had a direct or indirect impact on the GST. What began on the 13th floor of the Delhi GST department soon found a new home at Malaviya Smriti Bhawan, where SV Sir started training young professionals not just in knowledge but in public speaking and presentation skills. I feel privileged to have been given the first chance to speak before the public. As our activities grew, so did our membership, expanding from 40 to over 200 members. Our representations, including me, have since delivered lectures at various prestigious platforms across Delhi and other cities. Mega conference, we have held one of the proudest moment for our group was the organization of a mega conference, a first of its kind event where 9 first-time speakers delivered outstanding lecture under the mentorship of SV sir. The event was attended by 250 members and marked a significant milestone for all of us. GST Moot Tribunal. The idea of the GST Moot Tribunal followed soon after. Today we are hosting the third GST Moot Tribunal after the success of 2 GST Moot Tribunals. And the result is आप सबके सामने है. Then we started the legal aid service. As we said, didn't stop here. Recognizing the need for the legal support among small traders, he launched the Legal Aid Committee. The initiative allows young professionals with up to 5 years of experience to assist clients by filing appeals before appellate authorities under the tribunal without charging any fees. Based on a simple affidavit, it's a step forward to both social responsibility and professional improvement. Help the needy. SV sir initiated to help students of law or any other professional who are in the need of financial help. Many members of this group have enrolled themselves for this work. 2 students are getting a financial help of rupees 5,000 per month from SV sir, who has not enrolled yet, so you can do it. We are clearly told to do all appellate work till High Court on our own, and SV sir and our team shall do the hand holding, and we are ready for this gesture. This group is under oath that we will charge no fees for any seminar, any lecture or any program, whether in the Delhi or outside the Delhi. So this was the journey, and इस जर्नी के आज एसवी सर जो कुछ कर रहे हैं, हम उनका 1% भी नहीं कर सकते. मैं आपके साथ एक छोटी सी स्टोरी शेयर करूंगा कि कैसे हम एसवी सर का साथ दे सकते हैं. तो उस स्टोरी को जरा ध्यान से सुनिएगा. उससे पहले मैं आपको एसवी सर के बारे में एक शेर बोलता हूं. कौन कहता है कि आसमां में सुराख हो नहीं सकता? कौन कहता है आसमां में सुराख हो नहीं सकता? एक पत्थर तो तबीयत से उछालो यारो. तो स्टोरी ये है कि एक राजा बड़ा दयालु था. उसने देखा कि उसकी प्रजा भूख से मर रही है या पैसे की कमी है, दिक्कत है. तो उसने अपने मंत्री को बुलाकर बोला कि क्यों ना लोगों की कुछ हेल्प की जाए. तो मंत्री ने कहा जैसा आपको वैसा कर लेते हैं. तो राजा ने कहा ठीक है, 3 दिन के लिए हर महीने राज्य के खजाने खोल देते हैं और जिसको जरूरत है, जो जरूरतमंद है, उसको हम वो खजाने में से पैसे देंगे. शर्त ये थी कि सुबह 10 बजे वो खजाने खुलेंगे और 5 बजे बंद हो जाएंगे. लोग आने शुरू हो गए, मुनादी हो गई, लोग आने शुरू हो गए, लाइनें लगनी शुरू हो गई. तो जिसका नंबर आया, जिसको पैसे जितनी जरूरत थी, राजा ने उसको पैसे दे दिए. एक बंदे का नंबर आया, तब तक खजाने बंद होने का टाइम हो गया. तो उसने सोचा चलो आज मेरी किस्मत में नहीं होगा तो मैं वो कल ट्राई करूंगा. नेक्स्ट डे वो सब 5 बजे जाकर लाइन में खड़ा हो जाता है और जैसे ही लाइन में खड़ा होता है उसके पीछे कोई और आके खड़ा हो जाता है. उससे पूछता है कि तू क्यों आया? कहता यार मेरी बेटी की शादी है, पैसे नहीं है तो मैं राजा से पैसे लेने आ गया. तो कहता तू आगे हो जा. ऐसा करते करते वो सबसे पीछे हो गया. उसको उस दिन भी उसको नंबर नहीं आया. कहता चलो कोई नहीं, मेरी किस्मत में नहीं होगा, अगले दिन फिर ट्राई करूंगा. तीसरे दिन गया, फिर वो आगे सबसे आगे आके खड़ा हो गया, फिर सबसे हेल्प करता करता सबके पीछे हो गया. राजा ये देख रहा था राजा ने उसको बुलाया, बोला कि तू कर क्या रहा है? तो रोज आता है, रोज सबसे आगे खड़ा होता है, फिर पीछे चला जाता है, खाली हाथ चला जाता है। तो उसने बड़ा मार्मिक सा जवाब दिया उस राजा को कि राजन, जो आप कर रहे हो मैं वही कर रहा हूँ। आपके पास खजाने हैं, आप खजाना बांट रहे हो, मेरे पास मेरी बारी है, मैं अपनी बारी बांट रहा हूँ। तो हम दोनों ही लोगों की हेल्प कर रहे हैं। तो एसपी सर जो कर रहे हैं वो कर रहे हैं, हम सिर्फ उनका साथ दे सकते हैं, अपनी बारी दे सकते हैं एसपी सर को। तो इन्हीं शब्दों के साथ मैं अपनी वाणी को विराम दूंगा और आज आपके सामने मैं अपनी डिप्टी कन्वेनर श्री रश्मि जैन जी को बुलाऊंगा। शी इज वेरी टैलेंटेड प्रोफेशनल। आप सबने उनको लेक्चर देते भी सुना है, आपने उनको आर्गू करते हुए सुना है, लेकिन आज वो एक सोशल स्पीच के लिए आ रही हैं। तो प्लीज वेलकम श्री रश्मि जैन जी।
Thank you, Narender ji. My dear professional colleagues, respected seniors on the dais, off the dais, welcome to the DGST world for continuous learning with and for us. It is indeed a great privilege to welcome you all to this third GST Moot Tribunal, being organized by the DGST Group in collaboration with the Confederation of Indian Traders, India. Friends, I can personally vouch that learning through such moot tribunals is a wonderful concept that is difficult to be explained in words. It has to be experienced. Many chartered accountants and advocates, including myself, have benefited to an extent we could not have imagined. Thank you for joining us in large numbers online and even more on YouTube channel, which is live now. Friends, today's topic is refund and its interplay with Section 73 and 74 DGST Act 2017. A total of 18 controversial topics will be addressed today, dealing with Section 54 refunds. Friends, the whole design of this moot tribunal is to debate important issues, so that in day-to-day practice and for giving opinions, we are well versed and with strategy and knowledge. The whole design of these moot tribunals is to debate important issues so that in day-to-day practice and for giving opinion, we are well versed with strategy and knowledge. All 10 appeals will be placed on our website, and SVSA briefing on each topic will also be available on the YouTube channel of the DGST group. I would like to take a moment to acknowledge the mastermind behind this initiative. This concept of moot tribunal is designed and directed by SVSA. It's his vision that we are holding our third moot and will be having another 3 more in the coming months. Friends, knowledge is power, and sharing your knowledge is indeed a powerful act, which one and only one SV sir can do. Can I? Friends, may I ask you all to give a standing ovation to SV sir? Yes. Thank you, friends. Friends, we are blessed to witness this magic of sharing and hand-holding. Am I right? Thank you. Before I close, I would like to express my deepest gratitude to our esteemed mentor, Advocate Sushil Verma ji. Sir, your expertise and insights are invaluable to our learning process. Thank you, sir. Once again, the DGST group is grateful for your gracious presence and for blessing our core team, for which we shall ever be grateful to you all. And to our host, a big salute from all the participants on the wonderful host, breakfast, equally good lunch, and high tea. And they are giving so generously to us. People have come from outside Delhi, from various states, which is a great gift to the DGST group. That would propel us to be more effective. We shall do our best. Thank you. Together we can, together we shall.
Thank you, Rashmi ji, for a wonderful deliberation. Now I request Rajnikant Verma ji to say a few words. Rajnikant Verma ji, please.
प्रिय मित्रों, आप सभी का आज की इस मूट ट्रिब्यूनल में बहुत बहुत अभिनंदन। और आगरा के आए हुए मेरे साथियों की ओर से जो मैं ये मौका नहीं है, आज मूट ट्रिब्यूनल को आप जो है एंजॉय कीजिए, लेकिन एक बात जो मैंने सीखी वो आपके साथ ज़रूर शेयर करूँगा। हमारे सुशील वर्मा जी ने कहा कि हमने ज़िंदगी में बहुत कुछ कमाया, अब ये सही समय है कि हम कुछ दे कर जाएं। और शायद मैं इनकम टैक्स करता हूँ, मेरा जीएसटी से दूर दूर तक नाता नहीं है। हमने पहली मूट ट्रिब्यूनल की मीटिंग में हम 5 लोग आए थे, दूसरी में 15 आए थे, आज हम 20 आए हैं। और इसके बाद भी बहुत से लोगों को हमने निराश किया, हम छोड़ कर आए। और अगली बार ले नहीं आएंगे, हम अगली बार आपको बुलाएंगे। और आशा करते हैं कि ज़्यादा से ज़्यादा लोग आगरा आएँ और ये कम से कम मेज़बानी करने का मौका हमें भी दें। इन्हीं शब्दों के साथ धन्यवाद।
थैंक यू सर, थैंक यू। आपका आमंत्रण हम स्वीकार करते हैं और जल्द से जल्द हम आगरा आने का प्रोग्राम बनाएंगे। सो फ्रेंड्स, विदाउट वेस्टिंग टाइम मैं रिक्वेस्ट करूंगा एसपी सर से कि वो आएँ 5 मिनट के लिए और उससे के बाद हम अपनी जीएसटी मूट ट्रिब्यूनल की प्रोसीडिंग को शुरू करें। एसपी सर।
Honorable Dr. Rakesh Kumar ji, Chairman of the Tribunal, our technical member, Shri K.P. Singh ji, friends on the dais and off the dais. Coming here will not help you. You can spend a day here listening to all what we talk. You have to go back, relearn it, or unlearn what you wouldn't understand, or what you don't like here. If you want to be a good professional, passion, dedication is not enough. You have to have a quality of perseverance. You have to persist in learning. If you can't persist, don't follow this path. We are lawyers. Law should not be loved. Law has to be practiced. There is no love for law. And law is not equal to justice. Law is what we read. Justice is an abstract term. We all know the case of Nirbhaya, where a juvenile caused maximum wounds to the girl, but law was he was below 18 years. So Supreme Court said you can't try him an adult. The entire country was after that. And he was in jail for 3 years, so today is a free bird. So we lawyers can practice law. Justice is in the hand of judges. Their perception, their knowledge, that's why we call justice is an abstract term which cannot be defined. On the same argument you may win, in the other court on the same argument you may lose. Because this depends on subjectivity, appreciation of judges' wisdom and knowledge. Therefore, whatever you study here in this group has no other mission whatsoever. It will never be an association. None of our core team members can ever join politics of any bar. If they do, they'll be out. We are not into any kind of politics. Nobody can market here. The e-newsletter which we circulate, you must take hard copies. That's a very invaluable document where we spend 6-7 days in drafting the 30-40 pages. It has 10 leading judgments, 8-10 opinions, articles, legal trivia. In legal trivia also we give you 7-8 judgments which are relevant for your practice. The biggest contribution this core team is making towards this group. There's a core team of 12 people, of which our members tribunal are also the members. They are also members of the group. Nobody takes a decision here. Idea is mooted, everybody agrees, we start. And let me share with you, we have never done accounting in this group. I don't know from where the money comes, who hosts lunch, who pays. We have no idea at all. So such is the passion this group has created all over the country. Mr. Praveen Khandelwal, who is a BJP MP, my friend, is the chairman of the group. And in October, we are going to hold a conference which members of this line would have never imagined that tax professionals can hold that kind of a conference. It will not be on GST. There will be 3 more tribunals, Moot tribunals, and we may continue. I think it's a good concept to learn more. Next will be 12th August on works contracts and government services. And I can tell you, as one of the leading lawyers in this line, infrastructure, this will be the biggest ever litigation that will happen in this country is works contracts. Infrastructure. जो आप ये trader के ये IT से खा गया, ये खा गया, वो खा गया, makes no sense now. It's a very boring subject. Get into new areas. That's why Rashmi said knowledge is power. We will give you knowledge. I guarantee you the knowledge you get here, you will get nowhere in the country. We are not doing any marketing here. We don't want 100,000 YouTube channel subscribers. We don't want it. We are enough what we are enough. And all these appeals which you get free of cost on our website, they are not easy appeals to handle. Whatever topics you can think of in law on that topic, those appeals cover, along with the latest judgments. You take out, it's in Word file. You can print, make files. Registration 29-2, 1 folder. Input tax credit 11 appeals, 2nd folder. Today refunds, 3rd folder. And I can tell you in day-to-day practice, you will not come across ever in this country a point which is not covered by these appeals. And that's the service this team has done to you. And if you think that these appeals are easily drafted, no. All the counsels have to go through such a serious grilling so that everything they can think they have to write. And there is no AI used in these appeals. These lawyers cannot use, if they use AI, I'll catch them and their appeal will be thrown out. No, no AI. You have to write original. In this e-newsletter, I have written an article, should we follow electronic jurisprudence? Read this article. It will forewarn you if you use this chat GTP, Genrico, all this, that this has no meaning for lawyers. What I have seen in recent days, people have used AIs for their clients, it was a suicide. They are writing provisions of Indian Penal Code. Value added tax is gone 17. आज भी वो कट पेस्ट चैट जीटीपी से उठा के डाल दिया उसमें. So when you take up these cases to courts or arbitration, these contracts are private contracts. No court can give an interpretation which is different than the parties have agreed to. So you are out, you lost money. Therefore, spend time. When you go back, think of this tribunal. See YouTube again, spend time. You have to spend only 4 or 5 hours. Spend 3, 4, 5 times. You will learn more. Then think of the issues you have in your day-to-day practice. You will find all answers there. In my opinion, refund, there were 18, 19 issues which were very important. The other, in every appeal you will see, there are interlocutory applications for condonation, additional evidence, application for examining people. These applications, I don't think all of you can draft even today. Even the application drafted by these counsels have a lot of deficiencies. So you have to learn this, because once you go to tribunal, you cannot bring any new evidence which was not a part of the lower proceedings. The members will shut you up. Okay, these documents are not there. So why here? So you have to make out a case to persuade the honorable tribunal members to accept your additional evidence. And if it's not accepted, your case is finished. Therefore, all this you learn here. That's the group that will teach you. And this group will go to places very, very soon. Maybe we will go to Bangladesh to teach Indian GST very soon. Things are on. Sri Lanka also people are calling, we want to understand Indian law. And I can tell you, this DST group have 25, 30 people who are giving 4-5 hours a day of their professional time to nurture this group. 4-5 hours. And even till night they spend. And like he said, akela chalate chalte chale gaye. So we have people who are doing pro bono work. Like Mr. Pankaj, what money we give him is a peanut for whatever he does for us. Vinny Single is free. His entire setup costs every month 20-25,000 rupees. We can't afford. Yes, we have a graphic, this young girl, Nishtha Garg. She designs all these posters free of cost. So there are people who are trying to help these judges who had left practice. We have put them back in this groove. You know, so we need your services. Let's give two judges our standing ovation for the wonderful work they have done so far. This is Dr. Rakesh Kumar, his chairman, advocate, and Mr. KP Singh, Chartered Account Technical Member. And for any help you need, we have our website phone number. You can give a call, it will be picked up, you will be answered, or write on our email. Now, this time you will get YouTube link. It will carry all this Instagram, Facebook, everything. Every day I circulate 2-3 judgments in 3-4 lines. Just to tell you that this judgment means this. You can read it. But do not have shortcuts in life. This bribing business, paise wala dhanda, better you leave as early as possible. Because today the surveillance, the intelligence, the information technology is very fast. When will you get caught? We don't know. Yesterday also I circulated a magazine, a CA got involved into 341 crore fraud. His family is finished. He cannot get away. So please be very careful. Do not run after money. Knowledge will make money run after you. That is the power you have to get. With these words, thank you so much for coming in large numbers. And we shall continue. And I'm sure we shall continue to receive your cooperation. God bless you. Thank you for coming.
Thank you, sir, for such an important inputs to all of us. Now, friends, I am going to release my e-newsletter, 6th edition, to the Delhi GST Professional Group. Members who are not associated with this group can contact me after the session. I will add them in the group. Thank you very much. Thank you all of you. So now we start the GST Moot Tribunal.
Hi friends, we are a core team of DGST group. I am Sushil Verma. With me are my colleagues of this Delhi GST Professionals group. We have started an innovative idea of creating GST moot tribunals where more than 150 lawyers, CAs and company secretaries come, and the honorable tribunal is headed by 2 or 3 members, lawyers and chartered accountants. One of them technical members, Mr. KP Singh, we have with us today. And the idea of this GST Moot Tribunal is to prepare people for litigation in tribunals, especially youngsters one, whether they are CAs, advocates or company secretaries. Now, this idea was created a few months ago by our core team, and we implemented it. It has been a huge success. We encourage younger lawyers and CAs to come prepare the appeals based on orders this team creates, right from show cause notice to reply to adjudication order and the first appellate order. Now they are learning to create evidences before the tribunal. They are learning law. They are learning speaking skills, and they are learning where to be aggressive, where not to be aggressive. And I am the government counsel. I mean, this is not my profession, but I think to give them better training, and therefore I've taken the role of government counsel. All the appeals they prepare are available on our website, the link of which is given below. And already, this is the third tribunal today. We have held on section 29(2), RC cancellation. We have held on section 16, 17, 18, 19, 20 input tax credit, and today we are on refunds. So more than 15, 16 appeals are already on our website, which all of you can download free of charge, and these are also in Word form. You also have on our website the latest judgments in 3-4 lines, just the point of law settled. So that also you can go through. And we also have a program of free legal aid for youngsters up to 5-year practice where they need any help for any appeal work, provided they don't charge their clients. If they charge their clients, then there can be an issue. And also we have this legal aid program for needy people. This group also has a program for helping poor students who can't afford their fees. So you can send a recommendation to our core committee on our website if you have somebody who needs financial help, and our members will pay 5,000 rupees per month. Already we have 2 people who are getting this aid. And friends, this Moot tribunal are on YouTube live. Therefore, wherever you are in the country or wherever you are in the world, you can see this. And these appeals are argued by very senior professionals who are adept in their field. And the judgments are given by members without any
doing some share of shairi and keep you entertaining, because DGST group is not only about knowledge, it's about being a part of the family which it is always said, which runs together, laughs together, cries together, works together, studies together, and infinite possibilities being together. Friends, we have our guests here from Agra today, and the person who's representing them, I don't want to name him, but he said a very good thing कि मेरा income tax GST से कोई वास्ता नहीं है, but हम लोग बढ़ते गए हैं अपनी presence में, right sir? सर मेरा भी income tax से कोई वास्ता नहीं है, लेकिन मैं आपको यहाँ पे DGST group की एक अच्छी बात बता दूं. Just a session before we started the Moot tribunals, I, along with some other colleagues of mine, were given an order, rather not an opportunity, to present the new income tax, the insights about the new income tax law. And I don't mind telling that I don't even know the I of the income tax, and I had to study to the best of the possibilities. Of course, I think I did not perform well, but I still tried because of our mentor, who gave me and charged us so much, me and as well as other colleagues, to actually even read the new income tax law and understand and look at the horizons which would, bring in opportunities for all of us, not only for work. Like sir rightly said, that once you study hard, the money will follow you, right? So sir, उसी बात पे शेरो शायरी में कुछ कहना चाहूँगा. I think we are almost done. कहीं सुनी थी, जिनके आते थे सवाल उनके सलाम आने लगे, जिनके आते थे सलाम उनके सलाम आने लगे. अब समा ऐसा हो गया है DGST में आने के बाद कि नीम के पेड़ पे भी आम आने लगे. सो आपको इनकम टैक्स आता हो या GST, कुछ सालों के बाद दोनों आ जाएंगे. थैंक यू.
अभी आप रुको, जब आपको बुलाएंगे तब रखना. यहाँ रख लो नीचे. ए कैपिटल है.
वो परिवार हमेशा समृद्ध होता है जो अपने बड़ों का आदर करता है. लेकिन ये पहली बार देख रहा हूं कि एडवोकेट या चार्टर्ड अकाउंटेंट या प्रोफेशनल्स अपने परिवार के बड़ों का सम्मान कर रहे हैं. सुशील जी जीवन के उन सारे मापदंडों पर खरे उतरते हैं, जिन मापदंडों के आधार पर आप सम्मान पूर्वक जीवन जी सकते हैं। लेकिन वो शिक्षक, वो पिता उस समय प्रसन्न होता है जब उसको दिखाई देता है कि मैंने जीवन में जो कुछ दिया वो किसी के काम आया।
So people like S.C. Bhatia are God's messengers for us.
आज के इस बहुत ही शिष्ट और विशिष्ट कार्यक्रम में
सर ये भी वैसे चल गया।
सर यहाँ आ गए जी, जहाँ हमने भारतीय परंपरा को जीवित होते देखा है। हमारे परिवार के मुखिया आदरणीय श्री एच.सी. भाटिया जी का सम्मान हुआ। वो परिवार हमेशा समृद्ध होता है जो अपने बड़ों का आदर करता है, और ये हमारी संस्कृति और हमारी सभ्यता भी है। जब भाटिया जी का सम्मान हो रहा था, भाटिया जी बार बार रोक रहे थे, बहुत हो गया यार, कितना करोगे। भाटिया जी, एक पिता बहुत प्रसन्न होता है जब उसके पुत्र से उसको जाना जाता है। मुझे याद है पहले जब लोग मुझे जानते थे तो वो कहते थे ये प्रवीण खंडेलवाल, विजय खंडेलवाल जी के सुपुत्र हैं। और एक मौका जीवन में ऐसा आया जब मेरे पिता ने मेरी पीठ थपथपाई और ये कहा कि आज मैं धन्य हो गया, आज मुझे एक व्यक्ति मिला और उसने कहा कि आप प्रवीण जी के पिता हैं। तो आज ये वही क्षण है कि ये पूरा ग्रुप आज वो परिवार हमेशा समृद्ध होता है जो अपने बड़ों का आदर करता है। लेकिन ये पहली बार देख रहा हूं कि एडवोकेट या चार्टर्ड अकाउंटेंट या प्रोफेशनल्स अपने परिवार के बड़ों का सम्मान कर रहे हैं। सुशील जी जीवन के उन सारे मापदंडों पर खरे उतरते हैं जिन मापदंडों के आधार पर आप सम्मान पूर्वक जीवन जी सकते हैं। लेकिन वो शिक्षक, वो पिता उस समय प्रसन्न होता है जब उसको दिखाई देता है कि मैंने जीवन में जो कुछ दिया वो किसी के काम आया।
So people like S.C. Bhatia are God's messengers for us.
आज के इस बहुत ही शिष्ट और विशिष्ट कार्यक्रम में
सर ये भी वैसे चल गया।
सर यहाँ आ गए जी, जहाँ हमने भारतीय परंपरा को जीवित होते देखा है। हमारे परिवार के मुखिया आदरणीय श्री एच.सी. भाटिया जी का सम्मान हुआ। वो परिवार हमेशा समृद्ध होता है जो अपने बड़ों का आदर करता है, और ये हमारी संस्कृति और हमारी सभ्यता भी है। जब भाटिया जी का सम्मान हो रहा था, भाटिया जी बार बार रोक रहे थे, बहुत हो गया यार, कितना करोगे। भाटिया जी, एक पिता बहुत प्रसन्न होता है जब उसके पुत्र से उसको जाना जाता है। मुझे याद है
श्री एस.सी.
पहले जब
प्लीज गिव हिम ए स्टैंडिंग ओवेशन। सर आप हम सबके गुरु हैं। गुरुओं के गुरु हैं।
लेकिन आज गुरुजी ने हुक्म माना है, मैं कहा जी व्हाइट कपड़े पहन के नहीं आओगे, स्मार्ट बन के आए हो। स्मार्ट बन के आए हैं, देख लो।
आज आपके समक्ष वो जीएसटी इनकम टैक्स कुछ नहीं पढ़ाएंगे, आज सिर्फ आपको रामायण के बारे में कुछ बताएंगे। तो विदाउट वेस्टिंग टाइम आई रिक्वेस्ट एससी सर, आइए प्लीज सर। सर आइए सर, आइए प्लीज 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 सर आइए, आइए।
बाद में करूंगा ना, 15-20 मिनट का है, इसलिए लंच के बाद कर रहे हैं।
कोई नहीं, अभी तो मेरा स्टार्ट भी नहीं हुआ।
लोगों का भला होगा, जजों को और किस टाइम मिलेगी, रिलीफ देंगे लोगों को।
नहीं सबसे पहले तो आप सबका हार्दिक स्वागत और धन्यवाद। और मुझ जैसे साधारण व्यक्ति से को ये मौका दिया कुछ कहने का, मुझे सुनने के लिए भी। अगर किसी से पूछा जाए कि एजुकेशन इम्पोर्टेंट है या नॉलेज इम्पोर्टेंट है, आप क्या कहेंगे? नॉलेज। बीइंग नॉलेजेबल और बीइंग वाइज, व्हाट इज इम्पोर्टेंट? बीइंग वाइज। और वाइज होने के लिए ज़रूरी नहीं कि आप पढ़े लिखे हों, आप नॉलेजेबल हों। उसी के लिए एक ये रामचरितमानस का, एक्चुअली में तो रामचरितमानस अगर आप सबने पढ़ी हो, रामचरितमानस के जितने भी पात्र हैं वो आदर्श हैं। सिर्फ राम, लक्ष्मण, सीता, भरत, शत्रुघ्न, हनुमान जी, इनकी बात ना करें, और भी जितने पात्र हैं, यहाँ तक कि रावण के परिवार के भी अगर आप देखें, मेघनाथ को देख लीजिए कि जब पिता को लगा कि और कोई नहीं रहा, मेघनाथ ने युद्ध किया। केवट के ही प्रसंग के विषय में कुछ कहूँगा। आप देखेंगे केवट पढ़ा लिखा नहीं था, पर कितना बुद्धिमान था, ये पता चलेगा इस दृष्टांत से जो केवट के बारे में है। और ये देखिए कि होनी कितनी प्रबल होती है। बड़े से बड़े गुरु लोगों ने रामचंद्र जी के राज्याभिषेक के लिए एक मुहूर्त निकाला, और एक दिन पहले रात को ही कैकेयी ने अपने वर मांगे कि इनको आप 14 वर्ष के लिए वनवास में भेज दिए और मेरे पुत्र को राज्य दे दें, भरत को। दूसरे दिन ही उनको वनगमन के लिए जाना पड़ा। पहले दिन और जब रामचंद्र जी ने जाने की सोची तो सारी अयोध्या नगरी, करीब करीब इवन बच्चे बूढ़े सब उनके साथ हो लिए कि हम तो आपके साथ ही जाएंगे। पहले दिन एक तमसा नदी थी, उसके किनारे रुके और उनको लगा कि भाई ये लोग मेरे साथ वन में कहाँ जाएंगे। उन्होंने अपने सुमंत्र को बुलाया जो रथ चला रहा था उनका, उसको कहा कि रात के वक्त जब सब लोग सो रहे थे, कैसे रथ को इस तरह से लेके जाओ घुमा फिरा के कि किसी को पता न चले कि हम कहाँ गए हैं। और सुमंत्र ने भी यही किया कि रथ को इधर घुमा उधर घुमा और चला गया। सुबह लोग उठे हैरान, इधर उधर भागे हर दिशा के अंदर, पर उनको पता नहीं चला कि किधर गए हैं। दूसरे दिन सुबह ये पहुँचे श्रृंगवेरपुर नगर के अंदर, श्रृंगवेरपुर में जो गंगा जी के किनारे था। ये गांव भीलों का था, जिनको हमेशा से पतित, अधम इस तरह से माना जाता था। हालांकि वो सदियों से उनके पुरखे भी यमुना के, ये गंगा जी के किनारे रहते थे, पर कोई उनसे बात नहीं करता था। यहाँ तक कि उनकी अगर परछाई भी पड़ जाए, उसको भी ये माना जाता था कि हमारे साथ जो है, कोई उनकी परछाई भी अपने उसके नज़दीक में नहीं जाता था। बात करनी तो बात दूर है। सब लोग उनके बहुत ही उनको निकृष्ट मानते थे। तो रामचंद्र जी जब वहाँ पहुँचे तो उनके श्रृंगेरपुर एक छोटा सा गांव था भीलों का, जहाँ उनकी झोपड़ियाँ थी। उनके राजा थे गुह, निषाद राज गुह। जब उनको पता चला कि रामचंद्र जी यहाँ आ रहे हैं तो उनको लगा कि इन्होंने ऋषि गौतम की पत्नी अहिल्या जो थी, जब उस शिला को छुआ तो वो फिर से ऋषि अहिल्या के रूप में निकली। क्योंकि जब उन्होंने इसका उद्धार किया है तो मन में एक विश्वास था कि हमारा भी उद्धार, अगर ये आएंगे, विश्वास था कि अगर उसका किया है, उसकी झोपड़ी में गए थे, तो हमारा भी उद्धार करेंगे। और मन में ये था कि हमें छुएंगे तो नहीं, हम लोग इतने अधम हैं, हमारी तरफ देखेंगे भी नहीं, ना हमारे से बात भी नहीं करेंगे। पर यह था कि अगर हमारी तरफ देख भी लेंगे तो हमारा जीवन सफल हो जाएगा। जब दूसरे दिन सुबह राम, लक्ष्मण, सीता जी गंगा में स्नान करके वहाँ पहुँचे तो गुहराज अपने परिवार के साथ आया। उसने दूर से ही जो फल फूल लाया हुआ था रेत के अंदर रख दिए उनके सामने, और उसने कहा, महाराज, एक आज अधम आपके सामने, एक पतित आपके सामने आया है, उसे आप पावन कर दीजिए। और ज्यों ही वो उनको प्रणाम करने के लिए झुका, रामचंद्र जी ने देखा कि गुहराज जो था उसकी आंखों के अंदर पानी है। वो दौड़ कर गए और उसको बोले, घू क्या करते हो? उठा करके उसे गले लगा लिया। हम राम राज्य की बात करते हैं। जिस जाति के लोगों को सदियों से जो गंगा के किनारे रहते थे और उस जाति के लोगों को बहुत ही छोटा और अधम माना जाता था, रामचंद्र जी ने उसको, जिनको अछूत माना जाता था, जिनकी परछाई को भी लोग नहीं, परछाई से भी दूर भागते थे, उसको अपने गले लगा लिया। तो राम राज्य की शुरुआत वहाँ से हुई। वो पहला दिन था जब राम राज्य की शुरुआत हुई। आज हम राम राज्य की बात करते हैं। तो निषाद राज ने कहा, गुरु ने, कि महाराज आप आए हैं तो हमारे नगर में पधारिए। लक्ष्मण को हंसी आ गई। लक्ष्मण जी ने कहा, महाराज आपने इसको गले क्या लगा लिया? अब ये देखिए, अपने झोपड़ियों के छोटे से गांव को भी ये नगर कह रहा है। गुरुराज को ये व्यंग समझ में आ गया और उसने कहा, महाराज लक्ष्मण जी कह रहे हैं कि ये झोपड़ियों को गांव में मैंने नगर क्यों कहा? मेरा ये मानना है कि जहाँ आप जाते हैं, चाहे वो गांव भी क्यों हो ना, वो नगर बन जाता है। अवध तहाँ जहाँ राम निवासु, जहाँ राम निवास करेंगे वो अवध बन जाएगा। और जाकर के अवध की हालत देखिए, वो तो वहाँ तो मतलब एक तरह से सन्नाटा है, वहाँ कोई है ही नहीं अवध के अंदर, तो इसीलिए मैंने इसको नगर कहा था। तो फिर उसने कहा, जी आप फिर अगर वनवास में आए हैं तो यहाँ हमारे इसमें ठहरी है। उनका नहीं, मेरे को पिता की आज्ञा ये थी कि मैंने वन में ठहरना है, इसलिए मैं यहाँ नहीं रुकूंगा। उनका अच्छा ठीक है, रात भर आप यहाँ रह जाएँ। तो राम जी, क्यों मेरे को ठहराना चाहते हो? ये भी देखिए, जो राजा होता है या कितनी उसकी विशाल वो होती है, कहेंगे मैं और मेरा परिवार तो मिल लिए हैं, पर जो हमारे गांव के बाकी लोग हैं उनको नहीं पता था कि आप आ रहे हैं। नहीं तो वो आज काम पर, हम वो लोग करते क्या, मेहनत मजदूरी करते हैं, लकड़ियां काट के लाते हैं, जानवरों का शिकार कर देते हैं, फल फूल लाते हैं। तो अगर मैंने आपके दर्शन कर लिए तो उनको भी आपके दर्शन का हक मिलना चाहिए, इसलिए मैं कह रहा हूँ कि आप यहाँ पर आज ठहर जाएं। जब वो लोग जंगल से वापस आ रहे थे, बाकी भील लोग, तो गू ने ऊंची आवाज़ में कहा, आप सब लोग आ जाएं, आज हमारे उद्धारक यहाँ पधारे हैं। अब वो लोग तो, उनको समझ ही नहीं कि किस तरह से किसी का स्वागत किया जाता है। होड़ लग गई, भागे हुए आए। जिसके हाथ में जो था, उनको तो ये भी नहीं पता कि भेंट क्या देनी है। जिसके आगे जो था, किसी के हाथ में लकड़ी है तो लकड़ी उनको रामचंद्र जी के आगे रख रहा है, फल है तो फल उनके आगे रख रहे हैं। और फिर रामचंद्र जी ने एक एक करके सबको मिले रामचंद्र जी, जितने भी लोग वहाँ पर आए थे। रात को उन्होंने कहा, जी मैं आपके लिए और सीता जी के लिए ये जो घास फूस है उसके भी दो उन्होंने वो बना दिए कि आप यहाँ शीशम के पेड़ के नीचे ठहरें। और लक्ष्मण जी ने तो वो कहा था कि मैं जब तक रामचंद्र जी हैं मैं रात को सोऊंगा नहीं, मैं इनकी रक्षा करूँगा। लक्ष्मण जी और गू बैठ गए उनकी रक्षा करने के लिए। गू ने सबको कह दिया कि आप लोग सारी रात आज पहरा देंगे, कोई जानवर इनको परेशान ना करे। उन लोगों को हैरानी हुई कि ये हमें क्यों कह, जानवर तो हमारे नाम से डरते हैं यहाँ पर भील लोगों से कि हम इनको मार न दें। तो ऐसा क्यों कह रहे हैं? इसका कारण ये था, गू को ध्यान था कि ये तमसा नदी के किनारे अयोध्या वासियों को छोड़ के आगे आ गए थे। उसके मन में ये था कि ये नो कि हमें भी छोड़ के चले जाएं। इस तरह से उसने रामचंद्र जी और लक्ष्मण जी को और सीता जी को वहाँ रोक लिया। तो रात को जब गू और लक्ष्मण जी बैठे तो गू ने कुछ ऐसे ही कैकेयी जी के बारे में बोला कि उन्होंने बहुत गलत किया ये है। तो लक्ष्मण जी ने कहा कि ऐसी बात मत कहिए, जो जिसके भाग्य में लिखा है वो होना है। और फिर बातचीत के अंदर गू ने कहा कि राम जो हैं वो ब्रह्म हैं और उनके चरणों में ही दुनिया के जितने परमार्थ हैं वो उनके चरणों के अंदर हैं। सुबह हुई तो उन्होंने गंगा पार करनी थी। रात में जितने भी भील थे जो नाव चलाते थे उनमें एक आपस में स्पर्धा हो गई कि सबकी ये इच्छा कि रामचंद्र जी हमारी नाव के अंदर बैठें। तो कोई अपनी नाव को फूलों से सजा रहा है, कोई अगर टूटी हुई है तो उसको ठीक कर रहा है, कोई उसको रंग कर रहा है। केवट भी उनमें से एक था। तो उसको भी ये था कि रामचंद्र जी मेरी नाव में बैठें, परंतु उसने अपनी पत्नी से कहा, उसकी आंखों में आंसू, कि हमारी तो टूटी ही नाव है, रामचंद्र जी जब इतनी अच्छी अच्छी नाव बन रही हैं तो हमारी नाव में कैसे बैठेंगे? पर अगर वो मेरी नाव में ना बैठे तो मेरा तो जीवन व्यर्थ हो जाएगा। तो पत्नी ने कहा कि अगर हमारे भाग्य में हुआ तो हमारी ही नाव में बैठेंगे और किसी नाव में नहीं बैठेंगे। केवट को ध्यान आया कि साल भर पहले निषाद, घूराज निषाद जंगल से आखेट करके आ रहे थे और उनको आखेट मिला नहीं था और केवट अपने सिर पर लकड़ियाँ लेकर के जा रहा था। तो उन्होंने कहा, केवट मुझे पानी पिला, मुझे बहुत प्यास लगी है। केवट ने लकड़ियाँ फेंकी, उनके लिए जल लेकर के आया। तो उन्होंने कहा कि तूने आज अपने स्वामी को तृप्त किया है, उसकी प्यास बुझाई है, जो मांगना है मांग ले। उसने कहा नहीं, ये तो मेरा फ़र्ज़ था, मेरी ड्यूटी थी कि मैं आपके लिए जल लेके आया हूँ, पर फिर भी अगर आपने देना है तो मैं बाद में कभी भी मांग लूँगा। बोले ठीक है। केवट को याद आया कि गुरुराज ने मेरे को ये वचन दिया था। तो उसने उनको कहा, सुबह सुबह जब जाने लगे तो उनका, गुरुराज आपको ध्यान है कि आपने मेरे को एक वचन दिया था? बोला हाँ। तो कहते उसे पूरा करोगे? कहते एक क्यों, आज राम जी आए हैं, दो मांग ले। कहने लगा नहीं, एक ही चाहिए। बोलो क्या? कहते आज आप मनादी करा दें, ढिंढोरा पिटवा दें कि और किसी की नाव गंगा के किनारे नहीं लगेगी, सिर्फ मेरी नाव गंगा के किनारे सुबह से शाम तक, सूर्योदय से सूर्यास्त तक सिर्फ मेरी नाव वहाँ लगेगी। वो वचनबद्ध था। बोले वचन पूरा करोगे? बोले हाँ। मुनादी करा दी गई कि और कोई नाव नहीं लगेगी, सिर्फ केवट की नाव लगेगी। अब जब रामचंद्र जी गंगा पार करनी थी, आए तो देखा केवट की नाव है। उन्होंने केवट से वो नाव मांगी कि भैया हमें ये नाव दे दो और ये गंगा पार करा दो। अगर आप रामचरितमानस देखें तो सिर्फ दो ही समय हैं जब रामचंद्र जी ने कुछ मांगा किसी से, और एक मांगा था शिव जी से जब सती हुई थी दक्ष के यहाँ पर, और अगले जन्म में वो पार्वती के रूप में जब पैदा हुई, शैलपुत्री थी, और शिव जी अब तक उससे बाहर नहीं आए थे सती होने से। तो रामचंद्र जी ने कहा, सब देवताओं ने कहा, तो रामचंद्र जी ने उनसे कहा कि मैं आपसे एक ही चीज़ मांगता हूँ कि आप शैलपुत्री से आप विवाह कर लें। और दूसरी बार उन्होंने केवट से ये नाव मांगी। तो केवट ने कहा नहीं, मैं तो नहीं ले जाऊँगा आपको, मैं तो आपको मर्म जानता हूँ, आप क्या हैं मैं जानता हूँ मैं, इसलिए मैं आपको नाव नहीं दूंगा। रामचंद्र जी हैरान तो नहीं। उनका क्यों भाई, क्या हो गया? कहते जी मेरे को पता है कि आपने एक पत्थर की शिला को जब पैर लगाया तो वो स्त्री बन गई, वो तो पत्थर था, और मेरी नाव तो लकड़ी की है और पानी में रहती है, ये तो और भी नर्म है। अगर इसको आप छुएंगे और ये भी स्त्री बन गई तो मेरी तो रोजी रोटी जाएगी, मैं तो आपको नहीं बिठाऊंगा, मैं आपका मर्म जानता हूँ। उसने ये वर्ड यूज़ किए। तो मर्म यही था कि आप जिसको भी छूते हैं वो तो कुछ बन जाता है। तो रामचंद्र जी ने कहा फिर? कहता है ऐसा कर लीजिए, या तो मेरी बात मानिए, नहीं तो गंगा के किनारे जाएं, जहाँ पर पानी कम होगा वहाँ से आप पार कर लीजिएगा। पर मैं ये जानता हूँ कि आपको तैरना नहीं आता, आप तीनों को, तो आप पार नहीं कर पाएंगे। फिर मैं तो आपके जब तक चरण नहीं धोऊंगा अपने हिसाब से, तब तक मैं आपको अपनी नाव में नहीं बिठाऊंगा, जिससे कि मेरी नाव भी कहीं स्त्री ना बन जाए। अब कोई चारा नहीं था। रामचंद्र जी ने कहा भाई अच्छा ठीक है कर। कहेंगे हमारे में हम हालांकि अनपढ़ हैं पर ये जानते हैं कि जब भी कोई अच्छा काम करना होता है तो स्त्री भी साथ, पत्नी भी साथ होनी चाहिए। तो मैं अपनी पत्नी को बुला लाता हूँ। गया पत्नी को, उसने कहा भाई तेरी बात ठीक थी, उन्होंने हमारी बात मान ली, हमारी ही नाव के अंदर बैठ रहे हैं, पर उनके अब चरण धोने हैं तो क्या करें। तो पत्नी बोली भी अगर हमारे पास सोने या चांदी के बर्तन होते तो उनसे हम उनके पैर धोते, पर हमारे यहाँ तो एक तांबे का बर्तन है और उसको केवट का नहीं मैंने वो इंतज़ाम कर लिया। बोली कैसे। तो कहने एक काठ की वो कठौती होती है जो ये लोग नाव में रखते हैं कि जिससे अगर नाव में पानी आ जाए तो निकालते रहते हैं। तो कहने मैंने ये सोचा कठौती में उनके पैर धोएंगे। कठौती में? कहते हैं हाँ। कहते ये देखना नाव में तो हमारी बैठेंगे, कठौती में तो होंगे तो दो बातें होंगी कि उसमें जब पानी रखेंगे तो थोड़ा सा पानी वो सूखेगी और थोड़ा सा उसमें भी बच जाएगा। इस तरह से कठौती को भी शिकायत नहीं होगी कि नाव के अंदर तो रामचंद्र जी को बिठा दिया और मेरे लिए कुछ भी नहीं किया। और दूसरा ये कि उसके अंदर अगर जल होगा थोड़ा बहुत तो उसके मैं तेरे को बाद में दे दूंगा। घर का अगर रोटी वोटी उसी में बनाएगी, खाना बनाएगी तो हमारी भी बुद्धि सुधरेगी। अच्छा ठीक है। तो दोनों आए। रामचंद्र जी का हाँ भाई बोलो। कहता जी आप कठौती के अंदर जल भरा, मेरी गोदी में अपने पैर रख लीजिए, मैं आपके पैर चरण धोऊंगा। तो जब चरण धोने लगा तो उसके जैसे ध्यान लग जाता है, किसी का ध्यान लग गया और वो हिलने लग गया। रामचंद्र जी के पैर भी हिलने लगे। तो लक्ष्मण ने कहा जी इसको कहिए कि ये कठौती जो है इसको ज़मीन पर रख दे। तो रामचंद्र जी ने कहा भाई इसको ज़मीन पर रख दे और पैर धो। कहता क्यों। कहते भाई देख तेरा ध्यान मैं देख रहा हूँ लगा हुआ है और तू हिल रहा है तो इससे जो है मेरे को गिरने का डर है। कहते एक काम ये करिए अपने पैर मेरे गोदी में रख दीजिए, गोदी में तो थे ही सही, आप दोनों हाथों से मेरे सिर को पकड़ लीजिए जिससे कि मैं नहीं हिलूंगा और मैं आपके पैर। रामचंद्र जी ने दोनों हाथ सिर पर रख दिए। इस तरह से देखिए उसने आशीर्वाद ले लिया, रामचंद्र जी का आशीर्वाद ले लिया। जब उनके पैर धो लिए तो उसके बाद कहने लगा जी कि ये जल मैं अपने परिवार को भी बुला लेता हूँ। उन लोगों को लाइन लग गई भीलों को। तो सीता जी ने लक्ष्मण से कहा कि चलो हम भी। लक्ष्मण का नहीं हम तो क्षत्रिय हैं, हम इससे मांगेंगे क्यों। उनका जी शुरुआत तो ऊपर से हुई है, रामचंद्र जी ने नाव मांगी, हम भी इसका वो लेते हैं फ़ायदा और हम भी। वो लोग भी लाइन में लग गए। जब ये हो गया तो उनका जी अब नाव में बैठे हैं। कहने लगा हाँ जी बैठे हैं पर एक काम और कर दीजिए। कहते हैं मेरे को पता है कि आपने जब गुरु वशिष्ठ के यहाँ शिक्षा ली थी तो उन्होंने आपको जो सारे वे सब चीज़ें सारी विधियाँ सिखाई थी और उसके अंदर जब पुरखे हमारे चले जाते हैं तो उनका जो हम तर्पण करते हैं, मेरे को पता है कि आप कर्मकांडी नहीं हो, आप उस तरह के पंडित नहीं हो, पर आपने वो सीखा तो होगा ना, याद तो होगा आपको। हाँ ध्यान है। कहता है ऐसा है कि मेरे पुरखे जो इतने सालों से यहाँ पर रहते थे किसी ने आज तक उनका तर्पण नहीं कराया। मैं और मेरी पत्नी इस कठौते के अंदर जल लेके गंगा जी में डालते रहेंगे और आप वो मंत्र बोलते जाइए। और फिर रामचंद्र जी ने लक्ष्मण को कहा चल भाई शुरू हो जा। और वो लोग उसके पुरखों के लिए तर्पण करते रहे, मतलब मंत्र बोलते रहे और ये जो है जल वहाँ पर गंगा जी में डालता रहा। इस तरह से अपने पुरखों को, 7 पुरखों को जिस गंगा के किनारे रहता था अपने पुरखों के लिए भी उसने ये कर दिया। बीच में एक और वो रह गया कि जब इसने कहा कि मैं आपका मर्म जानता हूँ, साथ में ये भी कह दिया, कहता जी मैं आपसे कोई उतराई नहीं लूँगा, ये मैं आपको कह रहा हूँ, मैंने आज तक किसी को डुबोया नहीं है, मैं आपसे पार कराने की उतराई भी नहीं लूँगा आपसे, क्योंकि और मैं सौगंध खाता हूँ आपकी भी और दशरथ जी की भी। लक्ष्मण जी को गुस्सा आ गया। कहते अरे तुम मतलब राम जी की, कभी कहता है मैं मर्म जानता हूँ, कभी कहता है मैं जानता हूँ कि आप ब्रह्म हैं, कभी मैं जानता हूँ कि आपके चरणों में परमार्थ हैं, और फिर राम जी की भी कसम खा रहा है और दशरथ हमारे पिता तक पहुँच गया तुम। और लक्ष्मण जी को गुस्सा आया, उन्होंने तीर निकाल लिया। तो केवट कहते दोनों चीज़ें नहीं चलेंगी, आप तो नाव मांग रहे हो और ये मेरे को मारने के लिए कह रहे हैं, आ रहे हैं। और अगर ये मेरे को मारना चाहते हैं तो अच्छी बात है, मेरे को मार दें। मैं तो राम लक्ष्मण सीता के सामने, लोग तो इनको याद करते हैं मरते टाइम, और मैं तो इनके सामने अगर मरूंगा तो इससे बड़ा मेरे को क्या वो पुण्य मिलेगा। और कहते हैं मेरे को ये भी मालूम है कि फिर मेरी पत्नी रोती हुई आएगी, ये मेरे को मार देंगे तो वो रोती हुई आएगी। आप तो बड़े कृपालु हो, बड़े दया के वो हो, तो आप क्या करोगे, उसको सांत्वना दोगे, मेरा अंतिम संस्कार तक रुकोगे और मेरे अंतिम संस्कार में इससे बड़ी बात क्या होगी कि राम लक्ष्मण सीता मेरे संस्कार के अंदर हैं। और मैं ये भी जानता हूँ, लक्ष्मण जी को भी आया ध्यान कि अगर मैं इसको मार देता हूँ और हमें रुकना पड़ा, तो ये प्रथा होती थी कि जब तक वो सारे कार्यक्रम पूरे नहीं हो जाते थे क्रियाक्रम के, तब तक वहाँ रहना पड़ता था। तो लक्ष्मण जी को लगा कि भाई हमें तो इतने दिन यहाँ रहना पड़ेगा, उन्होंने तीर अपने तरकस में फिर से रख लिया। ये उसकी भक्ति का प्रणाम था। अब जब नाव में बैठे तो आगे गए, तो नाव को केवट को लगा कि अगर इनको अभी जल्दी पार उतार दिया तो ये तो छोड़ के चले जाएंगे हमें। तो केवट ने क्या किया, नाव आगे ले गया, फिर पीछे ले आए, फिर आगे ले जाए। तो लक्ष्मण कहा इसको समझाइए क्या कर रहा है। तो केवट ने, रामचंद्र जी ने पूछा भाई ये आगे पीछे क्यों कर रहे हो नाव को। कहता है आप तो 14 साल के लिए जा रहे हो ना। कहते हैं हाँ। कहते हैं आपने कोई दिन तो नहीं फिक्स किया हुआ, निश्चित किया हुआ कि भाई इस दिन यहाँ जाना है इस दिन। कहते हैं नहीं। तो कहता है 8 दिन यहाँ रह जाओ ना, मेरी नाव है ही सही, तो उसके बाद आप चले जाओ। उनका नहीं भाई हमें जाना है। कहने अच्छा। फिर जब आगे पीछे कर रहा था, उनका जी रामचंद्र जी ने कहा भाई केवट ये क्या कर रहे हो, हमें ले चल के। उनका क्यों महाराज क्या हुआ। कहते जब तुम आगे पीछे करते हो तो हम इससे ऊब गए हैं, हम परेशान थक गए हैं। कहते हैं महाराज मैंने तो 4 चक्कर लगवाए और आप हमें 84 योनियों के चक्कर कटवाते और हम नहीं ऊबते क्या। नाव किनारे लगी। अब रामचंद्र जी कुछ उसको देना चाहते थे, उनके पास कुछ था नहीं। उनको थोड़ा सा उनकी आंखों के अंदर हुआ, सीता जी पहचान गई। उन्होंने अपनी अंगूठी उतार के रामचंद्र जी को दे दी कि इसको दे दीजिए। उसने मना कर दिया, कहता मैंने पहले कहा था आपसे उतरा ही नहीं लूँगा। और उसकी वजह यह है कि हम दोनों का एक ही व्यवसाय है। लक्ष्मण जी को फिर गुस्सा आया, कहते ये क्या बात कर रहा है। कहते बात ये है कि मैंने आपको गंगा नदी पार कराई है और आप भवसागर से पार कराते हो, इसलिए मैं आपसे उतरा ही नहीं लूँगा। तो फिर उसने यही कहा, कहता जी अच्छा चलिए। मैं रामचंद्र जी ने बहुत ज़्यादा ज़िद की, तो कहने जी सिर्फ एक काम करिएगा, मैं ये आपको वचन देता हूँ कि अगर आप जब वनवास काटने के बाद 14 वर्ष के बाद वापस आएंगे, उस वक्त मैं आपसे उतराई ले लूँगा। और इस तरह से ये देखिए कि उसने उनसे इस बात का भी वचन ले लिया कि जब वो वनवास काट के आएंगे तब भी इसी रास्ते से जाएंगे जिससे उन लोगों को। और फिर अंत में फिर जब जाने लगे, रामचंद्र जी आगे जाने लगे तो रोने लग गया बहुत ज़्यादा। तो रामचंद्र जी ने उसको कहा कि तुम जा कर के अपने उसके अंदर करो, और उसको अपनी निष्काम जो वो भक्ति होती है उसका वरदान दिया। और इस तरह केवट ने उसके बाद से उस नाव को नहीं चलाया। उसने कहा जी अब ये नाव तो मेरे लिए एक आपका प्रसाद बन गई है, मैं रोज़ाना इसकी पूजा किया करूँगा और इसी तरह से जो है हम तो रहेंगे। और 14 साल बाद भी भाई जब आप आएंगे तब मैं आपको इसी तरह से इस नाव से कराऊँगा। धन्यवाद।
थैंक यू सर। सावन के इस पवित्र मौसम में आपने बहुत बढ़िया एक प्रसंग आपने जो रामायण का सुनाया है। हम आशा करेंगे कि आप दोनों मेंटर, आप और एसवी सर, हमें इस तरीके से भवसागर से पार उतारते रहो। सर हम भी उसी नाव में डूब रहे हैं। तो आप दोनों की ज़रूरत है हम सबको, जितने भी यहाँ बैठे हैं, जितने भी यंग लड़के बैठे हैं यहाँ पर खासकर, तो आप हमें भवसागर से पार जरूर करिएगा। सो मैं अब एसवी सर से रिक्वेस्ट करूँगा कि भाटिया जी को एक तुलसी प्लांट से सर जस्टिस करें, सम्मानित करें प्लीज। एक छोटा सा तुलसी प्लांट दे दें सर माँ को। नहीं सर, कल से लग चुका है सर, कल से लग चुका है सर। सर भक्तों से पूछा करो। थैंक यू सर, थैंक यू। अब हम अपनी हाँ जी प्लीज।
कि मेरे पास आपने जो अपील्स वगैरह भेजी थी जिन लोगों ने आज वो करनी है, मेरा भी कैटरेक्ट का वो सर्जरी हुआ था, मैं पढ़ने में थोड़ी सी दिक्कत थी, पर उसके बावजूद आई हैड ए ग्लांस ऑन दोज अपील्स एंड आई हैड सीन द इंडेक्स ऑल्सो। मैं ये बात बड़े उसके साथ कह रहा हूँ, कॉन्फिडेंस के साथ, और बिल्कुल सच कह रहा हूँ कि जो अपील्स मेरे पास आई हैं और जो आप लोगों ने मेहनत करके बनाई हैं, 90% से ऊपर लोग, चाहे वो हाई कोर्ट में प्रैक्टिस कर रहे हैं, चाहे वो सुप्रीम कोर्ट में एडवोकेट्स ऑन रिकॉर्ड हैं, इस तरह की अपील नहीं बना सकते। हार्डली 8 या 9%, और वो भी मैं ये नहीं कह सकता कि सारे इस तरह की बना सकेंगे। रेयरली उनमें से भी जो होंगे, वाकई में इतनी कॉम्प्रिहेंसिव अपील मैंने तो कभी हाई कोर्ट में किसी को आज तक, मैं हाई कोर्ट में थोड़ा सा करता रहा हूँ काम, हाई कोर्ट में नहीं देखा, सुप्रीम कोर्ट के अंदर एडवोकेट्स ऑन रिकॉर्ड की जब आते हैं हमारे पास, वो उसमें भी नहीं देखा है। पर हेड्स ऑफ टू ऑल ऑफ यू जो मेहनत किया, और एंड नो क्रेडिट, यस क्रेडिट फॉर दिस गोज टू श्री सुशील वर्मा जी।
Thank you, sir. Really, the credit goes to the Swiss sir and आपको also, sir, कि आपने इतने ध्यान से हमारी अपीलें पढ़ी। थैंक यू सर, थैंक यू। अब हम टाइम को वेस्ट नहीं करेंगे। मैं गुप्ता जी से रिक्वेस्ट करूंगा कि दोनों जजेस को एस्कॉर्ट करके उनके सीट तक ले जाएं। प्लीज वेलकम आवर जजेस डॉक्टर राकेश कुमार एंड CA KP सिंह सर। Members, the GST Moot Tribunal is live on the YouTube. Please switch off your mobile or keep it on silent mode. With the permission of the court, may I proceed, sir? Item number 1 is Star Export Private Limited, argued by Rajmani Jindal ji and Government Counsel is Advocate Sushil Verma. This appeal is regarding Section 74. Revenue alleges fraudulent export to claim refund of unutilized input tax credit, items brought and exported mismatch, suppliers, credentials, serious questions, payment issues, etc. Very interesting question of law in this appeal is, when factum of export is not denied, can the revenue deny refund based on the presentation of the conjectures as alleged by the appellant? Additional evidence filed to support the legitimate claim of the appellant along with individual affidavits of the suppliers to satisfy the requirement of Ecom Grill Trading Company judgment. Reverse, revenue strongly defends the order of the lower authorities. Very innovative order prepared and very interesting question of law likely to be debated. Let us hold our breath and listen to the argument of both the sides. Let's welcome our senior most member, Madam Rajmani Jindal ji. Aye.
Well, friends, in this case, it's a first very important case for you guys. Under Central Sales Tax Act, it was contractually webbed. All main sections were deeming sections. Export was involving a contractual privity between the importer and the exporter. In GST law, there is a change. There is a definition of exports under Section 2, subsection 5 IGST Act when goods are taken out of India. Right? So that is the purpose of export. But that's only a definition. Definition does not give you any refund. Refund is given by Section 16 IGST Act when it says it's a zero rated transaction. So export is not tax free. It is subject to zero rating if you have incurred any tax liability on buying goods for manufacturing exports, for trading exports, you are likely to get benefit. You have to be very careful when you listen to this case. This case is very complicated, very serious matter, where the order is based on total fraud. The revenue says that सारा कुछ fraud किया आपने. In this case, the importers asked for item red. Item exported was blue. And the item that were procured, they were men of straw. Nobody knows who these fellows were. And right up to appellant stage, the counsel did not produce any evidence. And the owner of the company could not answer any question to the appellate authority. So revenue alleged this is all fake. It's a circular trading. Goods were not supplied. You only purchased bills. Right? But revenue somewhere failed. It did not say that goods were not exported. So the question is, if factum of export is not denied, can you deny the refund? So remember in section 16, you have two kinds of exports. One is IGST paid exports. Other is against LUT, where you get unutilized ITC credit. But in both cases, you get ITC credit only. IGST paid, you pay on difference. 1% you pay VAT, remaining you adjust ITC. Right? So notwithstanding some rules to the contrary interpretation, but the issue is one. Refund was given because refund has limitations. Before you proceed with the case, you should know what are the limitations. Section 54 read with 73-74 has 5 limitations. 5. There, whenever you do an export matter, the first question is you have to see whether the limitations have been adhered to or not. First is you have to apply refund before the expiry of 2 years from the relevant date as defined in section 54 explanation. Then the RFD02 acknowledgement has to be mandatorily given within 15 days from date of filing of refund application. Now most of the time I see people, they don't know what to do with it. 16th day you have to put in a petition before the proper officer. You have violated law, it's a contempt. There are a number of judgments now, Delhi High Court, Supreme Court. There are mandatory limits. That is after 15 days, RFD 03 cannot be issued. Once he gives you acknowledgement RFD 02, that is he is supposed to have verified all the particulars, Circular 125 or Rule 89 or whatever formalities are to be there. Then RFD 03 deficiency memo cannot be issued. Deficiency memo has to be issued within 15 days. Second deficiency memo cannot be issued. The law does not authorize the proper officer to give you a second deficiency memo. Right? So after deficiency memo, you are supposed to file a fresh application. That fresh application is a rectification of the original application. So this rectification always relates back. So your limitation starts from date when you file the application. You got it? As per 54(7), within 60 days from date of filing of application, excluding the time you take in rectifying deficiencies. Suppose you take 10 days to rectify the defects. Now the time is 70 days. He must pass the order, accept or reject. If he does not, then 56(1) gets into operation. That is, interest meter starts. And nobody can deny. Right? These are the limitations under 54. But when you have interplay with 73-74, how many people you know that 73-74 have 2 limitations? I will say 3. I again tell you, you have to learn to read law. 73, notice 3 months, 6 months, 73-74, order to be passed. For refund, there is a separate limitation within those 2 sections. In 73, 3 years from date of refund. It has no interplay with the annual return. And 74, it is 5 years from date of refund. And what is date of refund? It's not when the RFD 06 is passed. Date is when the money goes into bank. That is the date of refund. So whenever you do a refund case, be very careful to note down on your notebook whether these orders have been passed within the limitation period. At every stage, you have to put the proper officer to notice. Okay, buddy, you have not followed this law. It is your duty. Tomorrow, High Court will say, what will you do as a professional? And there are High Courts who are questioning this now. What were you doing? Is the government working? Recently, Delhi High Court has said in one of the cases. Therefore, once 15 days are over, put a letter on record. Other question you have to know is 54, the question of jurisdiction. 54(5) says only proper officer can pass a refund order. Like in Delhi, special commissioners pass orders. We have to explore, investigate, are they proper officer for the purpose of section 54? If not, you have to put your petition to special commissioner, not to the STO. Because acknowledgement in Delhi is also issued after his approval. There is no such procedure anywhere in law. No commissioner can devise any procedure which is not authorized by law. Such a procedure, what is happening in Delhi, it's also happening in Karnataka. Ravi Kumar was the commissioner. I talked to him once because you can't do it. They do it otherwise now, but it's not official. But here you have a committee, a peon, a clerk, a reader, STO, assistant commissioner, special commissioner, commissioner. So they have constituted a bench behind your back to give or not to give you refund. This is completely illegal. It's a fit case for High Court writ. Absolutely fit case. No High Court will refuse to entertain this because you are hitting the jurisdictional issue. So whenever, for example, 73, 74, Rajmani has done, of course, you have to first see whether this notice 73, 74, is it hitting a limitation of 3 years or 5 years from date of refund. If it's hitting, you don't have to bother at all. Let the case be the worst case. Let it be a total chori case. But tribunal or high courts cannot extend limitation. Right? Therefore, this is a case where you are going to see that there were a lot of issues. And the counsel has prepared some evidence which revenue is going to say is an afterthought. So now on such cases, if you want to bring fabricated afterthought or original additional evidence on record, you have to make out a very strong case to bring additional evidence on record. Otherwise, revenue is going to absolutely hell-bent not to be allowed. Because evidence which was not given below at all, there are findings that have nothing else to produce. From where did you get all the evidence now? So whenever you come to tribunal, this is a litigation strategy which I am teaching you. You have to be very careful what evidence you bring on record. Don't take the tribunal for granted. अरे भाई वर्मा जी खड़े हुए तो हो ही जाएगा, आप बाकी साहब खड़े होगे वो हो ही जाएगा, ऐसा कुछ नहीं होता. Judges don't bother who is a lawyer. I just saw in Supreme Court day for yesterday with Kapil Sibal, one of the two senior lawyers are being fired. What shit are you talking? What is his petition? What is his application? So additional evidence, condonation, and question of jurisdiction. And if you have a question of limitation or a question of jurisdiction, make them first two legal issues, preliminary issues. Don't make it a ground of appeal. First to argue these preliminary issues. Okay. Honorable judges, these are our two initial issues. If I win on these two issues, I don't have to go into grounds at all. Like last tribunal, they said, you can't be a judge in your own cause. They quashed the orders. So you don't have to argue. Don't be very keen to argue. You have to learn to win cases on law, jurisdiction, technicalities, limitations, circulars, notifications. There's a difference between circular and notification. Circular is the understanding of department. It's not your understanding. Circulars are also not binding on tribunal. Notifications are. Notification is a part of law. Circulars are not a part of law. So be very careful. I see a lot of people, oh, वो circular है. No, you don't have to bother. आपके खिलाफ है तो आपको circular, you don't bother. Second, always remember in refund you have this lot of rules. Rules cannot override act. Notwithstanding any explanation given in rules, rules, proviso or explanation appended to rules, they cannot override the act. So if in a given case you are entitled to more refund, but somebody tells you rule mein ye likha hai ji galat, don't follow. Debate it. You may lose, how does it matter? But law is about innovation. The more you read, the more better results you will get. For example, in 16.3, the provision is subject to section 17.5, you will get unutilized ITC. So what is barred is 17.5. Any other portion of section 17 is not barred. So if you read these three words, you will understand वो exempt supply, taxable, non-taxable, proportion करो, ये करो, 1, 2, 3 सब खत्म हो गए आपके. So whenever you do a refund case, your first job is you have to read section 54. I can bet you none of you has ever read section 54. I can guarantee जितने भी लोग यहाँ बैठे हैं, आपने 11 सबसेक्शन आज तक इसके नहीं पढ़े. मेरा अपना एक्सपीरियंस है. और शायद 54, 1, 2, 3 भी ध्यान से नहीं पढ़े होंगे. Read VKC footstep judgment of Supreme Court. Please note down. Read this judgment. You will be lifetime clear on refunds. Dr. Chandrachud was a habit of writing a very good judgment. Forget his politics part, but he wrote some beautiful judgments. Though it was on IDS, but they discussed the entire refund law, including limitations. And it has more than 13 judgments which are relevant for the question of refund. VKC footsteps. So if you don't want to read law, raw law, read judgments. But be clear on section 54. Thank you, Madam Rajmani. Please continue.
With the permission of the chair, my lords, this case before you raises a very crucial question of interpretation of law in GST, where the factum of export under section 2 subsection 5 of the IGST Act is not denied, my lord. It is also not denied that the laptop has been exported, my lords. Can the benefit of the zero-rated transaction under section 16 of the IGST Act can be rejected? This is the main question, my lord, which this case raises, my lords. This is appeal before section under section 112 subsection 1 read with rule 1110 read with section 16 and section 54 also of the DGST Act and DGST rules against the impugned order of Joint Commissioner Zone 8 for the tax period 2021. My lords, the appellant most respectfully submits for the kind consideration of this appellate tribunal, my lords. All the conditions precedent to filing of the appeal have been complied with, my lords. The appellant Star Exporter Private Limited, my lord, is a registered dealer of GST department with GSTN number so and so. The appellant is engaged in the business of trading of electronic products, including export to Gulf countries, particularly Dubai. The appellant is aggrieved with the orders of the proper officer and the first appellate authority, my lord. My lord, I just want to apologize for one thing. The total demand in this case is 13 crores 18 lakhs, my lords. But I have deposited 54 lakhs only, my lords. So the balance amount is 74 lakhs is required to be deposited. I apologize this mistake. Kindly, I will deposit it. Thank you very much, my lords. The second point is the appeal is within the... Yeah, please.
No, I think there's a mistake. The tax amount is 54 lakhs only. 5 crore 40 lakhs. Remaining is interest and penalties, 13 crore, but she wrote in the wrong columns. There is no short deposit in your case.
Thank you very much. Thank you, to the learned counsel. The appeal is filed within the limitation period of 3 months, my lords, and the order has been received in 14/2/25, and appeal has been filed on 5/4/2025. The pre-deposit I have already talked about, and the filing fees for the appeal has been filed 25,000. The order is appealable as does not fall under section 121 of the DGST Act, and the 2 copies of the originals are attached, and memorandum of appearance along with wakalatnama are enclosed as annexure 21, my lords. Now the brief facts. The Appellant Star Exporter Private Limited is a company incorporated under the Companies Act 2013 and is also a registered taxpayer under the Okay, my lord. Okay, sorry. And that he is also a registered taxpayer under GST department by GST number so and so, engaged in the business of trading of electronic products, my lords, and export to Gulf countries, especially Dubai, etc. They are exporting for decades, my lords, and that's why they have given the status of star exporter, my lord. This point to be noted. They are not the new one, they are very old person in this field. For the tax period 2021, the audit was conducted under 65 of the GST Act, my lord, and it was completed on 1/8/2024. The appellant also entered into few purchase transactions at Mumbai and made some exports in the course of business. The appellant company received export order of 2,000 laptops, my lords. That is of Dell make made in Malaysia from the Association of Importers of Information Technology Products at Dubai at the rate of 1,000 per laptop at US dollars. The date of export was, my lord, 6/6/24, and the said purchase and export were duly supported by valid tax invoices, shipping bills, export bills, e-way bills, and all the proof of the goods were physically received by us, and these are the admitted facts, my lords. However, the audit team pointed out few deficiencies, that none of the suppliers is the distributor for Dell in India or Malaysia. Out of 5 invoices dated 6/5/24, only 2 for Dell laptop and their configurations were different from what was exported. These were the deficiencies. Payment made to 3 suppliers only and adjusted against the amount already lying with them. The payments made by the association, not by the association, but the 20 individuals, numbering 20. The inspector report from customs was not received. Summons sent to all the 5 suppliers returned back with remark, no such form exists, my lord. The appellant claimed cash refund of 2,70 lakhs in accordance with the provisions of the DGST Act, duly sanctioned by after scrutiny by the GST department, my lords. And all the requirements of the DGST Act and the rules have been complied with. That is why the refund was given under section 54, subsection 7 of the Act, my lord. On 28/8/24, a show cause notice was received from the proper officer, Assistant Commissioner Zone 8, why the refund of 2,70 lakh be not taken back with interest. The copy of my lord show cause is on page 100 to 106 of this appeal, my lord. Further, he also alleged why the fraudulent export, the term which he has used for the export, is not treated as interstate supply instead of zero-rated supply, my lord. We have given a reply to this SCN on 17/9/2024, explaining various points in very detail and attending the proceedings in connection with the reply to the show cause, my lord. The reply is also filed on page 107 to 110, marked as annexure 17, my lords. On 3/10/2024, the proper officer made adjudication order under section 74 of the DGST Act, that is on page 1111 to 115, marked as Annexure 18, rejecting export of 30 crores, my lord, and demanded a tax of 18% that comes to 5 crore 40 lakhs, my lords, and also further threatens to impose penalty under section 122, under section 122 of the Act, and further threatens as to why the criminal proceedings under section 132, read with section 69 of the Act, be not initiated, my lords. On 13/2/2025, the appellant filed appeal before the first appellate authority under section 107 of the Act with the condonation of delay application of 8 days because of the sickness of the advocate of the appellant, and that was allowed by them, but they confirmed the order of the proper officer only. The appellate authority has confirmed the order of the proper officer only. Then, my lords, on 5th of April, the appellant is aggrieved by the order of the proper officer and the first appellate authority. We have come before this honorable tribunal for the demand for the justice. The appellant has filed before this on. My lords, with this application, I'm also filed 4 interlocutory applications. 4 interlocutory applications, my lord. First is for urgent hearing, dated 1/4/2025, page 43 to 50 of this appeal, my lord. My lord, I filed this application because, as the proper officer has show caused by the refund of 2 crore 70 lakhs be not taken back from you, and then also the adjudication order that rejecting the export of 30 crores, taxing it 18%, that comes to 5 crore 40 lakhs, then interest of 3 crores, and also penalty of 5 crore 40 lakhs, my lords. He also said that we will start the penalty, we will also put the penalty under section 122 of the Act. And he also threatened us that we will start the criminal proceedings under section 132, read with section 69 of the Act. I have also filed a second interlocutory application, my lord, for the additional evidences under Rule 112 of the Act, along with application Rule 29 of the GST 80 rules, with affidavit and challan. We have deposited the fee of 5,000 with this, my lord. We have filed this additional evidence, kindly see, my lord, because we were prevented from filing that lower level for the reasons beyond our control. These evidences are very crucial and important as they go into the root of our case, my lord. I also filed an interlocutory application dated 1/4/2025 on page 86 to 95 of this appeal for calling or summoning the suppliers of the laptop, for summoning them under the provisions of the Act to give evidence in support of legitimate claims of the appellant and to cross-examine them in the matter to unearth the truth regarding the purchase of the laptop, my lords. I also filed interlocutory application, my lords. I have given a copy of that. That is today, 5/4/2025, for interim relief for staying criminal proceedings under section 132, read with section 69 of the Act, as it is necessary to meeting the demands of the justice. I humbly pray kindly allowed this above application so I can argue on merits and give the proper orders and direction as the Honorable Tribunal may deem fit and proper under the circumstances of the case.
Your Honor, on this additional evidence, I have a little write-up for both of you, please. Because I don't know. Now, friend, this you have to listen. Okay, what is the law on additional evidence? So we'll keep telling you, okay, keep listening carefully. I'm going to spend 5-10 minutes on this. Your Honor, if you see the show cause notice, adjudication order, appellate order, the appellant refused to bring anything on record, and they made a statement, there is nothing else we have. Appellate order question, do you have anything else to say? They said no. Therefore, I strongly object to this application of following additional evidence, which is also not satisfying the ingredients of Rule 1112. Let's understand Rule 1112. Rule 1112, sub-rule 1 starts with the negative clause. The appellant shall not be allowed to produce before the appellate authority or the appellate tribunal any evidence, whether oral or documentary, other than the evidence produced by him during the course of proceedings before the adjudicating authority, or as the case may be, the appellate authority, except in the following circumstances. So there are only 4 circumstances in which this evidence can be, if at all, entertained by the honorable tribunal. 1, where the adjudicating authority, or as the case may be, the appellate authority has refused to admit evidence which ought to have been admitted. This is not the case in this case. Where the appellant was prevented by sufficient cause from producing the evidence which he was called upon to produce by the adjudicating authority, or as the case may be by the authority. This is also not the case they have made out. Where the appellant was prevented by sufficient cause from producing before the adjudicating authority, or as the case may be, the appellate authority, any evidence which is relevant, there is no ground taken in application, what were those reasons sufficient, which was beyond their control. For example, they had a contract. It was there. It was not produced. There cannot be any reason.
My lord, sufficient cause was that the papers were somehow was not traceable. And we tried our best.
We'll come on your application. You please allow me to speak. Now, there was nothing. Now they have brought on record some 20 the wife-based fellows that we sold laptops. That is also an afterthought of document, which is, we will prove that document is fake. That is also not the case. And all authorities want them, do you have anything else to bring on record? Now suddenly, when Section 70 summons was sent, the reports came that none of the firms exist. They did not tell us anything below. Now suddenly their affidavit has come. And affidavit, sir, who witnessed it? We don't know. So if this kind of additional evidence is allowed to be produced, even for the sake of justice, this will open Pandora box. People will start bringing all kind of documents here. I mean, not that I'm against such evidence, but the whole case is metaphorical. It's absolute fraud. It's total circular trading. If at all this honorable tribunal admits to argue on merits, there are findings given by the authorities below. It will be very difficult to honorable tribunal to go against those findings, because that's based on an evidence. And that evidence is a part of record. Show cause notice, their reply, adjudication order, appellate authorities, they did anything, whatever they could do. They filed the entire whatever they had. But the authorities below found that this all fake and fraud. And that is why a notice was given to them, why should we not reject your exports for these goods, and why not make it interstate sale? Because exports are interstate transaction in Section 5 DGST Act. The next reason is where the adjudicating authority, or as the case may be, appellate authority has made the order appealed against without giving sufficient opportunity. I think many opportunities were given. Then subsection 2 says, no evidence shall be admitted in sub-rule 1 unless the appellate authority or the appellate tribunal records in writing the reasons for admission. Now, if this honorable tribunal has to record reasons, the reasons have to be based on the orders below. The reasons cannot exist in a vacuum. Some reasons will be innovated and to give relief. I agree with my counsel that text has to be as per law. But then they have to follow the law. We have a problem there. Then sub-rule 3 is more important. The appellate authority or tribunal shall not take any evidence produced under sub-rule 1 unless the adjudicant authority or an officer on his behalf by the said authority has been allowed a reasonable opportunity to examine the evidence or document. So if at all that has to be admitted, it has to go back to him. He let him give a finding whether this can be admitted. Number 4, nothing contained in the rule shall affect the power of appellate authority, the appellate tribunal, to direct the production of any document. So if honorable tribunal wants any evidence to come, direction can be given. Now this is the latest ruling on additional evidence. It has many Supreme Court rulings, so I have given you a brief only on this. This is a ruling you can note down. Javed Bhai versus Sikandar Ali, 2024, SCC Online, Gujarat High Court 3987, October 24. Yeah, on top, sir. Okay. Now, in this, a very long judgment, Gujarat High Court went into what is the role of additional evidence. As all of us know what is this additional evidence business. Appellants are not automatically entitled to produce additional evidence, and such a request will only be allowed in exceptional circumstances. Despite being aware of the document and having the opportunity to produce the additional document, the appellants failed to do. Additionally, neither have they satisfied the ingredients Rule 112, nor have they made any assertion based on which it can be said that such documents are necessary for proper adjudication of the order. Union of India so-and-so Supreme Court and affirmed that the observation of Supreme Court in the above mentioned case indicate that the general principle is that the appellate court should not travel outside the record of the lower court and cannot take any evidence and appeal which is stated in the provision. However, as an exception, Rule 112 enables the appellate tribunal to take additional evidence in exceptional circumstances. However, at the same time, where the additional evidence sought to be adduced removes the cloud of doubt over the case, and the evidence has a direct and important bearing on the main issue in the suit, and interest of justice clearly records it imperative that it may be allowed to be permitted on record, such application may be allowed. Then again a Supreme Court judgment says, wherein it has been held that the appellant who is guilty of remissness in the lower court is not entitled to indulge of being allowed to give further evidence. If my lords have gone through the order, there are findings at every stage they have miserably failed to cooperate. It's a miserable failure, intentional. Now suddenly those documents come, that documents were being called by the lower authorities. From where the documents come? How can tribunal take this in record when there is no verification? We cannot verify these documents, what the documents are. Are you going to call Dubai fellows here? The application, interlocutory application to call people for cross-examination can be allowed. Can be allowed if facts of the case permit. But here facts are so bad against the appellant that there no purpose will be served by calling, because those fellows will never come here. They will never come because section 70, which are judicial proceedings, they never bothered to come.
More important thing is the whole
You are not.
before we proceed, let me be Counsel, one question from you.
Yes, sir.
You have exported
Yes.
200 US dollars, 200 Dell
Laptops.
laptops
Yes, my lord.
at the rate of
1,000
US dollars.
Yes, my lord.
So that comes to around 2 million US dollars.
Yes, my lord.
And at the prevailing exchange rate of say 90, it comes to around 18 crore rupees, right? On which you have made purchases on which the ITC, presumably at the rate of 18%, it comes to around 15 crore rupees, which is fairly good enough, because giving a reasonable margin of 20%. Now, at one stage, page, I think there is one page, how can the export, at one, you have claimed that the total export is 30 crore, because it cannot be more than 18. Where is the difference of this 12 crore rupees?
I don't know.
Getting a point?
No, my lord.
You have exported 200 laptops,
2,000 laptops.
2,000,
Huh.
at the rate of 1,000 US dollar,
That
comes to 2 million US dollars.
Yes, my lord.
At a prevailing exchange rate, it comes to 18 crore, on which fairly you have made purchases for 15 crore, and your ITC comes to around 2 crore 70 lakh, for which you have made an application under 54(1), and you have been allowed. But 30 crore, because your export have been rejected to the tune of 30 crore as against 18 crore. So where is the difference of this 12 crore?
This is margin, you can say.
No. That is the export you have made. No one can make any alteration. No any authority, no any.
But Milord, why you are calculating with the US dollar?
Maximum, I have taken the maximum in the last 2-3 months. It has not scaled so much high. It's approximately 90, below 90. Sir?
Yes.
That is one thing. Secondly, one more issue is involved in it. They have received the payment, this whooping amount of $2 million from parties with whom they do not have any contractual privity.
Yes.
So, in my opinion, the possibility of PMLA cannot be ruled out in this case. So, if with the permission of our honorable chairman, if we reject it, so it will close here. Can we give one opportunity to dig into the root of the case to find out everything? Where from they have purchased?
Milord, may I make a request? Since tribunal is the last finding authority, if we will not argue before, put our case before the authority, or the tribunal will not allow us, then it will be very difficult for a common man. Where that person will go?
We are furthering your concern. So, in the interest of justice,
I request we kindly.
Your Honor, I will agree with Honorable Tribunal, because the notices and orders, they have not been able to rebut it. First is this case. Second is, the only issue which he is raising is, can the proper officer initiate Section 132(69) proceedings? He has not initiated. He says, as per law. As per law, what is written.
Exactly.
So there is no, this tribunal has no inherent power to stay such proceedings. There is no order passed, and there is no demand raised.
yeah.
So this law doesn't give you inherent powers. I don't think they have any case for additional evidence. And regarding PMLA, well, that's something which department has to take a call. I cannot say anything on this issue. And but
we can certainly give directions.
Why not, Your Honor? On the tribunal can.
That's what
They have a right.
That's what my.
Oh yeah, they have a right to go to High Court.
Yeah.
Based on the tribunal can say.
Yeah. So that has to be looked into, number one. And number two, as far as entertainment of additional evidences are concerned, sir, she is very right that GSTAT is the last fact-finding authority.
Yes.
After tribunal, courts cannot intervene for finding any facts. And in case, because of any reason, we have seen number of cases that many times because of various reasons, the evidences cannot be produced at the lower stages. But if they come with a concrete evidence which ultimately proves this thing, that yes, this claim is genuine, or there was an erroneous adjudication order passed, then definitely, as you have also rightly said, that ultimately we have to seek the
Truth.
Comments of the adjudicating officer also before coming to any final decision or order. So, as per the principles of natural justice, the evidences retained, number one. Number two, those should be sent back to the adjudicating officer, and we should ask for the report from him. He should evaluate whether those evidences are correct or incorrect.
There can be an interim order, I have no objection.
Yeah,
Only interim order. Yeah, well done. Now you know what happened in this case now, understand. The revenue alleged, and they proved on record, it's a circular trading, it's a fraud export, these firms of fraud. Right? The counsel was able to make out a case with enclosing the evidences, whatever she could collect, whatever the client could give. Right? Normally, in court of law, as per CPC, this will not be allowed. I'm very sure about it. But here, because this is tax matter, right? So honorable judges were kind enough to pass an interim order, go back to adjudicating authority, produce all the agreements you have, which apparently are, in my case, they are fake. I can prove that just now they are fake, but they have not been prepared correctly. Just so interim order. So therefore, it is a very good strategy. When you appear for tribunal in such horribly bad cases, don't die today, die tomorrow. Yes, don't die today, die tomorrow. So this is a good litigation strategy which Rajmani has followed, and she has been able to convince. And I cannot speak because if judges take a view, interim order pass karna hai to karna hai. Well done. Thank you.
My lord, I highly obliged because I also want to make a request. Kindly send this remark. I am highly obliged, my lord.
हाँ जी, वो अभी बाद में हिसाब करेंगे मेरे साथ. The question was कि you are saying कि you have exported 2000 top at a particular price. You are claiming an ITC on 50% of value, purchase value. Sale is double. How? That factor she was not able to explain in the grounds of appeal. That happens when you do not read orders carefully. Once you use Google and AI stuff, in my article I have said in a newsletter, it's a suicide for your client. Ultimately he will die.
Then you die today only, not tomorrow.
Then you die today only, yes. Because there are provisions that the appellate authority can ask more than 10% also. There is no bar. He can say the entire tax is admitted. You go on fighting wherever you want to go. Rule is 10% of disputed amount. He records the finding, all the taxes are admitted. It's payable. Because the entire thing is fraud. वो तो बोल दिया deposit 100%. आप अब जहाँ जाना है आप जाओ ना आगे जाके. So read the order carefully. And this is the best. Instead of losing a case, she has been able to obtain an interim order. It's a major victory for her. And this could only our judges do. I can tell you. Thank you so much.
Because of you. Because of you.
Item number 2, Agastya Trading Company, argued by Narender Ahuja and Government Counsel Sushil Verma ji. Friends, this appeal is an eye-opener and is the most crucial appeal of today's Moot Tribunal. The appeal has allegation of bogus billing, only invoices and no goods received. Appeal has issues of unauthorized bank accounts by the appellant as well as by the suppliers. Appeal has issue of RC cancellation retrospectively. HSN issue is there, section 31 violation are there. Lack of proof of delivery as noted by the proper officer and confirmed by first appellate authority. All the suppliers are of doubtful nature and strong reply by the appellant on each of the issues. Let us hear this interesting argument now from our convener, Advocate Narender Ahuja ji, SV sir. Friends, virtually this case has all the issues that we face daily under section 74 to deny benefits of input tax credits. Let us vote.
Now, listen carefully 5 minutes about this case. This is a case passover from the earlier tribunal. We didn't get time on that day. It's one case, if you hear 25 minutes with attention, you will understand entire section 16 and 74. Section 16(1) is the only substantial provision in section 16. 16(2), 3, 4, 5 are machinery provisions. ये मिलेगा, ये बिल लाना है, ये लाना है, वो लाना है. They are a matter of machinery provisions. And when you go to 16(2), two conditions are key conditions. बाकी सब आपके पास होता है. It uses past perfect tense. When you read law, your grammar has to be very strong. It's not using indefinite or continuous tense, using a past perfect tense. the taxpayer has received the goods. That is, unless you prove goods have been received, ITC cannot be had by you. So you have tax invoice, you are buying from a state dealer, you have made him advance payment, you have got the invoice, right? But you still have to prove that you received the goods before you claimed input tax credit. That is a sine qua non of input tax credit mechanism. And onus lies upon you to prove it. No pre-GST regime judgments will hold any zero value judgments on ka. That is why in Ecom Gill, Quest Marketing Delhi High Court case, SLB was filed, SLB was dismissed Supreme Court. So basically we thought that this High Court judgment is final. But when it came to Ecom Gill, judge threw it out. They did not consider section 155. So section 155 should be always in your mind. Cases you have to prove your claim of input tax credit. How you do this is none of the business of revenue. इनको कुछ नहीं करना है. आपको प्रूफ लाना रिकॉर्ड के ऊपर. हम लोग गलती क्या करते हैं जब अपील बनाते हैं या हम क्लाइंट से बात करते हैं जो maybe we have to begin, we don't know. There are many collateral issues with sale and purchase of goods. For example, in this case, he is buying marble from the mines. Without royalty payment, material cannot move. That's the Mines Act, Rajasthan. They have nothing. And his 70% turnover is from 10 dealers. सबके आरसी कैंसिल हो गए. That is why in Ecom Gill Supreme Court wrote, if the assessing officer doubts your transaction, they are dubious, he has all the authority to deny you input tax credit. Ecom Gill से बाहर आप नहीं जा सकते. All high courts are following it blindly now. And they are dismissing, including Calcutta or Allahabad High Court, who has given a maximum relief early on judgments. Collateral transaction में जो rules लगते हैं वो भी देखने हैं आपको. Imported marble, domestic marble में rates में फर्क हो सकता है. HSN code में दोनों में फर्क है. So when you talk of tax invoice in section 16, you refer to section 31. उसके सातों पैरामीटर आपके टैक्स इनवॉइस से पूरे होने चाहिए, अदरवाइज आई विल रिजेक्ट. जहां जाना कोर्ट वोर्ट में जाओ, बोलो टेक्निकल एरर है, प्रोसीजरल एरर है, जो मर्जी बोलो, रेवेन्यू विल टैक्स यू. That is why in 3B they are slowly making everything subject to HSN. Right? Now in this case, they didn't even declare their bank account. हम भूल गए, हमारी बैलेंस शीट में है. That's why they filed a reply to the revenue. So we have to say, can this ground be taken? That is, if they were to invoke section 83, attach your bank account, which bank account? With a zero balance. मेन तो आपने डिक्लेयर ही नहीं किया. He may come to know after 4 years, 5 years when it issues 73-71 notice. तो 4-5 साल तक इलीगल बैंक अकाउंट चला रहे थे. आपने जिन लोगों को पेमेंट दी वो भी बैंक अकाउंट गलत है, और प्रॉपर अफसर ने पैन बेस से उनके बैंक अकाउंट निकाले, वो बैंक अकाउंट है ही नहीं उसमें. So what happens? That is, you have made payment in 180 days. Payment to whom? Law is silent. Payment आपको किसने आपको करनी है, किससे आपने लेनी. But who issues your tax invoice? Payment has to be made to him only. That is negotiable instrument act, payment in due course. Right? Then you are now enclosing some evidence that our physical goods were taken, but the lower authority say इनके stock ledger में भी account नहीं है वो. Stock ledger was shown, they say these stocks were not received. Now what happens when you do a case like this? Law is never laid down in good cases. Ex parte आ गया, आपका tax invoice बाद में आ गया, आपके C form बाद में आ गया. This is no law. Law is made in the worst cases, this way or that way. This is where you need to challenge yourself. These 3 appeals were given to the 3 conveners. They are the worst appeals I've ever drafted in my life. Rashimi Jain is still the worst case, because now they are the leading this group. They have to work hard. They are also first-time counsels. So when you hear this kind of appeal, now say section 74 cannot be invoked. If under these circumstances 74 cannot be invoked, well, this will be invoked. But you still have to challenge section 74. 74 and 73 are conditional jurisdictions. There is no inherent power in the proper officer. Power is given by way of three reasons: short paid, not paid, wrongful availment ICU, erroneous refund. चौथा कारण उसके पास नहीं है, दोनों सेक्शन में नहीं है. So once these preconditions are put, we call this conditional jurisdiction. This is not an inherent jurisdiction. But 65, they are inherent jurisdictions. They can do anything. Then whether it's 65 audit or 66 audit or 66 audit, both have to culminate in 73, 74 proceedings. There can be no demand in 65 or 66. Special audit or a whatever audit. So this case, listen to carefully what Mr. Ahuja has to say. He is going to state the facts correctly. He is not going to conceal anything. We are not here to win or lose. We are here to learn law. There is no win-lose here. I am not here to win. He is also not there to win. We are trying to bring issues before this August House. Okay, what can happen in a given case? Thank you very much, sir. Thank you very much, sir.
Thank you, sir. With your permission, sir. Your Honor, this appeal relates to the raising of a demand of rupees 51.70 crore, including tax of rupees 32.40 crore and interest of rupees 18.30 crores, by denying the input tax credit against the purchases made from 12 suppliers from Rajasthan, alleging that these suppliers did not supply any goods but only raised the bills. Order of the copy is attached on page number 23 to 34, sir. My lord, the appellant deals in trading of marbles and marble products, etc., and purchasing these marbles from Rajasthan for the last 20 years. He has never been charged with such a huge allegations earlier at any stage in his business, neither in VAT regime nor in GST regime. He is a law-abiding person and all his returns have been filed on time, and appellant has paid all the taxes well on time through credit card and through cash ledger. My lord, a search was conducted on his premises on 16th January 2024, and soon after the audit was conducted by the authorities. The appellant was issued a show cause notice on 14th October 2024 after the completion of audit and the filing of audit report on 3 July 2024. Based on the SCN, the proper officer has passed the order and created the above demand. The appellant had filed an appeal before the appellate authority within the time limits of 3 months, but the appellate authority rejected the claim of and confirmed the order on 8th February 2025. Aggrieved by the order, the appellant filed the appeal before the Honorable Tribunal within the prescribed time of 3 months from the date of the order. My lord, all the procedures for filing the appeal has been duly followed and well placed in the paper book submitted with the Honorable Tribunal and the Government Council. Apart from that, my lord, the appellant has filed some additional documents that could not be placed before the proper officer and appellate authority due to unavailability of those documents at that time. So, the appellant requests the Honorable Tribunal to accept those additional evidences. These are just the correspondence made with the suppliers whose registration was cancelled by the authorities, and they all have filed appeals against the cancellation of the GST registration. So I request the Honorable Tribunal to accept these evidences. My lord, before I discuss the facts of the case, I would like to take to some questions of law. These questions of law are substantial to quash the order under section 107 subsection 11. The first question is that the search was conducted by the authorities under section 67 subsection 1 without the proper authorization from the Commissioner of the GST. No such authorization was shown to the appellant, and moreover the search should be conducted by proper officer not below the rank of the Joint Commissioner, but the same was not conducted by the Joint Commissioner, and no such approval was available with the authority who visited that who searched the premises. My lord, after the search was conducted, the appellant received the notice for audit under section 65, but again, my lord, appellant was not served a legal notice. The notice period should be at least 15 days under section 65 subsection 3 of the CGST Act, which was not done. then the audit must be completed within a period of 3 months under Section 65 of Section 4 of the Act, but the audit went beyond the prescribed time limit of the 3 months, and no approval of the Commissioner of the GST was taken or shown to the appellant to conduct the audit beyond the time limit of 3 months. It is important to note here, my lords, Section 65 is a conditional jurisdiction provision, and unless the mandate given by the law is followed to in a strict sense, the proceedings initiated and completed in gross violation, which is admitted here, shall and must be declared void ab initio. Hence, on the three counts, the entire audit proceeding and hence consequential proceeding under Section 74 must be declared void. Procedures again procedure requires 15 days notice, not given. Procedure requires approval of Commissioner, not conducted for the conduction of audit, not taken for the 3 months. And hence, if law mandates that something must be done as per the procedure and timelines must be done, otherwise the entire proceeding must be void ab initio. My lord, a big question of law is whether a man can be a judge on his own cause. The proper officer who had issued the notice for the audit, conducted the audit issued under and the show cause notice, and even passed the adjudication order under Section 74 was the same person. It looked like he was in a hurry to complete all the proceedings against the appellant on his own. The Honorable Supreme Court and the Honorable High Courts in numerous judgments clarified that no man can be a judge in his own cause. Lordship, I have provided the copies of some of these judgments for your reference. Menka Gandhi versus Union of India has also Supreme Court has also pointed out that the same issue, that no one can be a judge in his own cause. There are another judgments in this regards. Mohapatra and Company in Union of India versus Tulsi Ram, and I have provided all the judgments. The Honorable Odisha High Court even quashed the National Trading versus Assistant Commissioner of Sales Tax Civil Writ Petition number 2148/2000 on the same issue without going into the fact of the case. My lord, whether the unsubstantiated allegations levied against the appellant without bringing them on the record could be a reason to invoke Section 74 and issue the order under Section 74, even the notice was not issued under Section 74. These were the questions of law which I will bring to the Honorable Tribunal. So, I request the court to consider these questions of law before I present my case on the facts.
My lord, this question of jurisdiction of people should be questioned when the proceedings were on. Once you participate in the proceedings, later you become wiser. This is not a question of jurisdiction that goes to the root of demand. It is only an irregularity that could have been questioned by the taxpayer when this was going on. Because when they visit people, they show INS form number 1, which is normally signed by Joint Commissioner. No evidence has been placed on record. It's only an averment made in grounds. Regarding 65, they should have explored the possibility whether there was a general audit instruction by Commissioner in 65(1). He is right that there has to be an order, either to a general or a specific audit for 65(1). But no such document has been closed. This is their job to put it. Therefore, these grounds cannot be taken. Now, when we say that 74 proceedings can be quashed, this is pursuant to a notice. The Section 170, I would like you, my lord, to go through. Section 170. It's only in this act. It was there in VAT Act also, a similar provision. No, so it's not 170. Sorry.
So 170 nahi hai.
No, it's 160, sir. Sorry, 160, not 170. 160.
Assessment proceedings.
No assessment, reassessment, adjudication, review, revision, appeal, rectification, notice, summons or other proceedings done, accepted, made, issued, initiated or purported to have been done, accepted, made, issued, initiated in pursuance of any provisions of the Act shall be invalid or deemed to be invalid merely by reason of any mistake, defect, or omission therein, if such assessment, reassessment, adjudication, review, so and so, or other proceedings are in substance and in effect in conformity with or according to these intents, purposes, and requirements of this Act or any existing law. The service of any notice, order, or communication shall not be called in question if the notice, order, or communication, as the case may be, has already been acted upon by the person to whom it is issued, or where such service has not been called, and so and so. So, this is a precaution Parliament has taken. Implementing such a vast law throughout the country, these mistakes, errors, which are unintentional, can happen. But it was for the appellant to take note of it and question it. Once you participate in all the proceedings till 74, file replies, now you want to place additional evidence on record, now you say that without jurisdiction, that cuts no ice. But this is not something that goes to the root. Supposing audit is illegal. For argument's sake, entire audit was illegal. Entire search was illegal. Is it a part of the law that consequential proceedings will also be illegal? Which are done after a notice? A notice which they have applied, they have participated with the proceedings. Therefore, it is not fathomable to appreciate this. We can bypass section 170. A provision like this has never been acted upon in any of the judgment for the time, like 155 or section 70 Karnataka Act and Ecom Gill. So once the provision exists, and here the appellant is not saying that the proceedings are ex parte. The search was done in their presence. INS one form has to be shown, because the report has to be put out to the Revenue Department that we have followed these procedures. They should have taken copies. They should have gone to Revenue Officer, give me copies of the order sheet. They should have made out a case. And in this case, he is not becoming a judge in his own cause. There is a search, there is an audit, and then there is a show cause notice. So the Honorable Tribunal is examining only the impugned appellate order. And in appellate order, these points are not taken. So the Honorable Tribunal will have to travel beyond the appellate order to decide whether, if at all this issue exists. We can always argue this issue.
Sir, section 160 does not elaborate that the permission of the commissioner is not required.
No, that is
Where
correct.
it is written in the section
What
160.
Mr. Verma is
This
saying.
is not the clerical mistake, sir.
No, what Mr. Verma is saying.
I'm not even saying this, I'm
that-
reading the
that
section.
Did you raise these objections below the lower authorities ever? or
Sir,
not?
I accept that the appellant could not or did not admit that he did not entertain that. अगर उस समय नहीं उसने किया तो it is a last fact जैसे fact finding.
No, this is not fact finding. This is a question of law.
I admit, sir, कि I couldn't take that point at that time.
You know,
But
there is another issue.
I can take
That this is another substantial issue. Supposing this point is allowed, for an argument, so we allow this point. Let us say this Honorable Tribunal quashes the order. It cannot be annulled. It's an irregular assumption of jurisdiction if at all this exists. But section 74 brought out all the facts to them. 74, 73 is not subject to any other section.
No, that's
They are
correct.
self-contained courts.
No, Mr. Verma, that is correct. In the last tribunal,
Yeah, we held.
we held it because at that time we demonstrated this thing that there are two separate commissionerates. One is commissionerate audit and one is commissionerate for adjudication.
Yes.
The circular numbers and all were also
We referred.
quoted. We referred it. And based on that, I think that matter was being argued
Rashimi
by
Jain.
Rashimi Jain.
Huh.
We had given the relief also. But here in particular case,
But last time we did not refer section 160.
160 you,
The interplay has to be understood.
yeah, that 160 you have brought it now. And
It's exactly a Ecom Gill case. Had Supreme Court not taken section 70 Karnataka VAT Act, they would have followed request marketing case. One additional fact or point of law has to change the order. This Honorable Tribunal has to appreciate whether 160 can be imported for any relief to the revenue. Otherwise, if we don't read one section 160 in the spirit in which it is intended, it will become osseous. It will have no purpose. And no part of a legislation can be without motive, without intent. Intent is very clear. Now because they are faced with the demand of 50 crore plus based on completely ingenuine stuff, such questions should not be allowed because they participated and these funds are not taken anywhere.
But jurisdiction question is a very
No, but there are Supreme Court judgment that the coastal jurisdiction should be raised at the first earlier opportunity.
That is
First
correct.
opportunity. They had 4 opportunities.
Okay.
All findings are dead against them.
So let's hear the case on merits.
Yes.
We'll start with the facts.
Thank you, Your Honor.
Okay, sir. Thank you, sir. Now I come to the facts of the case, sir. The first fact is cancellation of registration of suppliers from where the appellant has purchased goods. My lord, the proper officer has alleged that out of the 12 firms, 7 firms have applied for the cancellation of their registration on their own, while the registration of the remaining 5 firms have been cancelled suo motu with retrospective effects. The proper officer in his order alleged that even registration of the 2 firms XYZ and Company and ABC and Company were cancelled before the transaction took place. In this regard, my lord, the appellant submits the following. Number 1. The appellant has made the correspondence with all the 5 suppliers whose registration were suo motu cancelled. All the 5 said suppliers have either filed the appeal against the cancellation or have applied for the revocation of the cancellation. The proof of the correspondence along with all the relevant documents have already been submitted in additional evidences, sir. Second, that the allegation that 2 of the firms' registration was cancelled before the actual transaction is absolutely wrong. We had even shown the documents to the proper officer, but he forgot to take that point in that order. We admit that we could not get it rectified from the proper officer and appellate authority was not agreed with our view. The appellant has also made correspondence.
Hello. Yeah. You mean to say that regarding those 2 firms for which the allegation is there that they were cancelled prior to making supplies to you, you raised that issue before the adjudicating authority first?
Yeah.
It was not considered?
Yes, sir. Yes, sir.
And thereafter, you brought that fact before the knowledge of first appellate authority also?
We will bring that before the appellate authority.
No, you will bring or you brought it? I am asking the question, I am raising a question to you.
We
Whether
have mentioned that point to the proper officer that the allegation is wrong and we have provided the documents.
You submitted all those documents
Yes.
to the
proper officer also.
to the proper officer
But
also.
he forgot to mention that point in the order. First appellate authority didn't listen us.
No, not. So there is a difference. That authority may entertain your submission, entertain your evidences or not. That is something different.
He
No,
didn't,
I am asking this thing whether you, like Mr. Verma said, that the jurisdiction question you never raised before the lower authorities.
But
This question you have raised,
we have raised
at both the
before
both
the-
the
both
times.
the,
So that can be verified from the record also.
yeah, yes, sir. Yes.
Mr. Verma.
No, Your Honor, this has no point. If certain facts are not brought out, that goes to the justiciable process. Section 161 is there, they should have moved a rectification application. But an honorable tribunal cannot go on to say whether it was taken or not. There is no affidavit. There is no the order sheet copy in it.
You mean to say that if
They
a
did not bring
person,
anything on
if a
record.
person does not exercise his right under section 161, he cannot raise
No,
it in
he
the
can.
appeal?
No, he can, sir. I'm not saying that.
So no, he has not. He is saying this thing.
No, but-
he is admitting that he has not taken the course of 161,
No, Your
but
Honor,
he is in
Your
the
Honor,
appeal
I'm
before
not even
us.
talking of 161.
Hanji.
I'm saying this is an averment made.
No.
Right?
My only question is that he is saying that regarding those 2 particular firms against whom the allegation is that they were cancelled prior to date of supply.
Yes.
there are firms which are cancelled retrospectively on the date of supply. They were active. They have shown the sales in their GSTR1 also. That is a different
You're
case.
not even in
But
this-
in this particular case, the allegation before this court is that there were two firms who made the supplies, and on the date of making the supplies, they were inactive and their registrations were cancelled prior to that itself. He says no, he is denying that fact, and he said that in support of my denial, I have brought these evidences and facts before the adjudicating authority also.
He should have annexed his evidences here. We'll admit.
Yeah, that's what I'm asking.
We'll
whether-
admit, sir, but no issues.
We have admitted, we have produced the evidences, sir, as additional evidences.
No,
Where-
no, no.
where?
See, they cannot form part of additional evidence. The additional evidence means the evidence which you never placed before the lower authorities. If those evidences were already forming part of the evidences are your submissions before the lower authorities, then you have to simply annex it as a paper book or the submissions which were filed. I am again and again asking you this question, whether those are forming part of adjudication proceedings or not.
Sir, we have mentioned this point in our ground. We have taken this point in our ground that we have provided the documents and
Can you give the affidavit also?
Yes, sir. Affidavit of the two firms is enclosed.
So, Mr. Bhawan, he has already filed and he says that I have placed the affidavit also now.
But I don't have. I have only one file. There is no evidence at all here included.
See in the additional
But can you give me the number, please?
evidence.
Yes.
Additional evidence, page number 9, sir.
No, but there's nothing, what you say, there's nothing in this. There is no, not even iota of averment made. You have to approach the tribunal with clean hands, my dear friend. They may trust you.
just a minute,
They
sir,
may pass
just
a
a
wrong
minute.
order.
No, sir, just a minute.
There is no just a minute. It's not in the application. It has to be part of the application before an evidence can be admitted. If it's not put in the application, no evidence can be admitted.
Sir, these are enclosed with application of the additional evidences, sir.
No, but in the application you make no averment. Application has to be allowed, not the evidence.
But application is enclosed, sir.
No, but application में लिखा ही नहीं आपने कुछ भी नहीं लिखा आपने तो इसमें there is nothing. This application itself is not admissible. It doesn't
Sir,
satisfy.
I am only of the view that if he has already submitted all those submissions and documents at the adjudicating stage also, and during the course of first appellate authority proceedings also, then the question of additional evidence or IEA doesn't come here.
But that doesn't come here.
So only a paper book, it will become a part of paper book
Yes,
which he will
yes, it
enclose.
could have become,
so that's
but
what
there's
I am
nothing.
telling him also.
But there's nothing.
So it is neither in the paper book nor in IA. So now whether if we will tell you to file an affidavit today, can you file an
Yes,
affidavit
sir.
today?
I can file it.
And we can get it verified from the adjudicating officer, and it will be forming part of your submissions filed at that
It will
time.
amount to perjury if you make a wrong
Yeah,
statement here.
that's what
No,
we
sir,
are giving you.
I will file it. I will file it.
Okay, then we'll proceed.
Yeah, you can proceed further. Assuming this is filed, you can
Assuming
go on with
assuming it is filed.
Yes.
Okay. What about the rest 10 suppliers? There are total 12 suppliers.
Hani, I am coming to that point. The appellant has also made correspondence with the 7 firms who have got their registration cancelled on their own. All the 7 firms have deposited their taxes and filed their returns before the cancellation of the registration. And proof of the returns are available at the GST portal, and we have provided to the proper officer and also to the appellate tribunal. The Honorable Allahabad High Court in the writ petition number 18282-18252 to 1289 or 2024 held that at para number 31 of page number 38, sir, that under GST regime all the details are available at the GST portal, and therefore the authorities ought to have been verified the same as to whether the filing of GSTR 1, GSTR 3B, how much tax has been deposited by the seller, but the authorities have failed to do, and the Honorable Allahabad High Court had quashed the order. The copy of the order is attached on page number 38, sir. Sir, each and everything is available at the GST portal, and we have shown to the proper officer. Next, my lord, Appellate Authority in his order stated that the burden of proof under section 155 of the DGST Act 2017 lies on the recipient, and the Appellant Authority also given the reference of the famous case of e-commerce Gill. I read the paragraph in Ecom Gill Trading Private Limited Company. Mere claim by dealer that his bona fide purchaser is not enough and sufficient to claim credit. The burden of proving the correctness of credit remains upon the dealer claiming such credit. Such a burden of proof cannot be shifted on the revenue. So, but appellant in my case, your lordship, has provided all the documents of the constructive delivery to the proper officer and to the audit team, and to the even were shown at the to the appellate authority. The same were placed before the appellate authority, but the documents provided by my clients were not considered at any stage of the proceedings. The appellant is ready to produce all the documents again if the Honorable Tribunal wants to check these records. The appellant will take a sigh of relief if can produce all the records if the matter is remanded back to the proper officer. This is the case of 12 firms. Next allegation was truck number and name of the GTA. The proper officer at the time of personal visit alleged that the partner Mr. A.K. Gupta could not give answers to the questions regarding truck number and the name of the driver, and the counsel was misleading the officer by his vague answers. The proper officer has also alleged that the goods weighing 40 tons cannot come in one truck. The proper officer also alleged that the appellant could not give answer of the place of unloading the goods. In this regard, my lord, I would like to say there was no single truck as alleged by the proper officer. The appellant is still stick to his answers that there were more trucks coming behind the main truck. Yes, we could not update the number of truck on the e-way bills or the invoices, but in the invoices, as he was unaware that mentioning all the trucks was necessary. The appellant is providing the details of each of the truck to the Honorable Tribunal on page number 84. That the appellant submits that he has enough space regarding the space of the showroom. The appellant submits that he has enough space in front of the showroom where he can unload the goods and store enough material. At the time of registration, he has unloaded the at the time of registration, he has uploaded the picture of the showroom and the space in front of his showroom at the GST portal, and the same can be verified from the portal also. This justifies that the time gap between the sale and purchase of the goods. We have enough space to unload the goods and keep the goods for storage purpose. Next allegation was payment was not made in declared bank account. My lord, the allegation that the appellant has made the payment of the goods in a bank account which has not been declared by the supplier on the GST portal seems to be baseless. My lord, section 16 subsection 2 only say that we have to make payment within 180 days. We could not know that his bank account is uploaded or updated on the GST portal or not. There is no such mechanism that that we can see that the supplier's bank account is updated or not on the GST portal. So this allegation is a baseless allegation. Provided further that where a recipient fails, no, I will read the sections proviso of section 16 subsection 2 clause C. Provided further that where the recipient fails to pay the supplier of goods or services or both, other than the suppliers on which the tax is payable on a reverse charge basis, the amount towards the value of supply along the tax payable thereon within a period of 180 days. We have to make the payment within 180 days. We can't know that his bank account is updated on the GST portal or not. How can we know about that? So this allegation is baseless allegation. Next allegation that royalty not paid by the supplier for extracting the marbles. My lord, there is a provision of royalty payment at prescribed rates in Rajasthan when the marble are extracted from the land. The royalty is paid by the supplier royalty is paid by the person who extract the marble from the land. In our case, the supplier has the liability to pay the royalty, not the buyer has a liability to pay the. It's the supplier who extract the marble from the land and to pay the royalty to the lessor who owns the land. So the appellant is in common parlance could not know that the supplier has paid the royalty or not. Yes, we admit that we didn't verify that the royalty has been paid by the supplier or not, and this is not our question and our liability. So I don't think मुझे कोई ज़रूरत भी he has paid or not royalty. This is his question. He has to pay. Why should I bother? He has paid the royalty or not?
You mean to say that if a person comes to you and makes supplies of some goods which he is having an illegal title, so you will get the good title of those goods?
No, sir. But when a supplier will come to me, I will just check his KYC.
The simple thing is that no one can pass a better title than he has. Correct?
Right, sir.
So
but
if your supplier is selling you goods with the dirty hands, you cannot get the goods as a pious person.
Sir, but there is no mechanism. How can I check the royalty?
No.
I will
Normally-
I will check the KYC. I will see his GST registration, his PAN number, his ITR, his address proof. That all that.
No, but when actually the thing is here, the case is that this is a case of bogus supply, correct? So when they
Sir, I'm not admitting that there is a bogus supply.
no, but the department is proving against you that it is a bogus supply.
Department has
Well,
not proved it. Department has alleged it.
Okay. Their allegation is that it is a bogus supply.
Yes, sir.
And in order to prove their allegation, they have brought certain evidences on record. Out of that, one evidence is that your supplier has not paid royalty prior to 2 months in advance also. If they've checked the records, for earlier 2 months also, there was no payment of royalty. Correct? So it means that whatever goods were coming in their hands or whatever goods they were selling, they were absolutely, either there was no sale at all, that was a paper transaction, or those goods were illegal. Mr. Verma?
My lord, the whole narration has no legs to stand.
Regarding this royalty only, we'll discuss item by item.
Yeah, no, he cannot say that because I know how marble is sold.
Yeah.
The truck cannot come out of till there is a royalty receipt.
royalty
Truck
receipt.
cannot come out from the mines.
And if I am not
It's a
mistaken,
part of the documentation.
if I am not mistaken, that royalty receipt is always attached with the
Sir,
purchase
truck
invoice
cannot
also.
move, otherwise they'll catch the truck and impound it.
Sir, ये liability उसकी है supplier की. He has the liability to pay.
That's why we're saying there's a collusion. That's what exactly we are
Sir,
saying.
I admit that I didn't check, but he has not paid the royalty. What can I do? Why is my claim is what is the relevance with the GST?
So, you see, that is the indispensable part of the.
What's the
movement
relevance of GST? You are claiming
that
input that's
was
carried
not
based on
done.
that.
So
That is the
it can
relevance.
Prove that it was a bogus transaction.
Sir, they.
Yeah, next one, we can continue.
Continue. We'll tell you the other points also.
Next, purchase invoice were without HSN code. Next allegation was that. My lord, as per the show cause notice that the turnover of appellant is 375 crore and 75% of the purchase is made from the 12 firms. This is alleged by the proper officer. It means that comes to 281 crore, but the input tax credit that was denied was 32 crore. So I made purchases of 180 crore from the 12 firms. If I purchases the goods for rupees 180 crore from the 12 firms, it means that I purchased more than 20 crore from one firm. So read the notification number 1/22 of the central tax applicable from tax period of 22-23 for which my case is related. Persons having turnover of 20 crore,
If you have
20
the copy,
crore or above are
what page?
uh, my grounds देखिए sir.
Which number ground?
Just a minute, sir. दोनों भी सेम है सर.
Because your ground, I did not read any notification word. I hope it's there.
Page number 17 of my grounds, sir. Page number 17. 17, sir, 70.
The 17 doesn't refer to any notification.
Sir, allegations of the third paragraph, paragraph number 10, sir. There are 5 notifications, sir. Paragraph.
Okay,
point
yeah,
number
yeah,
10, sir.
okay,
Point
right,
number
right.
10, sir. Sir, notification number 1 of 22, central tax applicable from tax period 22-23. Persons having turnover of 20 crore or above are under the obligation of issuing e-invoice. My lord, the audit team found some pro forma invoices in my premises at the time of audit that did not contain the detailed description of HSN code, but that was not the final invoice and cannot be treated as an invoice against the rules. All the invoices were issued by the suppliers were e-invoices, and all the invoices contain each and every description, HSN and quantity. And copy of the invoice I attached at page number 37. सर 20 करोड़ से ऊपर की टर्नओवर है, 20 करोड़ से ऊपर की टर्नओवर है तो मेरे को इनवॉइस इशू हुई होगी, तो इनवॉइस इशू तो बिना उसके आगे नहीं बढ़ती. So the allegation that HSN is not mentioned, description is not mentioned is baseless allegation, sir. The invoice contains each and every detail, and the provisions of section 31 are next is next bank account of the appellant not declared on the GST portal. This is again that appellant is well versed of the rule 10A of the DGST Act, which prescribed for the uploading of the valid bank account at the GST portal. The appellant has updated only one account at the time of the registration. He subsequently opened 4 more accounts and declared all the accounts in the books of account and the balance sheet prepared for every year. He was unaware that all the bank account needed to be updated. So when the audit team pointed out those lapses, he immediately updated all the bank accounts maintained at the firm's name. He even produced the screenshot of the same to the proper officer and the the appellate authority. Copy of screenshot is attached at page number 38. We have updated the bank account when the audit team pointed out this lapse. The appellant further submits that no bank account is opened without the PAN number, as alleged by the proper officer that the bank account is opened without PAN account number. So he refutes the allegation that he has some secret bank account to accept the payment. The income tax portal provides the full detail of the assessee, including the bank details. Hence, the allegation seems to be baseless. The proper officer could extract the bank detail from the AIS detail of the income tax on the income tax portal, and he can match my turnover with those AIS detail. So the secret bank account question doesn't arise, sir. Next, size of showroom. I mentioned earlier that I have enough space before in front of my showroom, so I could easily store the goods there. My lord, as the notice is AB void ab initio, तो ये तो आपने मेरे को छोड़ दिया तो उसमें. That's all, my lords. I will request you to either quash the order or remand back the order.
My lords, first, my friend has said that all evidences were produced before the lower authorities. Let's read the additional application, page 2. We can winnow the falsehood from the truth straight away from the application. Page number 2.
Additional evidence.
Let's go to the grounds of application, page 3. The application wishes to bring on record additional evidences in the form of following documents to nullify the observation made by lower authorities who have passed the order based on presumption and facts for which no inquiry has been made from the appellant, nor any such evidence in the form of documents was called for. So he says, I have produced all the documents. But let's read the next line. The applicant always has his evidence and documents in support of legitimate claims made in the okay. Then the proper officer did not at any time call for such evidence. Why will proper officer call for evidence? Your claim, you prove it. And he ever remotely calls such evidence, the applicant would have given the same accordingly. So this is a complete lie. It's a contempt of tribunal. A senior lawyer should be very careful by drafting applications. And the affidavit is also is a complete case of perjury. Your Honor, नहीं वो उसको अंग्रेजी समझ आ रही है, फिक्र नहीं करो, उसको अंग्रेजी समझ आ रही है. This is how they will learn. Your Honor, let's read the impugned order. As we always say, that tribunal being a final fact-finding authority, if the findings below, honorable tribunal should be very slow to disturb the findings. Otherwise, the tribunal should be doing the job of an assessing officer. Let's read the order. The appellant has preferred this appeal under section 107 of DGST Act against on page 23, Your Honor. Creating a demand of so and so. The appellant has enclosed the challan so and so, 10% so and so. Looking at circumstances of this case, he has been advised to make sure this input is eligible to be used, failing which action may be initiated. Because the ITC was fraudulent, the appellate authority had to make an observation. I am allowing you. If it is not there, it's subject to this. So this order may also follow. He can go wherever he has to go. The counsel has taken me through the show cause notice, reply filed by the appellant, and the adjudication order passed by proper officer. I have inquired the counsel on each and every issue raised in the impugned order, and the replies were the same, and nothing more has been brought before me, including the law and documentary evidence of finding. The appellant telling a lie in the tribunal. I produce all evidence. If they are on record, is willing to file an affidavit. Does the appellant want to go to jail by filing a false affidavit here? Next, except the counsel has stated this, including, this is how you learn. Government counsel will speak this shit. So you have to be careful. You have to learn to take this on and be prepared for these kind of onslaughts. There is nothing personal here. But once you tell a lie in tribunal, as a lawyer, you have no obligation to your client to speak any lie at all. We are there to assist the honorable tribunal. We have not given any guarantees we'll win or lose. We have learned from Mr. Bhatia. Mr. Bhatia also lost many cases. Not that we have not lost cases. We have lost many cases. But we don't try to do this. Because the order, you cannot say this order is wrong. Nothing more has been brought before me, including the law and document, except the counsel has stated this trade the materials were procured on constructive delivery only. So who took delivery? The seller did not dispatch the goods. They took constructive delivery. So this is a very clear point of the collusion. And no evidence has been taken on record. But who gave him constructive delivery? The mine people or the seller? So it's not clear. To ensure there is no breakage or defective pieces and hairline breakages on the material that can cause tremendous financial loss to the buyers. Further, he has try to explain the factum of secret bank account where the payments from the buyers in Delhi were routed through, even though the tax invoices did not find place in the official documents. The whole scenario as brought about by the proper officer in the show cause notice, based on an investigation report received from the investigating wing, could not be explained satisfactorily by the counsel except stating that the taxpayer is being harassed for ulterior motives. He is putting an allegation that मेरे पैसे मांग रहा था मेरे से. There should be affidavit on record. He should have filed affidavit against the officer. The tribunal can call him. No such allegation should be made against officers of the government. It's a very serious matter. In fact, the case should be sent to police where his client and officer should go across and find out the truth. I have heard the counsel at some length. Nothing fruitful was brought on record either in terms of legal provisions of the or books of accounts or facts or any other material where some relief could be given to the taxpayer. The question raised before me is that this is not a case where section 74 of DGST is invocable, as the professor has failed to initiate proceedings satisfying the essential pre-jurisdictional issues section. I am in total agreement with the counsel. If this is not a fit case for invoking section 74, then there can be no other case. The jurisdiction under section 74 was rightly invoked by the proper officer, and the contention of counsel is too flimsy to baseless. This is not challenged at all, except making a vague observation. The proper officer has dug out the facts of the case in precision-like manner, and those findings are directly relevant in the law of terms of 16.1 Red v 16.2. Clearly, the proper officer has been able to establish that there was no purchase of goods in the course of business or in furtherance of business. This is 16.1. That is the only substantial provision of section 16. And nothing could be brought on record to satisfy the precondition 16.2 before the appellant became eligible to claim input tax credit. While on this issue, it is fitness of things to quote judgment of Supreme Court Ecom Gill. Mere claim of a dealer he is a bona fide purchaser is not enough and sufficient to claim the input tax credit. The burden of proving the correctness of credit remains upon the dealer claiming such credit. Such a burden of proof cannot get shifted to the revenue. He is trying to shift on us. You prove. How can I be witness against myself? I can't be witness against my own case. Mere production of invoices or the payment made by checks is not enough and cannot be said to be discharging the burden of proof case under section 70 of CAIT Act, that is 155 GST Act. The dealer claiming credit has to prove beyond doubt the actual transaction, which can be proved by furnishing the name and address of selling dealer, details of vehicle, which he miserably failed to do. He didn't give anything. For claiming credit, genuineness of transaction and actual physical movement of goods is the sine qua non, and the aforesaid can be proved only by furnishing detailed. You have to prove physical receipt. First he said the seller responsibility, but he took the delivery himself. Then he says a constructed delivery. Where is the provision of a constructed delivery? The constructed delivery, my lords, is only for 10(1)(b), where section 16 explanation says so, that their constructed delivery on the direction of third party can be made. There is no other provision for constructed delivery in the entire GST Act. It's not a sale. It's supply. Supply includes sales. It's a much bigger term. For claiming credit, genuineness so and so, if the purchasing dealer failed to establish and prove the important aspect of physical movement of goods alleged to have been purchased by them from the concerned dealers and on which the credit have been claimed, the assessing officer is absolutely justified, the Supreme Court, in rejecting the ITC. In Ecom Gill, the assessee had only furnished invoices and payment proof. Here their payment proof was also not taken, not proved. Payment kiya, we don't know. See, Contract Act deals with appropriation of payment. My lord, you are aware, section 10 clearly says when can payment be appropriated. There is not even an inch ke kahan se payment hai, kya hua, kisko diya, pata hi nahi, kaun hai. And there is a finding ke based on the PAN number of suppliers, they searched the bank accounts. They did not find any other bank account. That means a clear case of collusion. I won't say Hawala is a part of FEMA, not Indian law, but this is a kind of an Hawala transaction. It's pertinent to note that the Council of Assessee placed reliance on Delhi High Court in Quest Marketing which blocked credit to the recipient where supplier failed to pay to the tax government was read down as so and so. This was overruled by Supreme Court in Ecom Gill. Even though the above case related to Vera Dream, then 155. Such an hopeless case deserves no mercy and appeal is being dismissed with the direction that recovery amount be initiated as provisions of law. Further, this authority has no power. Now, HSN, if these documents were there with HSN, why will lower authority not record it? They are all afterthought. And none of the copies made as true copy. No document can be filed in any court unless a true copy and stamped signed. Now these are all photocopies. I can make all kind of photocopies. So if at all the appellant had to make out a case, there is no case at all. Absolutely. Then he said bank account we forgot. We have a PAN number, you verify income tax portal. Allahabad High Court judgment was in some other context. It was not in this context. I know the one-page judgment. And Allahabad High Court is not binding upon me. Where you say that your own bank account are not declared. And the appellant says rule 10A says so. Now that's a mandatory provision. Your money comes there. And then your suppliers also, you don't know their bank accounts. So tomorrow suppliers, he says that supplier gave me an account of a terrorist. Will he transfer money to that terrorist account? Will he face jail tomorrow? So that is why the condition is very clear. You have to make to a payment to claim input tax credit only in the bank account of a person from whom you have purchased the goods. Unless there is an appropriation request, consideration under Contract Act in our country cannot travel from third person. English law, yes. Not in section 25 doesn't permit Contract Act. Therefore, the whole case is based on total fraud. Circular trading is a case of section 74 second limb, where no goods were received, only invoices were received, input tax credit was claimed. I will say the inquiry should be ordered against both. 74, both can be caught, supplier and recipient, and there should be an FIR against it. If the tribunal doesn't direct, we will do it. Because such a case cannot be shown mercy where everything is fraud. The whole order is based on fraud. You cannot take a shelter of a judgment. You cannot take a shelter of, no, but this is what I told you, you must listen to this case. This is so. I gave the tough cases to my three conveners.
Mr. Verma,
Yes, Your Honor.
what are your comments regarding storage space with them?
Your Honor, there is no ground taken below. Correct. This is all afterthoughts.
Not only they have not taken the ground below, but otherwise their GST registration certificate also speaks of only 600 square feet.
Yes,
area with
yes,
them.
yes.
And now he is saying that there is a ample space outside. That is no man land.
But he must have shown Rajouri Garden marble shops के आगे illegal रखा होता है.
That is no man land.
Sir, देखिए, whenever we purchase a showroom, we have
Your Honor,
enough
even
space.
here this is an averment.
We have enough space.
This is
in
an
front of
averment.
the-
Averments have no value in
You
tribunal.
you can see anywhere in the.
So the same thing should have been told below. The findings should have been taken.
Mr. Ahuja, whatever we concur with all the statements which learned DR has given, and we have also examined your case in depth. He has not pointed out various other things also, that even we perusing your file, we found that the purchase was of beige color and sale was of pink color. So that type of mismatch was also
Manipulation.
there in your records. And similarly, you were supposed to make payment in 12 different bank accounts to the 12 suppliers. Against that, you used only 4 bank accounts, only 4 bank accounts. So at that point of time also, you are duty bound to find out that why they are giving you the same bank account again and again, which you failed to do. So that proves further your connivance with them. Number one, did they send you any email or other correspondence that the payment should be given only against 12 different parties in 4 parties account only. That case you have not been able to make. You have not brought that fact anywhere. Then as far as your transportation is concerned, for royalty I have already discussed that you have also miserably failed on that part also. You tell me, you said that only the first truck number was mentioned in the e-way bill and there were number of other trucks following that the first truck. How many other number of trucks were there?
6
Can you tell?
Yeah, I have written 6 trucks.
6 trucks. You have given the numbers also of all those trucks?
Yes, sir, I have provided.
LR also? LR also. So you have now given that, but that looks to be afterthought story. Because as per Transportation Act also, MTA also, I brought the notifications also for you. I thought probably you would have not brought it here. So the maximum weight this tandem axle rigid vehicle can carry is 21 tons. And at the time of charge, when the charge was levied against you, that how single truck could carry 120 tons.
But 120 trucks didn't come in one go.
No, but at that point of time, neither the counsel nor the proprietor, both were called before the proper officer. When proper officer posed this question, you had no answer. So this is an afterthought story. You also have found this thing that a truck can carry maximum 21 tons. So you have now added rest 6 tons, and you have accepted this thing that you have not filed it in the part B of e-way bill. This is a major lapse which proves that this is a bogus transaction. Similarly, regarding the space also, you are saying as per GST law as well as in the VAT law also, because you are relying on quest marketing and other things. So I am going traveling to you to the VAT laws also. Each and every inch of space which you are using for your business purpose, that you have to get it registered under your registration certificate. You are again and again saying that I have uploaded the photo of my premises, but the documents which you have uploaded, the house tax receipt which you have uploaded, the rent agreement which you have uploaded, talks of 600 square feet only. Correct? So the goods which were stored, the goods which you have purchased could have never been stored there. So all these things only prove this thing, that all this is a bogus transaction, bogus and fraudulent activity. So I take a very serious note on it. This tribunal will take. Bogus purchases and fraudulent activity under GST laws have been a significant concern, with various cases highlighting the severity of such offences. Courts have also taken a strict stance on these matters, considering false GST invoices and fraudulent transactions as economic crimes, and that causes substantial loss to the public exchequer. In your case, the entirety of allegations and facts presented in this case clearly indicate that the appellant has engaged in fraudulent transactions involving bogus purchases with the deliberate intent to deceive the exchequer and evade the tax obligations under GST laws. The appeal is dismissed with a direction to the department to initiate the necessary prosecution proceedings also. And we also levy a cost of 1 lakh rupees on Messrs. Agastya Trading Company and its partners, which must be deposited into the Welfare Fund of Advocates of Sales 6 Bar Association, New Delhi, within 10 days of this order.
Now friends, okay, no, we are not getting it. Now friends, what does this case mean? First, let's clap for Mr. Narender Ahuja. Very well argued, a very hopeless case. I told you it's a very hopeless case he has to argue. Now there are 5 lessons from this appeal. Wherever you think something has not been done as per procedure, as per law, you have to put up to the authority a notice immediately. Whether 65(1), 66 or 67, whatever requirements are there. Wherever limitations expire, put a letter to the proper officer that your 3 months are over. I will not appear before you. Extension has to be before 3 months expire, not after. Post facto extensions are not legally possible.
No, in this particular case, you said that audit had taken place and beyond 3 months. Now, in this, when it takes place beyond 3 months, and even if we would have taken some evidence from court file, or from that office file, that there was no permission from the commissioner, what is the stand about that?
Nothing.
audit?
There is no default consequences.
Just I want to know, okay,
No, evidence remains. There can be inquiry against officer. See, this law, there is no default consequences mentioned. That is the problem. For example, this special audit you do. Most of the CA start writing letters to the SSC. They have no authority. So that doesn't mean the special audit report is incorrect. It's a damaging issue. But if 3 months later you put a letter on record, he will stop proceeding, tell him I will not participate, your time is over. You exercise your right. But you get scared कि साला client भी पैसे नहीं देगा, यहाँ भी कुछ मिलना, रिश्वत भी नहीं मिलनी, तो आप इस चक्कर में पड़ जाते हैं. उसको लेटर दो ना लिखकर. आप तो रिफंड पे इंटरेस्ट मांगते हैं, डरते हो लोगों से कि हमारे रेट ना डाल दें. So therefore you have to put the authority to notice that your time is over. Right? Whenever you do a thing like this involving movement of goods, there is a Carriage by Road Transport Act. That's a collateral provision you have to understand with movement of goods. There is nothing like constructed delivery. There is a section 10(1) small a of IGST Act, but that doesn't talk of constructed delivery. He can take the goods and he can get it to Delhi himself. But that section 10(1) also allows whether the goods are taken by recipient. But when you use a term constructed delivery, it doesn't exist in the GST except for bill to ship to transactions. Whenever you create evidence, in this evidence there are dates problems also. With a matter of procedure, we didn't want to waste time here. It's a moot tribunal. Your evidence must support with dates. Like the honorable chairman asked, did you get an email? This is huge evidence. वो email कहता है जी आप मिस्टर वर्मा के बैंक अकाउंट पैसे दे दो. But I will say even that was not enough. Something which has to be done legally, you cannot do in an illegal manner. So it's your job. Now there are enough rulings available. Input as credit can be denied to you if you did not make payment to the supplier. So when you read 16(1) with 16(2)(d), interplay is this only. Tax and wise किसने दिया आपको? Tax and wise मिस्टर वर्मा ने दिया, पेमेंट आप इसको दे देंगे? ऐसा पॉसिबल नहीं है. Appropriation tax law में allow करते नहीं. And then when you make prayers.
No, in any law, it is never possible.
Yes. Now, when you write prayers, the crux of your appeal is whatever you write above is your prayer. His prayers are also wrong. He should have challenged that I am calling physical reply now, personal hearing also. This is violation of natural justice. You can't be calling on the same day. Reply आज करो, आज ही मैं आपकी hearing करूँगा. The Supreme Court says this cannot be done. So natural justice keep attacking in your appeal because the higher authorities will remand. Majority of the cases by High Court are remanded only on this ground. Reply was not considered remand. And the prayer should be in consonance with the grounds you have taken. And when you create evidence, correlate with the grounds you have taken, correlate with the orders on facts passed by the lower authorities. That is why assessment you get 10,000, appeal you get 5 lakh. तो 10,000 से 5 लाख जाने के लिए आपको कुछ तो मेहनत करनी है यार. घास काटोगे तो यही होगा. बंदा जेल जाएगा, 1 लाख कॉस्ट भी देगा. कॉस्ट भी देगा. और मेरे ऐसा अपीलेट अथॉरिटी हो तो मैं सारे पैसे जमा करवाऊंगा. आई विल डिसमिस योर अपील एट द थ्रेशोल्ड. गो. आई विल गिव कंप्लीट फाइंडिंग्स. ये कंप्लीट शाम ट्रांजैक्शंस हैं, सब चोरी का माल है. इट्स ऑल टैक्सेस एडमिटेड. मेरी फाइंडिंग गलत, आप आगे जाकर तोड़वा लो. हाउ डज इट मैटर टू मी? इट्स इन द रेवेन्यू इंटरेस्ट आई एम डूइंग. सो दिस 10% of disputed tax, उसके आगे कुछ लिखा है पहले, you have to pay the entire amount of tax which is admitted. You might have to admit, I will write this is admitted. Supposing आपने 3B का टैक्स जमा नहीं कराया, 3B can be filed without payment of tax, there is no bar. अरे छोड़ो यार, हमने की हैं, वो अगर आपको इंस्टॉलमेंट से बाहर निकलना वो होती है. लेट अस से कि आपने 2-1 फाइल किया, लेट से 3 भी छोड़ दो, आप वहां आपने 10 करोड़ की सप्लाई दिखा दी, आपने पेमेंट नहीं की. अगर वो 75-12 में जाता है तो रिकवरी स्ट्रेट अवे कर लेगा. अगर 73 करता है तो आपको टैक्स इंटरेस्ट लगाएगा. नाउ कैन यू से डिपॉजिट 10%? So 10% is not a universal truth in any law. That is why these conditions, they write before this condition, entire amount of tax admitted. That is why for 75-12 proceedings, 73-74 notices have been dispensed with. They can straight away issue a rate of demand. So when you draft such serious appeals, I can tell you honestly, he has spent 1 month writing this appeal. It was very tough appeal, very tough appeal. And this year he retyped 3rd time. I can tell you because I know it. But I keep telling him, you have a difficult task, you cannot come out of these facts. So never die on facts. And whenever you talk of goods received, 16 नंबर लिखते हैं ना, हम क्या लिखते हैं? सर हमने इसका माल बनाया, हमने इसका प्रोडक्शन किया, हमने इस पर टैक्स दिया, it is zero value. Input tax credit when you get? When you receive the goods. All these actions are consequent to receipt of goods. So you have to prove physical receipt. Ecom Gill, Supreme Court has used this phrase beyond reasonable doubt 7 times. 7 times they have written in judgment that beyond a reasonable doubt you have proved your transaction was genuine. So the circumstantial evidence in Evidence Act section 6 called theory of res geste. This means circumstantial evidence. So the honorable judges have gone circumstantial evidence. तेरा बैंक अकाउंट नहीं है, royalty नहीं दी है, ट्रक का झूठ बोल रहा है, जगह का झूठ बोल रहा है. These are all circumstantial evidence which is leading to dismissal of the case. So whenever you rely on evidence, don't create evidence ever yourself. It's not your job. कल को ये पहुंचेंगे आज उसके क्लाइंट को बुला ले एक गुप्ता को, वो बेहोश आ जाएगा, वो बोलेंगे ऐसे को जेल में डालेंगे. एमपी हाईकोर्ट के जज बोलते हैं जेल में डालेंगे, सुनते हो ना वीडियो, वो तो बोल देगा जी तो आहूजा साहब ने बनाई थी, मुझे उसका कुछ पता नहीं, मैं तो कुछ साइन नहीं किया इसके ऊपर. Then yes, counsel also goes to jail. That is why in 132 beneficiary word was added.
अभी हाई कोर्ट ने केस में परजरी कह दी है.
मैंने पढ़ी है जजमेंट, वो वकील को छोड़ दिया.
वकील ने भी कह दिया इनके अगेंस्ट परजरी का वो जो है
केस करो. Be careful. Never file document before any authority which is not signed by the client. मैंने इस केस में भुगता हुआ, बहुत पुराना, प्रकाश कुमार जी आए थे, इनके साथ मेरा कुछ हुआ था. मैंने किसी वकील के कहने से ट्रू कॉपी कर दी थी, तो मेरी दोस्ती थी उनके साथ, उनको छोड़ दिया था. You have no authority whatsoever in law, in any law, to file documents which are not attested by the client. You should never attest anything. क्लाइंट ने क्या किया आपको क्या पता? अब इनके बिल पे कुछ भी नहीं है. That cannot be taken in evidence in any court of law. They will throw it out. So additional application, आप आहूजा साहब बोल रहे थे हमने मैं एफिडेविट फाइल करूंगा, नीचे मेरा हो गया. आपने एप्लीकेशन तो पढ़ी नहीं. So the other counsel can read your papers and prove you wrong. So it was a tough case. I hope you enjoyed it. Thank you.
Thank you.
अगर सुबह तूने अच्छे अच्छे मैसेज पढ़ने हैं तो अच्छा सा सवाल पूछियो, वरना मैं गंदा मैसेज लिखूंगा.
हमारे पास टैक्स इनवॉइस आया और सप्लायर हमारे से उसी नेम में क्रॉस चेक ले गया. अब उसमें सर हम कैसे चेक करेंगे कि वो बैंक अकाउंट उसका लिंक है या नहीं?
नहीं तो आपका चेक तो उसके नाम से दोगे ना.
उसके नाम से ही
हाँ तो उसके अकाउंट पे फिर क्या प्रॉब्लम है आपको? फिर तो उसके बैंक में जाएगा, कोई बैंक उसका हो. पर इसके केस में उसके बैंक ही नहीं थे ना, पैन से बैंक लिंक ही नहीं हुए. वो फाइंडिंग दी गई, वो जब मैंने ऑर्डर बनाया था इसलिए लिखा था कि तेरे पैन से मैंने चेक किया, कोई बैंक अकाउंट नहीं है.
सर ऐसा भी हो रहा है कि सेम नाम की और बोगस फॉर्म्स बना के उनका बैंक अकाउंट खुला.
वो तो फिर बाद इंक्वायरी होगी तो आप बीच में आओगे, आप अप्रूव करो उसको.
मेरे से मिल लेना.
एक मिनट. हाँ
लीजिए कोई व्यापारी है,
जेब हाथ बार,
हाँ सर, कोई व्यापारी है और व्यापारी ने जैसे कि कोई माल बेचा किसी को और माल बेचने में उसने मान लीजिए 20 फर्मों से माल खरीदा है, 20 फर्मों में से 10 फर्में तो मतलब कि जेन्युइन है और 10 फर्जी हैं। अब उसी व्यापारी से मैंने माल खरीदा है और मैंने जेन्युइनली माल खरीदा है, तो सर कोर्ट कैसे इस चीज को या हम लोग कैसे इस चीज को बताएंगे कि साहब वो जो माल उसने फर्जी से खरीदा था या जेन्युइन से खरीदा वही माल मेरे पास आया है, तो वो सर वो कोरिलेट नहीं कर पाते हैं। और एक क्वेश्चन और है इसी के साथ साथ कि जैसे सर कोई लोकल सेल हुई है, मतलब लोकल व्यापारियां आसपास हैं 1 किलोमीटर के अंदर है, तो सर उसमें तो क्या होता है छोटे छोटे ऑटो से माल आता है, मतलब जैसे छोटा हाथी वगैरह जिस तरीके के बोलते हैं, तो उससे माल आता है 1 टन 2 टन, धीरे धीरे रोजाना बोरों में या किसी में भर के स्क्रैप वगैरह आ रहा है। तो सर अधिकारी को अब इस चीज को हम कैसे मतलब जेन्युइनली बताएं कि साहब ना तो बिल्टी बनती है इनकी और जो ऑटो वाले होते हैं वो भी रोजाना कहते हैं हाँ भाई 2 टन माल हो गया तू आजा हमारे यहाँ से उठा के ले जा। तो इस चीज को सर मतलब कि जैसे
आज तक किसी केस में इंक्वायरी नहीं हुई जो ट्रांजैक्शन जेन्युइन है। DGST का डायरेक्टर मेरा दोस्त है, आई हैव सीट विद हिम, ही हैज शोन मी 100 केसेस, मोर देन 100। हर केस में लोगों ने पैसे जमा कराए। क्यों? ये जो आप करते हो उसको आपको क्या होना होता है, एक ईमेल बनाइए, जब आई हैव पिक्ड अप फ्रॉम ऑनरेबल चेयरमैन मैसेज, ईमेल बनाइए कि भी आज तेरा इतना माल आया, ये ऑटो नंबर था, ये ट्रक नंबर था, वी हैव रिसीव्ड द मटेरियल इन गुड कंडीशन। So that is what Supreme Court says कि you have to give acknowledgement of receipt of goods. Email is the best document. Email cannot be antedated.
सर लेकिन अब जैसे अब ये तो अब जैसे आप लोगों ने फाइंडिंग दी कि हाँ साहब ऐसे करना चाहिए ऐसे करना चाहिए, जो 17, 18, 18, 19 में जिनके नोटिस भी निकल चुके हैं, अपील में हियरिंग भी हो चुकी है, जिनके ऑर्डर भी पास हो चुके हैं, अब हमें ट्रिब्यूनल जाना है या हाई कोर्ट जाना है, तो सर उसके लिए
हाई कोर्ट का केस है नहीं, ये सब ट्रिब्यूनल के केसेस हैं।
हाँ सर, अब हमने एविडेंसेस मान लीजिए इस तरीके के नहीं दिए कि हमने ईमेल नहीं करा या कुछ नहीं,
आपके पास उस हाथी का पेमेंट का बिल तो होगा,
हाँ है सर,
तो उसके ऊपर उसका पूरा रजिस्ट्रेशन नंबर आ रहा है।
रजिस्ट्रेशन नंबर साइन उसके दे दें।
That's it. That is enough. That is enough.
That is not enough now as per Supreme Court. That is not enough. Tax invoice payments are not at all document of receipt of goods. आपको सातों कंडीशनें सेटिस्फाई करनी है 16(2) की साइमल्टेनियसली, और बीच में ऑड वर्ड नहीं है, एंड है।
टैक्स पे करने वाली बात है जब उसने अपना रिटर्न भरा और उसने मान लीजिए फर्जी आईटीसी को अपने यहाँ क्रिएट कर लिया और उस आईटीसी,
हाँ तो ये आप देखें जब 16 में जाते हैं, सप्लायर शुड हैव मेड पेमेंट थ्रू एलिजिबल इनपुट एज क्रेडिट और कैश। उस एलिजिबल वर्ड की वैल्यू है ना। अब जैसे इसके राजमनी के केस में था, उन्होंने कभी लैपटॉप खरीदे ही नहीं थे, तो लैपटॉप बेच कैसे दिए? उनकी 3 पे कहते हैं हमने लैपटॉप खरीदे ही नहीं कभी उन्होंने। सो दिस इज अ क्लियर, हाँ
जेन्युइन से भी माल खरीदा है और कहीं उसने
अगर देखो व्हाट्स योर नेम, निखिल, अगर जेन्युइन है देन यू डोंट हैव टू वरी।
सर दोनों से खरीदा उसने, कुछ बिल तो एक्चुअली माल खरीदा है और कुछ बिल फर्जी
देखो,
तो अब उसको अब अधिकारी,
in that case let him suffer, let him enjoy his life, you keep getting money for filing appeals, हाई कोर्ट में मेरे पास आ जाना, मैं ले लूंगा थोड़े पैसे। हाँ जी प्रमोद, व्हाट इज योर क्वेश्चन?
मेरा क्वेश्चन सिंपल यही था, मैं ऐड करना चाह रहा हूँ, जैसे हमारे होलसेल मार्केट्स हैं दिल्ली में ज़्यादातर, तो एक दुकानदार मेरा पड़ोसी है, वो मेरे को माल दे गया, मैंने माल खरीदा, मैं मान रहा हूँ मैंने टैक्स इनवाइस भी लिया, जो आइटम उसने मेरे को बेची मैंने आगे सेल भी कर रखा है, मैंने पेमेंट,
यू स्टिल हैव टू प्रूव के फिजिकली रिसीव आपने कैसे किया।
डिलीवरी ऑफ गुड्स कैसे प्रूव होगी?
आप उसको उसके इनवॉइस पे लिखो, उसके साइन करा लो, ये प्रूफ है। ईमेल लिखो ना, ईमेल पे कितनी देर लगती है?
ईमेल अगर नहीं है तो
नहीं कैसे, क्यों नहीं ईमेल, दुनिया बात पास को साले हर के पास ईमेल है।
के पीरियड में भी ये था कि जब लोकल में माल जाता,
एक नरेंद्र आपके केस में एक और कमी थी, देयर इज नो कंसेप्ट ऑफ परफॉर्मा इनवॉइस कीपिंग इन द कंपनी।
गुड्स रिसीट हम वो
ए इनवॉइस देयर कैन बी नो परफॉर्मा इनवॉइस। ऐसे कॉल का 50 परफॉर्मा बोल दो जी, ये सेल कैंसिल हो गई थी, हमने इनवॉइस बनाया ही नहीं। So whenever you make grounds of appeal based on law, re-verify the law कि are we correct in writing this? क्यों मेरे यहाँ से गवर्नमेंट काउंसिल होगा, आपको रिलीफ नहीं लेने देगा किसी भी कीमत पर। और जब आपके लीगल इश्यूज हों, तो व्हाट इज लिटिगेशन स्ट्रेटजी? यू कैन रिक्वेस्ट द ट्रिब्यूनल, दीज आर माय 2 issues, you please decide first before you do on merits.
इनका सबसे स्ट्रॉन्ग केस था जिसको इन्होंने एब्सेस कम दिया, नहीं दिया, रादर बहुत थोड़ा दिया, और सेक्शन 74 का नोटिस ही नहीं इशू हुआ, which is jurisdiction
नहीं वो 74 का नोटिस था, नहीं वो नहीं था, इससे बड़ा नहीं लिखा है, नहीं है वो 74 का नोटिस।
सर आपने उसमें
मैंने बनाया हुआ है सर, तो मुझे पता है 74 का नोटिस है। ऊपर नहीं लिखा है,
हाँ ऊपर नहीं लिखा,
ऊपर ही लिखा नोटिस एंड सेक्शन 74, नीचे लास्ट पैर में लिखा है।
और ऑडिट का भी, अगर ऑडिट का उसने ऑडिट किया हुआ कि अगर उसको जुरिडिक्शन नहीं था बल्कि उसने परमिशन लेनी थी, अगर वो परमिशन उसने नहीं लिया, खुद ही उसने
लेकिन that doesn't annul the demand।
वो सिर्फ वही था कि हमें फैक्ट्स पे ये केस
वो नहीं उस पे नहीं बात बनती,
जुरिडिक्शनल इशू है।
हर एक तो jurisdiction, लेकिन आपको शोकत नोटिस इशू 74 में है ना, 74 का 65 से लेना देना,
वहीं पे उन्होंने तो वो उसमें उनसे करना
वो नहीं बनता। वो अब जजमेंट आ चुकी काफी हाई कोर्ट की, इसका इंटरप्ले हो चुका। सो फ्रेंड्स, now we take up the next case. Can you take the case of Tanishq?
रश्मि।
Okay, रश्मि। चल भाई कन्वीनर, आज आप तो खड़ी हो जा।
Friends, first of all, I would like to say that I have no regret in losing this appeal.
No, you have no. Who told you have lost? You have not lost appeal.
सर मैं कुछ कह नहीं रहा, मैं जो
आपने लॉस किया ही नहीं
ना,
अब उनको तो डिसीजन देना है कि तेरा क्लाइंट चोर है तो चोरी बोलेंगे उसको। You have done your best.
The message we want to give through this appeal is clear, that never indulge in bogus trading. Yes. We want to give this message. मैं अपने आप को
Here comes the cat out of the bag. You admit के चोरी का क्या?
Next.
Yes.
Next item number.
एक मिनट। जब उसने वैल्यू 0 दिखा तो टैक्स नहीं दिया उसने। वन का आपका 2-1 का आपको 2B बन के आ गई। 2B की रिटर्न की कोई बुक्कत नहीं है, इससे जीरो वाली डॉक्यूमेंट है ऑलवेज से। इट ओनली एनेबल्स यू टू एडजस्ट योर आउटपुट टैक्स अगेंस्ट इनपुट टैक्स। अगर ये फाइनल होता था 70-74 खत्म कर देने चाहिए। 16-1 की कोई भी रिटर्न, कोई भी ये स्टेटमेंट है फाइनल नहीं है, कुछ इनका कोई बुक्कत नहीं है। आपका 3B में हो, अब इनके केस में तो सारी 3B रिटर्न फाइल है। देखो उनका तो यही है कि जो उसकी 3B रिटर्न है उसमें दिखाया हो और आपके पास बाकी सारे डॉक्यूमेंट्स हो।
हम कैसे चेक करेंगे सर? पोर्टल पे भी शो करता है, पोर्टल पे से ये शो करता है कि 3B फाइल यस लिखता है वो।
आप अपने सप्लायर से कॉपी मंगा सकते हो।
हां, कॉपी मंगवा सकते हो।
काम आपको करना है। सेक्शन 155 उन्होंने क्यों नहीं देगा वो? 155 में आपको प्रूव करना है उसने टैक्स दिया या नहीं दिया। एक मिनट, आप ऐसे करो, एक दिल्ली हाई कोर्ट की केस था प्रिंस प्लास्टिक्स, मेरे ब्रजेश माना साहब ने किया था। उसमें जज ने लिखा था, इफ यू आर डीलिंग विद ए मैन ऑफ स्ट्रॉ सफर द कॉन्सिक्वेंसेस। आप उसका टैक्स उसका रोक के रखो, मैं नहीं परमिट को टैक्स पे उसके 6% ब्याज साथ दे दो। If it's not possible, then you suffer. फिर तो लॉ है।
Friends, the time is running out. Please keep your.
Okay, let's welcome Rashimi Jain.
This case relates to notice under section 74 for erroneously claiming and availing refund of unutilized input tax credit on the basis of export of goods. The allegation was that the supplier's registration certificate against whom the input tax credit was claimed were cancelled suo motu on the base. And on the personal visit of the department, it was found that no such firm was in existence at the given address. Please welcome CA Rashimi Jain ji.
Now you are going to see a other side of the case. It's not a case of lines of Narender Ahuja. अब इस केस में she has exported goods, लेकिन वो जो goods कहाँ से आए वो सब चोरी चिकारी का मामला है। She purchased from 3 suppliers who were found non-existent. She herself transported the goods, appointed transporter was non-existent. उसकी इंक्वायरी की गई, कुछ पेमेंट भी नहीं की। कई लोग मेरे से पूछते हैं क्या 180 डेज की कंडीशन एक्सपोर्ट के केस में लगती है? मैंने आपको शुरू में बोला था, इट सेज सब्जेक्ट टू सेक्शन 17(5). अगर 17(5) में कोई क्रेडिट ब्लॉक नहीं है तो आपको आईटी से नहीं ब्लॉक करने की जरूरत नहीं है, बट यू आर स्टिल डीलिंग विद इनपुट टैक्स क्रेडिट। Input as credit given in section 16 only. Therefore, export के cases में there is a debate, but my also view is कि आपको ITC reverse करना होगा. It's my view. No court has ever said so. Whenever you are faced with such cases, let the tribunal not dismiss the appeal. Follow a strategy, my lords. We will deposit the tax with the liberty that if this case decides in our favor, we can approach you back. So here you get a leverage, a gateway open to you tomorrow. But if you simply deposit without any such order from the court, then you have problem. Right? So whenever you are faced with these situations, the best litigation strategy is to live for another day. पैसा जमा करा दो, because interest meter will continue. कल को penalty भी लग सकती है आपको. Deposit money, make an application to the Honorable Tribunal or High Court that we are seeking liberty to approach back if the case is decided in favor of assessee whenever. तो उसमें आपके limitation will not run. Rashimi Jain.
My lord, with your permission, I would like to proceed. My lord, I am pleading as a counsel for ABC International, a proprietorship firm dealing in tobacco products including pan masala. This appeal relates to recalling of the IGST refund given to the appellant in compliance of section 54 subsection 1 of DGST Act, read with rule 96 of DGST rules. Amount involved is rupees 23,40,000 and interest is 13,32,000, penalty to be calculated separately. My lord, appellant's compliance with regard to the reclaimed refund are fully evidenced and verified during refund sanction process. First, appellate authority confirmed the order of adjudication authority to recall without appreciating the law. These are the briefs, sir. My lord, the appellant has filed an application for additional evidence in compliance to Rule 112 of the DGST rule. An affidavit of the proprietor is also annexed as Annexure AD3, page 6 and 7 of this appeal. My lord, the absence of these documents in early stages was not due to an intentional omission or negligence, but rather due to a good faith assumption that returns and declarations already filed were sufficient to support the refund claim. These documents are always a part of our books of accounts. We request this honorable bench to allow these evidences so that the liability of the appellant can be determined properly and legally. Thank you, my lord. Your lordship, I pray you to have your attention on the issue of jurisdiction first. May I? So the question before this Honorable Tribunal for Adjudication is whether the proper officer under the provision of section 74 of the DGST Act was justified in recovering the refund of rupees 23,40,000 given to the appellant for the tax period January 22. The refund was credited to our bank account on 29th March 2022. After making the inquiries and satisfying himself of all the transactions at the time of sanction of the refund under section 54 subsection 1 read with rule 96 of the DGST Act and rules. All this was done by the officer on the subsequent events. So do you want to me read section 54 subsection 1 and rule 96? Thank you, sir. Now, the lordship, I want to draw your attention on the question of laws. Sir, my question of law is on page.
Your question of laws have been framed rightly at page number
52, sir.
52. But before coming to your questions of law,
Yes, sir.
before coming to the questions of law, we would like to argue on the additional evidences.
Yeah.
Because if you are able to convince this tribunal regarding your innocence and
Yeah.
correctness of your claims of IPC, then these questions have got no relevance. They
become insignificant.
So, sir, you want me to first discuss my application for additional evidence?
Yeah, additional evidences and the new evidences which you have adduced now. How you will prove that the charges are the demands which were created against you can be quashed?
Sure, sir. Sir, please refer page number 4. So I would like to read my grounds of application. Page number 4, sir. The applicant respectfully submits that the additional evidence now sought to be placed on record has always formed part of the books of account.
No, see, this was regarding acceptability of your IA as well as additional evidences which we have accepted.
Okay, sir.
But now you try to prove and convince us that the charges which have been levied
No, my
in
lord, but
SCN.
there's one more application for.
Cross-examination is there, sir.
You have one more additional application, na?
Sir, for cross-examination, I have forwarded the application.
Okay, but that can come later.
That will come later. So my question is that the charges which have been levied against you in SCN, basis thereof the demands have been created, which have been confirmed by the first appellate authority also. How you are able to come out of those allegations through these additional evidences? Because during the course of assessment proceedings, you never brought all those evidences on record. And you have been mentioning since you were never asked for. When SCN is issued, then the ball comes in your court. You have to prove your innocence and you have to bring the entire material, whatever is available with you, to prove that the allegation is wrong. So during both the stages you have not brought it, but now you have brought it, and in the interest of natural justice, and we are allowing it. But now you please convince us that how the SCN needs to be quashed.
सर जो एविडेंस अभी मैं एडिशनल एविडेंस में दे रही हूँ, आप अगर उनको मेरे जो ओरिजिनल एविडेंस फाइल्ड हैं उनकी लाइट में देखेंगे तो वो उसका एक्सटेंशन है. हर जगह हमने अपने इन्वॉइसेस को दिया है, अपने कॉन्ट्रैक्ट्स को भी हमने, वो जो सारी हमारी वर्किंग हुई थी जो पहले RK शर्मा जी ने किया है काउंसिल ने, उन्होंने जो एडिशनल एविडेंसेस मैं आज लेके आ रही हूँ वो इन कॉन्टिन्यूएशन ऑफ ओरिजिनल एविडेंसेस हैं. अगर मैं आपको उसकी ट्रेल बना के दिखाना चाहूँ सर, तो हम इस तरीके से चल सकते हैं. सर एविडेंस के अंदर मेरा पहला एविडेंस है सर, बैंक ई-कॉम गिल रिक्वायरमेंट की शीट मैंने दी है. तो सर ई-कॉम गिल रिक्वायरमेंट की जो शीट दी है उसके अंदर हमने लिखा है द डीलर क्लेमिंग इनपुट टैक्स क्रेडिट हैज़ प्रूव बियॉन्ड डाउट. सर इट्स पेज नंबर 9. जी सर. सर पहला एविडेंस मैंने दिया है ई-कॉम गिल रिक्वायरमेंट शीट, द स्टेट ऑफ कर्नाटका वर्सेस मेसर ई-कॉम गिल कॉफी ट्रेडिंग कंपनी प्राइवेट. ठीक है. द डीलर क्लेमिंग इनपुट टैक्स क्रेडिट हैज़ टू प्रूव बियॉन्ड डाउट द एक्चुअल ट्रांजेक्शन विच कैन बी प्रूव्ड बाय. First point
is this the ratio of e-com gill?
What sir?
Is this the ratio of e-com gill?
Yeah.
No, it's not. It's not even 10% of e-com gill.
During the course of adjudication, you said that e-com gill is not applicable, so you will not reply for all those things because that pertains to non-GST Act.
Yeah.
And now you are relying on e-com gill.
Sir, Sir, I am relying on e-com gill, and that statement was given by Mr.
No, but
Sharma.
is this the ratio of e-com gill? My question is this.
Yes, sir.
This is 10% of e-com gill.
Sir, आप मेरी सुनिए तो सही, मैंने क्या लिखा है?
ये मैंने पढ़ा है, मैंने पूरा पढ़ लिया आपका.
सर क्या लिख पढ़ा है आप बताइए
The
क्या
dealer
लिखा?
claiming input as credit has to prove beyond doubt that actual transaction which can be proved.
By
Is this e-com gill?
Sir, e-com gill के
Is this
अंदर-
e-com gill
Yes,
ratio?
sir.
It is not. E-com gill says that you have to prove transaction was genuine, you physically received the goods.
Sir, I have given the documents ना.
On
आप मेरी
document,
detail
but this is not the e-com ratio. This is not the ratio.
Sir, documents.
Transaction in any case has to be genuine. E-com gill doesn't have to say you.
सर फिर मैं कैसे प्रूव करूंगी? मैंने ईमेल्स अपनी सारी चीजें यहाँ दी हैं, आप उसको ट्रांजैक्शन को देखिए तो सही, सुनिए मुझे पहले।
Let it be not the ratio. You go on.
Wait,
Sir,
you are in
please,
tribunal.
sir,
Wait,
please.
you can't interfere.
Can I speak now?
Yeah, please.
So my first point is furnishing the name and address of the selling data. I have written refer purchase tax invoice. Sir, I have written this intentionally because at the time of lower authorities, Mr. R.K. Sharma has provided the invoices. But he failed to satisfy कि ये कैसे उस चीज को कर रहे हैं, सेक्शन 155 को प्रूफ कर रहे हैं।
नहीं, आपने इनवाइसेस दिए थे,
जी सर।
लेकिन उसके ऊपर आपके ऊपर काउंटर एलिगेशन लगा कि वो इनवाइसेस बोगस है।
हाँ जी सर।
करेक्ट। और उसको बोगस प्रूफ करने के लिए आपके ऊपर चार्जेस जो लगाए गए, ट्रांसपोर्टेशन के लगाए गए, पेमेंट्स के लगाए गए।
जी सर।
करेक्ट। तो आपने दे दिया इनवाइस, उसमें नाम और एड्रेस आ गया,
सब कुछ आ गया।
डन। So that is not question in dispute. The question in dispute is whether those invoices are genuine or ingenuine.
सर मैं उसी को प्रूफ करने जा रही हूँ और मैंने हर जगह रेफरेंस जो दिया है पुराने उनका दिया है, वो इसीलिए दिया है कि जो मेरे लर्नेड काउंसिल जिन्होंने पहले इस चीज़ को प्लीड किया, फर्स्ट एससीएन को भी जो रिप्लाई किया और जो इन्होंने फर्स्ट एपेलेट अथॉरिटी के सामने भी केस को प्रेजेंट किया, उन्होंने एविडेंस दिए पर उनको वो प्रूफ करने के लिए और जो वो लैंग्वेज यूज़ करना था वहाँ उनसे कुछ कमी रह गई। तो सर एक कमी कभी रह सकती है, उसको हम आगे चल रहे हैं। सर वही बताने की कोशिश कर रही हूँ कि मेरे जो सारे परचेज इनवॉइस, सेल इनवॉइस पहले भी दिए गए थे और उन्हीं से लेके जब हम आगे बढ़ते हैं तो मैंने अब आपको ईमेल्स दी हैं अपनी, क्योंकि हमारे यहाँ जो मेरा क्लाइंट है वो सारा काम थ्रू ईमेल्स करता है और ईमेल की ट्रेल मैंने फर्स्ट डेट से दी है कि कब उसके पास एक्सपोर्ट के लिए ऑर्डर आया, कैसे उसने आगे फर्दर अपने सप्लायर्स को ईमेल करा, कैसे उसने अपना CHA अपॉइंट किया, कैसे उसने अपने ट्रांसपोर्टर को अपॉइंट किया। साथ में ही सर वो ईमेल्स की पूरी ट्रेल मेरी चल रही है, मैं आपको पेज नंबर बता देती हूँ। सर यू वांट टू सी ईमेल्स? सर इट्स पेज नंबर 11. No, sorry. Sir, it's from page number 15. Yeah. Purchase order for cigarettes and roasted tobacco, sir. मैंने उसको नाम दिया। सर ये पहला मेरे पास परचेज ऑर्डर जो आया है, मेरे पास दुबई से आया है। अल्फाज जो LLE ने मेरे को ऑर्डर दिया कि उसको ये प्रोडक्ट्स चाहिए। सर सेकंड पेज नंबर 16। फर्स्ट सप्लायर सर रविंदर एंड कंपनी को हमने ऑर्डर प्लेस किया कि ये हमें चाहिए आपसे आइटम। सर देन ऑन पेज नंबर 17 ऑर्डर फॉर रविंदर सतिंदर एंड कंपनी। 18 जितेंद्र एंड कंपनी। Then sir on 19th we have appointment for CHA. Sir 20 number page. We have given the instructions to the transporter to the transporter. Yeah. Sir then on page number 21 instruction to Satinder and company to hand over our goods to Madhva and company. Then sir page number 22 is direction to Jitendra and company for handing over the goods to the Randhwa and company, our transporter. So page number 23. सर ये दूसरी मेल है जहाँ रंधवा एंड कंपनी को कहा गया है कि आप इन तीनों से जो गुड्स हैं आप ले लीजिए और जब आप गुड्स इनसे ले लें तो आप हमारे को इन्फॉर्म कर दीजिए। उसको भी इंस्ट्रक्शन दिया है सर ये। देन सर ऑन पेज नंबर 24 confirmation from Ravinder and company, goods are handed over. Then sir on page number 25 confirmation from Satinder and company. Page number 26 from Jitendra and company. Then on page number 27 there is a mail from our transporter which is a forwarded mail from the transporter's Chandigarh office. Then sir on page number 28 goods delivered to ICD TKD Delhi, sir. Sir, page number 29. Our CHA confirming the receipt of goods at TKD Tughlakabad.
So all these mails are there.
Yeah.
There are the allegations that in the appellate authority has mentioned that items are different in 3B of the suppliers.
Yes.
So whether in 3B HSN codes are mentioned and items are mentioned?
No.
So how this allegation is correct?
Because if the items are mentioned HSN code, maybe he was not required to mention HSN.
No, no, no. We are asking you that in 3B, because the allegation is that in 3B they are not mentioned.
Yes.
So whether in 3B those are mentioned?
The item is they purchased?
Yes.
No.
No. So it means this allegation is baseless?
Which allegation?
The allegation which has been framed against them and confirmed by the appellate authority also. They have the demands have been confirmed.
I'm saying, are you saying from where they have purchased or they have sold?
No, no.
3B of whom?
They are 3B.
No, no, I'm talking of the supplier 3B.
Okay. Supplier 3B also will not contain any HSN code or...
But they will have items?
No, no.
Wait, sir.
No. They come in GSTR 1 only, sir.
Yes, sir. 1 sec. We can read the order.
The one may mother code.
Doesn't matter, sir. It's a question of a fact. We can read the order.
Yes.
Adjudication order. This is on page 68. I will come on emails straight away. The taxpayer has filed a detailed reply to the above show cause notice 1225, which he has also personally heard in detail and with all the document evidence he was able to produce. When asked whether he would like to produce any other document in support of the claim made in the returns, the taxpayer said he would not like to produce any other evidence. So it's all these emails are, God knows what is this, we don't know. I have gone through
all these documents can be fabricated and can be brought today, but not the emails. We will accept that. So if the emails are there, so they are genuine.
Come on emails. This order is dated 8/2/25. Emails are 5 January 22.
Sir, that's the date of my transaction.
Wait. That means when the case was being heard on 5th February 25,
they were there.
the emails were always there with them. They were there.
That's what I'm saying. That they never produced all those documents at the time of assessment
I
before
said the
the
evidence
proper
can be produced. I have no objection to
Yeah,
that.
yeah.
We are coming on facts now.
Yeah.
Evidence and application, I have no issues.
No, my first question was regarding 3B. So what do you have to say regarding
Sir,
that?
I'm going to read this order.
Yeah, please.
Let's read the order.
Yeah.
Sir,
That
which
Page number
page you are
72.
reading? Sir, which page you are reading?
72 page
68.
number.
68. First adjudication order by the proper officer. I have gone through the records of all the investigation reports that were confronted to the taxpayer and the evidence produced that taxpayer in response to the above show cause notice carefully before passing adjudication order. I have also examined the legal provisions section 74 carefully and have also noticed the contentions of the taxpayer that provision section 74 cannot be invoked based on inaction, negligence or even fraud practiced by the supplier as alleged by the revenue in show cause notice that is 15/1/25. Whereas you are a trader and an exporter of tobacco products including pan masala. Whereas based on your returns for the period 21-22 and based on 0 rate transactions shown by you, you were sanctioned and given a cash refund of so and so amount. Simply based on your returns and your applications filed along with the documents. At the time of grant of refund, within statutory 60 days, you were put to notice that any adverse report received after verification of documents relating to input tax credit as per law will be initiated. Now reports have been received from investigation wing that your 3 main suppliers, so and so, were under investigation by the investigation wing of the department. It has been found that their certificates were cancelled retrospectively with effect from the date of registration, which in all cases in much prior to date of your transaction of 21-22. It has been found in documentary evidence and copy of the findings is enclosed with the stocker notice as Annexure A for your information that these three firms never opened their shops at the business premises, and landlord has denied having given these shops on rent to them, and above all at all their 3B returns it has been found that they have not purchased tobacco or pan masala products at all from any of the registered taxpayers. Hence, the entire reparation proceedings were based on fake documents. That's where the RC was cancelled.
Please read it again from and above all, their 3B returns.
All their 3B returns. Suppliers. 3B
Suppliers. So, it is found that they have not purchased tobacco
or pan masala products at all
so
from
that's
any
what
of
I'm saying. In how from 3B returns they have found that pan masala and tobacco has never been
report was
purchased.
shown to them. He's mentioned 3B. They must have done investigation.
No. That's what I'm saying. They are again and again, because appellate authority is also mentioning 3B.
Yes.
And this fellow adjudicating officer, proper officer is also mentioning
Let us say,
about
but this
3B.
is one allegation.
Yeah.
You may be right in this. I will take this point.
And my second, so this is there. My second question is, whether the allegation is regarding claim of ITC from the fake suppliers, number one. Non-export of goods out of India. I'm asking you that out of these, out of my questions, what do you support?
Yes.
And third is error in calculation of refund of GST.
No. First is their exports were admitted and refund was given. If the goods were not exported, refund would not have been given.
There was no error in calculation of refunds?
No, refund amount at that time, yes. That's why the refund was given.
And export was also admitted?
Obviously.
Correct.
Yes.
So now the question is ITC. So whether these proceedings are correct?
Yes.
No. Because these proceedings are in respect of refund.
No.
They are asking that refund back. Can these proceedings be initiated for refunds?
Section 74, yes. Yes. It can be. Why not? Erroneous refunds are no. I'll just read it. It can be. Why not? Where is the bar? If that cannot happen, the whole order goes straight away.
No. You see, आप SCN देखिए पहले आप.
But let's go section 74. It's erroneous refund given from the 5 years time. What is there?
लेकिन आपका जो SCN है वो क्या क्या है?
Sir, SCN भी है. चलने पर इसमें सब है. SCN adjudication order में है sir.
SCN is here action.
Sir, let's read the order, then we go back to SCN.
Okay.
Sir,
We'll read the order, sir.
On page 62.
We will read the order, sir. SCN also read. Correct. The reply filed by dealer falls short of the stringent test required for claim of input tax credit, so as in terms of section 155 of DVAT Act, with Supreme Court judgment DCOM Gill. The investigation reports, when examined independently by the undersigned, clearly go to prove the connivance or the collusion between the suppliers and the taxpayer. Name of the transporter is same for all three suppliers. All of them have raised bills on the same date. Even emails are at same time.
Sir, सब में difference है आप check करिए.
Wait, ma'am. Wait, you can counter later. All of them have raised bills on the same date, and all of them also prepared the e-way bill in the same time with few minutes here and there. And all the three have raised identical tax invoices and perhaps on the same computer, and all of them have bank accounts in the same bank, Punjab National Bank, Sector 17, Chandigarh. All have similar shortcomings of NHSN codes, and above all of them have failed to come for tendering their statements. They were never existing. These are findings. Even the transporters that were engaged by the taxpayer, they themselves, to bring back the material from the supplier are the same. I have considered the entire matter and tried to corroborate the evidence produced by taxpayer. I have also read the judgments of Milk, Food and Rice India carefully. While these judgments may be relevant, but these judgments did not consider Section 155 DGST Act that shifts onus on the taxpayer to prove his claim of physical receipt of goods by him to business preparation. The taxpayer has failed to satisfy how the suppliers have paid the tax to the government, whether in fact they have never purchased the item sold to the taxpayer, and how did they dispatch the goods that were physically received by the appellant is also unexplained so far. The reports collected by the Revenue Department were given to the appellant, who failed to satisfy. All the reports were not behind the back, they were given to the appellant. Hence, in view of the above, I am of the view that the input tax credit of so-and-so was fraudulently claimed by the taxpayer with an intention to evade tax, and hence the Joint Commissioner applies his mind before taking further call on merits. The issue is therefore decided against the taxpayer and remanded only on the simple issue of applying a first head rule. Copy with dim. The taxpayer directed to deposit 20 with interest so and so. It's ordered accordingly. This is Assistant Commissioner. Now let's go to show cause notice. You want to go?
So it's page 62.
Yeah. They have also filed reply. They cannot make a new case here. Show cause notice, Your Honor, page 62. Whereas based on your returns of so-and-so and based on zero transactions shown by you, you were sanctioned and given a cash refund of so-and-so. At the time of grant refund, within statutory date 60 days, you were put to notice that any adverse report received after verification of documents relating to input tax credit, the proceedings as per law will be initiated against you to recover the refund erroneously given. The refund was given to you on so-and-so. Now reports have come, received from the investigation wing. Your three main suppliers were under investigation by the investigation. This is the same thing which the written part record, Your Honor. So we can skip this. Yeah, I will pick up, no, we will read this. Last three lines of page 62. It has been found on documentary evidence, and copy of the findings is enclosed with the show cause notice as Annexure A for your information, that these three firms were never opened their shops at the business premises. The landlord has denied having given those shops on rent to them, and above all, their 3B returns has been found that they have not purchased tobacco or pan masala at all from any of the registered taxpayer. It could be an inference because the tobacco rates are with cess and everything. Tobacco is subject to cess also. So if 3B did not contain anything, there is no purchase of tobacco.
No, this is a presumption only. But
no, but this is also, of course it's a presumption, but this is also a fact. This has not been rebutted by them. Hence, the entire registration proceedings were based on fake documents. I have examined the matter in detail and come to prima facie conclusion that you were in collusion with these three firms, as all your purchases of these three products are from these three firms only, based on which you claimed input tax credit, even though you showed tax-paid exports on which you allegedly discharged your liability of IGST after adjusting the input tax credit from these three firms. Also, investigation wing of department sent them summons on Section 7T, but they never came for tendering the statements and produced their books of accounts. Based on the documents filed by you for receipt of goods from these three firms based on IGST payment, we sent summons to transporters whose lorry receipts were you produced, but these transporters never came forward, and when physically inspected their business premises, it is found that they were one-time transporters only with no regular business activity. Report of the inspector so-and-so. In view of the above, it is clear that you had obtained fake bills from the above three suppliers of so-and-so. The lorry receipt are fake, and neither the suppliers nor the transporters come forward to tender the statements in support of you, and the whole circumstantial evidence clearly suggests that there was a complete connivance and collusion between you and three suppliers. Hence, you are required to so-and-so. Then this show cause notice, you are therefore requested to file reply to this show cause notice. What were the questions which they have never answered? The complete shipping documents from customs, including physical inspection of goods, which is mandatory as per SOP of the custom department. It's not enclosed. The names of persons and their phone numbers with whom you dealt with, and their residential address. They have given phone number now in additional evidence without the address. the name of manager of the transport company, no name given. The bank certificate certifying whom payment was actually received, nothing. From the returns filed by these three firms, it has been found that the entire ITC claim by is not genuine, since there is no purchase of product sold to you from any source declared. It is not possible to infer that they ever paid tax to the government, more so when input tax credit is fake. Please note, in case you are not able to prove so and so, this was show cause notice, then this is the reply. They filed reply as well on page 65, Rashmi.
Yes, sir.
Reference show cause notice 15/1/25 under section 74, asking us to show cause why cash refund of so and so be not recovered back as interest and penalty based on investigation report received in show cause notice. Also, you have annexed some reports of fake documentation done by these three suppliers, landlord denying having given the declared premises on rent, and also the fact that they never opened their shops. Our reply is simple. Are we responsible for their conduct on the date when we purchase goods from their against tax invoices on which they charge the tax and the cess, and we paid them through banking channels? This is not denied. Also, there is no duty cast upon us to verify their business premises. These are the replies filed by the taxpayer, and they want relief. This is their questioning the law. Also, there is no duty cast upon us to verify their business premises on their whereabouts. They have sent the goods on ex-godown basis, and we duly paid the freight and also deposited the RCM on such freight as per books of accounts produced and returns filed on extract of which is enclosed in extra by so and so. Also, we made our stock entries based on goods received under so and so. We also settled their accounts to fulfill so and so. The entire export documents are also enclosed, shipping bill and bill of lading so and so. That the custom documents will be denied to you, which are never issued unless the entire export invoice, packing list and items are verified by the custom officials before let export orders issued by the custom department. There are a number of judgments on this issue. The negligence in this is the Milkwood judgment, we will skip it. Regarding transporters' names and addresses, this is their reply. Yes, the transporters were appointed by us, and they picked up the material from business premises of the above three taxpayers who are situated in and around Chandigarh. As the transaction are more than 2 years old, it seems the transport has been closed. They never existed. That finding has not been disturbed. That allegation is not even replied. Has closed due to some death of the family, and we are unable to give the required details as asked for by you in your show cause notice. How were these details given now? From where?
सर हमने
this is a book and bull story.
सर मैं कुछ बोलूं, हमने पुरानी मेल्स दी हैं सर, नया कोई एविडेंस नहीं लेकर आए.
तो ये तो आपका रिप्लाई है.
सर मेरा ही रिप्लाई है, उसी का उसमें बता रही हूँ कि हमने जो भी
आप कहते हो कि उसकी डेथ होगी.
Moreover, they have deposited RCM also. When they have deposited RCM, they must have raised invoices also. In those invoices, the details of transporter and that lorry was also mentioned.
So, my lord, with due respect, this is how the fake transactions are done. In circular trading, everything is 100% proof. 100%. You cannot find even iota of a difference between documentation in circular trading. This is nothing but a fake invoice case, circular trading. This is a reply filed by them. So,
without receiving the goods, they have exported the goods also. You mean to say that?
No, what I'm saying is what they have exported are not these goods which they purchased. Tobacco trade is unlike this. They pick a number to export it and then they buy the bill. It's a 40% item with cess. There are thousands of cases going on in the country on tobacco trade. That's why this case was made.
No, but we
But
have
simply because if they paid
we have
RCM,
produced their invoices also. They have purchased exactly the same number, and they have raised the
my lord,
packing list.
circular
And
trading is always back to back. That's the Supreme Court says circular trading back to back only. That means nothing. I will dig the records,
Anyhow.
but they are filed. We'll find out the mistakes there straight away.
okay, okay.
Also, regarding your direction to produce the suppliers for cross-examination, we submit you have all the powers under the Act to ensure they are present before you, and we shall cooperate fully. Hence, we request the above show cause notice be dropped. Then, personal hearing granted. As directed, he has produced books of account, 3B returns copies and lorry receipt with bank statements. However, he has been unable to show any satisfactory documentary evidence of goods having been received physically in the business premises from the three suppliers, or even their stock register do not show the name of suppliers. For such large transactions, even though for other similar transactions, the name of suppliers are shown, what could be more collusion? Things you have exported, you don't show in stock register. For 100 rupees you show. For crore rupees you don't show in the stock register. There's a complete investigation done to prove it's a case of circular trading. He has also not produced. Yes. However, he has been unable to show any
In
satisfactory
fact,
document.
even their stock registers do not show the names of suppliers.
हाँ आते हैं सर, बाकी के नाम लिखे हैं ना इसने, बाकी के नाम लिखे हैं सर, नहीं सर नाम भी लिखते हैं सर, आते हैं सर, बाकी के लिखे हैं ना इसने, बाकी के नाम इसमें लिखे हैं ना जी.
No. Even
बाकी के नाम लिखे हैं.
though other smaller transactions, the names of suppliers are shown. Here the allegation against you is
Yes, sir.
कि आपने सिर्फ इन 3 लोगों का नाम नहीं लिखा स्टॉक रजिस्टर्स में, और वेयरएज आपके स्टॉक रजिस्टर्स रिवील करते हैं कि आपने बाकी जो स्मॉल परचेजेस हैं उनमें सप्लायर्स का नाम भी लिखा हुआ है.
सर उनका भी लिखा हुआ है, वो शॉर्ट फॉर्म में लिखा है, वो मेरी बुक्स ऑफ अकाउंट मैंने दी हैं.
This is afterthought. This is
सर
not part of
आफ्टर
evidence.
थॉट नहीं है, आपके सारे आफ्टर थॉट नहीं है, मेरा सब आफ्टर थॉट है, ऐसा नहीं होता सर. रजिस्टर में है और उसका नाम जो है वो शॉर्ट फॉर्म में लिखा हुआ है, ऐसा बहुत बार हो जाता है. दूसरी चीज इन्होंने बोला कि बिजनेस प्रीमाइसेस में गुड्स आने चाहिए. सर मेरे बिजनेस प्रीमाइसेस में गुड्स आया ही नहीं है, मेरा तो गुड्स सीधा टिकट ही चला गया. तो सर मैं बिजनेस प्रीमाइसेस की रिसिप्ट कहाँ से दिखाऊं, जो है ही नहीं वो कहाँ से लाऊं?
वो तो आपके डॉक्यूमेंट सारा
सर
क्लियरली बोल रहे
मेरे से
हैं.
लैंडलैंड काउंसिल ये चाहते हैं कि मैं वो लाऊं जो है ही नहीं, वो कहाँ से लाऊं?
करेक्ट.
We don't let's read. I'll answer her question. This is absolutely no question to answer. There's no question to answer. Physical receipts has to be shown. I'm not saying business premises. TKD. Where the same good travel there, can they prove it? They cannot because the firm never existed. वो फॉर्म ही नहीं, मेरे माल कहाँ से आ गया उसके पास? ये कोई नहीं है कि मेरा वहां माल चला गया. अरे आप यू स्टिल हैव टू प्रूव. इट्स योर क्लेम, यू प्रूव. असेसिंग अथॉरिटी इज नॉट हैप्पी विद इट. आप आगे सुनिए वो क्या लिखता है. On the contrary, it has been found that the date on which the bank, he has also not produced bank certificates about the name of the importer who has made the actual payments. On the contrary, it has been found that the date on which the bank received the payment and the day on which bank's payment were entered in their books of accounts show a large gap of 15 days on an average. How could the taxpayer record payments 15 days in advance when in fact payments were received subsequently after 15 days? This is a finding. It's their books. 15 days. Further, the tax invoices produced show no items except tobacco products, whereas the exports are for various items including cigarettes, roasted tobacco. Now they produce invoice where roasted tobacco is also written. So they are fake documents they are produced. This is their record. I'm reading their record. They are produced. Now that invoices have been annexed where roasted tobacco is written. I've seen the invoices. This is a fake evidence being submitted in this tribunal. Still further, none of the invoices bear the signature of suppliers. Even now, it's not signed.
Sir, it's digitally signed.
Okay. So now they are signed. That means suppliers were existing.
Sir, it's digitally signed. आपके पास जो original है, जो हमने पहले दी
But
है,
I'm
वो
sure
भी.
the officer knows Rule 26 can be digitally
Sir,
signed.
how can I say that?
Then how can you
You
say
have
it's written
to,
wrong?
you have to ask question your
Anyway,
officer.
this is not a major thing for this. Regarding transported, the lorry receipts were shown to the taxpayer that bear no signature, and even the weight mentioned on lorry receipt and weight based on e-way bill show large variations. No HSN details are available. The e-way bill was issued at 11 p.m. from Chandigarh against 6 invoices from 3 suppliers dated 10/1/22, and surprisingly, the export documents were also made on 11/8/22, and in fact, the documents were filed on 11/2 itself. This evidence clinches the issue that there was no supply of goods at all, and the only fake billing was resorted to. How is it possible that goods that are coming by truck could reach so swiftly, and export documents with e-way bills were filed with the customs at 8 a.m. in the morning? There are no confirmation documents produced by taxpayer from any of the suppliers, nor the bank about the sender of payment into the bank, nor a confirmation letter from importers. All these facts were confronted to the taxpayer, and he said that in today's era of high tech, all such super efficiency is possible. But he failed to realize that what is involved is movement of trucks and physical receipt of goods, which is a sign-on kind of input as credit mechanism, which he has adjusted for his DGST payments. The taxpayer was asked if he has to say anything more or produce any other evidence in support of the claims made or for exports. He replied in the negative and quoted judgments of Arise India, Gherumal and other to say that he was not responsible for the conduct of suppliers, and hence his claims were legitimate and in due course of time. Further, the counsel has vehemently argued that provisions of section 73 or 74 cannot be invoked for the inaction so and so. This is Assistant Commissioner, right? So when you have such overwhelming evidence, now let's come to their emails. They are relying on emails. I think let's come on emails.
Sir, page number 11.
कह रहे थे रश्मि?
हाँ जी सर. सर वो बैंक की ईमेल्स हैं 11 पे और
नहीं, आपकी जो सप्लायर की ईमेल
सप्लायर की सर 15. ये सर बायर की है जिसने पुट्स एक्सपोर्ट किए हैं,
जिसको आपने एक्सपोर्ट किए हैं.
हाँ जी, उसका परचेज ऑर्डर है.
ये 5 जनवरी 22 को 4:29 शाम को आपको भाई.
हाँ जी.
ठीक है. ये कहते हैं कि मुझे सिगरेट और रोस्टेड टबाको चाहिए जो आपके बिलों में पहले नहीं लिखा था, अब आपने बिल लिखा जिसमें लिखा है.
सर हमने वही बिल लिए
थे.
कैसे ऑफिसर ने नहीं पढ़ा? ये
that's not acceptable. You can't put allegation against the officer. Make an application, call the officer, he will show the documents to you. Then
जी सर.
Then 5 जनवरी 22 को इन्होंने जी 4:29 पे शाम को इनको ईमेल मिली. इन्होंने उसी दिन 5:30 बजे आके परचेज ऑर्डर प्लेस कर दिया. ठीक है. सर वेट, आई वांट टू शो यू समथिंग. अभी दिखाती है ना सर आपको. अब इन्होंने क्या ऑर्डर प्लेस किया? सिगरेट्स, जो टेबल में लिखा है सिगरेट्स.
हाँ जी.
हाँ, हम तो वो घर भी बना सकते हैं, घर भी तो बनता है, क्या प्रॉब्लम है उसमें? ये सारे के सारे इन्होंने एक ही टाइम पे सारी ईमेल कर दी.
नहीं सर, डिफरेंस है.
5:29, 39, 49
जी.
So all emails are after 10 minutes of interval. That's not how business is done. That is not how business is done. And all emails have exact 10-minute difference. Exact. So when you create evidence, be careful that this is not doubted. मतलब मैंने देखा है कि हर ईमेल में एग्जैक्ट 10 मिनट का फर्क है. मेरे को मलिक साहब ने बोला था, हमारे मेंबर ट्रिब्यूनल, कि यू शुड बी ए क्रिमिनल लॉयर. ओपन ट्रिब्यूनल ने बोला था कि यू आर इन रॉन्ग प्लेस. Circumstantial evidence will finish your case. Nobody can give you relief on these documents. ठीक है, आगे चलिए. अब आप आगे आपने क्या किया?
सर CHE अपॉइंट किया 6 बजे.
ये कौन सा पेज है? ये 6 बजे आपने कर दिया।
सर मेरे को उसको जल्दी भेजना था, इसीलिए मेरे सारे
आपने माल
document-
भेजा है 10 तारीख को, कि जल्दी किस बात की थी आपको?
सर मेरे को ऑर्डर
माल
जल्दी
आपको
place
10
करना-
जनवरी को भेजा है, वो भी शाम को।
सर उससे पहले सीएचए को अपॉइंट करके मेरे को अपने एक्सपोर्ट के डॉक्यूमेंट्स पूरे कराने थे, जो कि एक नॉर्मल बिजनेस प्रैक्टिस है, इसलिए मुझे उसे अपॉइंट करना था।
वेरी गुड, वेरी गुड, वेरी गुड। अच्छा, ये कौन है रविंदर एंड कंपनी?
सर ये मेरा सप्लायर है।
और पहले आपने किसको भेजी थी? पहले रविंदर कंपनी लिखा था, उस रविंदर कंपनी ने आपको ईमेल भेजी है?
हाँ सर, वो मुझे भी भेजेगा ना बाद में।
नहीं, उसने तो, ये तो आपने भेजी है, डियर रविंदर।
सर यहाँ मैं जो पेज नंबर बताइए, मैं मेल बता रही
ये पेज नंबर 20 क्या है?
सर
बताइए।
यहाँ हमने उसको रविंदर को बोला है कि मेरे गुड्स जो हैं आप उसको दे देना, रंधवा एंड कंपनी को,
जो ट्रांसपोर्टर है।
हाँ जी, जब तक मैं उसे इंस्ट्रक्शन नहीं दूंगी वो गुड्स कैसे हैंड ओवर करेगा सर।
अच्छा,
इसीलिए 9
अच्छा,
तारीख
आप
को मैंने
इसमें भी सब 10 मिनट है। Your Honor, let us see their bills. If you see their,
सर यू आर चेकिंग सेल बिल पेज 35।
जो आपने अब इनके देखिए जरा, ये परचेज ऑर्डर, हाउ दिस इज फेक। जस्ट सी पेज नंबर 17. This is a lesson to learn by Rashimi Jain. Do you think this is not fake? Insert quantity. What quantity they are buying? उसने लिखा होगा फेक वाले ने कि क्वांटिटी लिख दियो यार, उन्होंने कहा छोड़ो यार, हम ऐसे भेज देते हैं बिल आगे। This is a shut case. They should be prosecuted for submitting fake evidence. और सब में है, मतलब सारा कुछ फेक है। जो पहले बिल थे, हमारा इन्वेस्टिगेशन हुआ, उसकी रिपोर्ट आई, ये एक्चुअली हाई कोर्ट केस है, उसके मैंने इसको बनाया था, लेकिन सारा कुछ ही फेक है। हाँ, मुझे मालूम है, इतना मुझे मालूम है सर। मैं तो इनके डॉक्यूमेंट से मेल निकाल रहा हूँ। अबे 2-3 घंटे बाद भेज देते यार, कोई डिस्कशन कर लेते, कोई कुछ हो जाता। वो सप्लायर को आप जानते ही नहीं, देवर अननोन टू यू, वो रैन अवे, भाग भूग गए, वो कभी थे ही नहीं, दुकानें नहीं खोली थी तंदर एंड कंपनी।
Rashmi ji, please come to page number 17.
जी सर।
This is your purchase order.
जी।
And it was sent on 5th January 2022
Yes.
at 5:39 p.m.
Yes.
Correct? So when you give an order to anyone, you have to mention the exact quantity. Specific.
Yes, sir.
Correct? That this is so much. And then you were in a hurry to export also. There was a target line, that's why you were doing everything in a haste. You were sending emails in 10 minutes intervals, and you appointed the transporters also, CHA also, so everything on the same day. But here, when we peruse this purchase order, preferred delivery date,
Nil.
insert date. What is the meaning of insert date?
बन के आया था, कहीं तो डाली नहीं, गलती की, बस और क्या।
Sir, actual
Rashmi, the serious mistake is more. There is no GST discussion here. ये टैक्स फ्री है माल।
टैक्सेबल है सर।
फिर कहाँ लिखा GST रेट इसमें?
एडिशनल सेस भी है।
कहाँ है? एडिशनल क्या मतलब? हाँ, तो इसमें तो लिखा ही नहीं आपने कुछ। एविडेंस देने से पहले 10 बारी देखनी चाहिए कोर्ट्स में। आपका जेन्युइन केस भी खराब हो गया।
Even total order value, insert amount. You have not mentioned the value also, that at what price you are going to buy. That is also not mentioned in this purchase order. Then again you are mentioning 50% advance and balance on delivery. Advance of what? Is there any amount mentioned in the entire purchase order?
Yes.
बन जाऊंगा अभी कौंसल, सारे वकील बन जाएंगे, मेरे को मरवा देंगे, मेरे को मरवा देंगे।
Same is on page number 18. This was for cigarettes.
Yes, sir.
And the next order is for your roasted tobacco. Sir, you had mentioned that they had never produced invoices for roasted
ये
tobacco.
प्रोड्यूस इनवॉइस और रोस्टेड टबैको था ही नहीं।
नहीं, पर ये परचेज ऑर्डर तो रोस्टेड टोबैको का ही है सर.
मैं तो जो इनवॉइसेस उस इन्वेस्टिगेशन में देखा उनकी रिपोर्ट है।
Okay.
उनकी रिपोर्ट दिखाई गई है इनको।
But again, this also carries the same mistakes.
It's all fabricated evidence. It's so clear. वो ईमेल बनाई जाती है सर्कुलर ट्रेडिंग में सर। वो अच्छे वकील नहीं मानते, बाकी तो मान लेते हैं उसको सारी ईमेल को। वो बंदे अवेलेबल ही नहीं है ही नहीं, उनको कभी दुकानें नहीं खोली इन्होंने वहां तक। दे आर मैन ऑफ स्ट्रॉ, भाग भुग गए। इन्होंने नंबर 2 में खेत के एक्सपोर्ट के रिफंड ले लिया, तो नाउ दे विल फेस प्रोसिक्यूशन आल्सो।
Sir, may I interrupt you? Sir, can we discuss my case first on question of law? We can discuss evidence later on. Question of law is there. I request you to discuss my question of law.
What question of law will do?
Sir, we haven't discussed question of law.
Question of law is not required when evidence is fake.
Sir, question of law तो पहले ही होगा ना?
No, question of law will come as the evidence is criteria. It's all fake evidence. Where is the question of law?
Sir, मेरी वो application approve हो गई थी.
कौन सी? नहीं वो application
Additional evidence की.
वो तो उसी को evidence को तो देख रहे हैं, आपकी सारी fake है.
ऐसे एविडेंस की एप्लीकेशन अप्रूव ना होती तो हम इतना टाइम इस का लगाते ही नहीं ट्रिब्यूनल का. हम जो आपने एविडेंसेस दिए हैं वही डिस्कस किए जा रहे
जी
हैं.
सर.
वो डिस्कस इसीलिए किए जा रहे हैं क्योंकि आपकी एप्लीकेशन अप्रूव हुई ना होती तो वहीं पे उसी समय केस शट हो जाता.
जी सर.
करेक्ट. और जब आपकी एप्लीकेशन अप्रूव हुई उसके बाद ही मालूम चल रहा है कि ये सारे डॉक्यूमेंट्स फेक हैं.
सर फेक नहीं है, टेक्निकल गलती है.
Well done, Rashimi Jain.
See page number 35. You are the page number. So there is written statistically clear quantity, HSN and everything.
No, that is on tax invoice, sir. It is, you are right that in tax invoice roasted tobacco is there. You mentioned that it is not there.
At least written quantity. But on
This quantity is in agreement with the shipping bill that I have checked. There is a difference of only 1 kilogram. That's it.
फेक ट्रांजैक्शन है ना. सर्कुलर ट्रेडिंग में सब कुछ ठीक होता है. इन्वेस्टिगेशन रिपोर्ट है कि रोस्टेड टबैको को बिल ही नहीं था. ये सारे बिल बाद में बनाए गए.
निश्चय ये तो जो ये इनवॉइस नंबर 35 है ये आपने अभी दिया है एडिशनल एविडेंस.
सर पहले से है
ये तो
पहले से है.
इन्वेस्टिगेशन रिपोर्ट वाज शोन टू देम कि देयर वर नो रोस्टेड टबैको बिल. आई हैव रेड द ऑर्डर. But in any case, this whole evidence is fake. What will invoice do? जो चीज आपने खरीदी नहीं, हमने बेच कैसे दी? परचेज ऑर्डर इन्होंने दी, हमने तो नहीं लगाए. Everything is fake. वो बंदे अवेलेबल ही नहीं है. There's the finding of collusion and connivance.
Besides these purchase orders and invoices,
Yes, sir.
the other charges which Mr. DR is mentioning, what do you say about those charges regarding transporters, regarding your payments?
सर मेरी पेमेंट्स पे कहीं भी क्वेश्चन नहीं आया है. वो पे
Difference.
सर वो 15 डेज का डिफरेंस है जो मैंने एक्सपोर्ट किया है उसके लिए. वो 15 डेज का डिफरेंस है जिसका पहले जो मेरे लर्निंग काउंसिल थे उन्होंने रिप्लाई नहीं दिया था. वो मैं अभी एडिशनल में लगाया है कि जो मेरे पास पेमेंट की एडवाइस आई थी कि मैंने वहाँ से दुबई से एडवाइस आया कि हमने आपको पेमेंट कर दिया है, तो हमने अपनी बुक्स में एंट्री कर ली पर हमारे पास नहीं आया. तो हमने एक अपने जो बैंकर्स के साथ कॉरेस्पॉन्डेंस किया कि मेरा पैसा आना चाहिए.
आपको अलाउ करता है अकाउंटिंग स्टैंडर्ड्स टू रिकॉग्नाइज रेवेन्यू विदाउट इन बैंक?
यस सर.
Does your accounting standard announce it as a chartered accountant?
यस सर.
No. It's not. No accounting standard can allow this. Payment है नहीं, आप उसको अपने इनकम बुक कर लेंगे. Honorable member can shed light on.
सर सर बैंक को डेबिट नहीं किया है मैंने. सर बैंक डेबिट नहीं हुआ है. जब मैंने अपने जो मेरा बायर है उसके अकाउंट के अंदर अपने उसको दिखाया है कि वो पैसा आ रहा है, बैंक में नहीं आया, तभी तो मैंने मेल फॉरवर्ड करी कि नहीं आया।
आपके
हाँ जी
सप्लायर को क्रेडिट होगा तो साइमल्टेनियसली डेबिट होगा बैंक, देयर इज नो अदर वे।
सर पेइंग स्लिप और उसका कॉन्सेप्ट हम लेके चलते हैं ना, रिकंसिलेशन में मैं लेके जाऊंगी।
नहीं, गलत करते हो, अकाउंटिंग स्टैंडर्ड डजंट परमिट इट।
और सर उसके बाद अभी मैंने रिसेंट में सर्टिफिकेट भी उसमें लगा दिया जो पहले नहीं दिया था कि यहाँ से आया। सर मेरी अकाउंटिंग गलती की वजह से क्या मेरा एक्सपोर्ट और आईटीसी गलत हो जाएगा? सर प्लीज, क्या मेरा अकाउंटिंग एंट्री से इनपुट गलत हो जाएगा? कैसे?
फेक है, आपके परचेज ऑर्डर सारे फेक हैं आपके, आपने माल खरीदा ही नहीं उनसे।
सर मेरी पेमेंट एंट्री से मेरा इनपुट नहीं जाता।
हर हालत में जाता है।
सर कौन सा सेक्शन कहता है?
You have to prove genuineness of transaction. Transaction includes purchase, sale and payment.
जी।
तीनों फेक हैं आपकी।
सर कोई भी चीज फेक नहीं है मेरी।
अरे परचेज में तो अभी ट्रिब्यूनल बोले सारा कुछ फेक है, आप कमाल कर रहे हैं। थोड़ा फेक है, बहुत ज्यादा फेक है। किसी इन्वेस्टिगेशन रिपोर्ट पे आपने एक पॉइंट नहीं लिखा कि क्यों उनकी रिपोर्ट गलत थी, आपको दिखाई नहीं थी।
सर जो
This is the training you are getting.
Yes,
You
sir.
did not read the orders.
सर मैंने ऑर्डर रीड किया है।
No.
जो पहले वाले
जो चीज़
काउंसिल
आपके
है
खिलाफ थी उसको आपको रिबट करना है।
सर, जो पहले वाला काउंसिल है उसकी लिखने की लैंग्वेज अच्छी नहीं है, वो अपने एविडेंस को
हम सारे होशियार हैं, पहले नालायक थे।
वो
तो मेरा भी एक
Rashmi ji, please
Yes,
come
sir.
to page number 26.
यस सर।
Confirmation of goods handed over to transporter.
हाँ जी सर।
Randhava and Company. So he's confirming that he has handed over the goods.
जी सर।
Do you agree?
यस सर।
Okay, good. Now this is to confirm that the consignment of insert item name.
सर ये मेरी टेक्निकल मिस्टेक है, मैंने अभी मान लिया है, इसको नहीं
fake. Whole documents were made now.
नहीं सर।
Now, my lords, on this, the honorable
Mr. Verma, we don't agree, we differ on this point that these are, documents have been made now. Because in emails, the time which you are mentioning again and again, 10-minute difference and all, that cannot be made today. So all these emails were sent in the month of January only. But at that point of time, whatever emails they have sent, they are erroneous. उसके अंदर बहुत इंपॉर्टेंट चीज़ें हैं जो कि मेंशन नहीं है। डेट एंड टाइम ऑफ हैंड ओवर वहाँ पे भी लिख रहे हैं इंसर्ट टाइम, करेक्ट? मतलब कहीं पे भी कुछ नहीं, आइटम इंसर्ट आइटम नेम, क्वांटिटी हैंडिंग ओवर का ईमेल जा रहा है, उसके अंदर आइटम नेम इंसर्ट नेम, क्वांटिटी इंसर्ट क्वांटिटी, ट्रांसपोर्टर का नाम क्योंकि रंधावा है तो उसका नाम आ गया है, टाइम insert time. There are too many mistakes. All these evidences are absolutely erroneous. Mistake can be in one particular email. एक जगह गलती हो गई, दो जगह गलती हो गई, आपने परचेज ऑर्डर्स बनाए तो गलत बनाए, आपने जो हैंडिंग ओवर आपका, और ये तो आप बता रहे हैं कि ये ईमेल तो आपकी तरफ से आया भी नहीं है।
सर ये उसकी तरफ से आया है।
यस, तो जो गलतियां आप कर रहे हैं वही आदमी वो भी कर रहा है गलतियां।
सर एक ही मैंने देखे, एक ही कंप्यूटर पे बनी है, एक ही फॉन्ट है। अगर फोरेंसिक ऑडिट में ले जाए तो और बहुत प्रॉब्लम खड़ी हो जाएगी बहुत।
So let's dismiss this appeal and department may initiate prosecution if required.
Well, I think wait for 5 minutes. Lunch can wait. We are not come for eat food. What does this case teach us? Forget this case is over. Again, I told you, never fabricate evidence. चोरी के चोरों के पाँव नहीं होते, चोरी पकड़ी जाएगी आपकी. If this was a case in High Court, her client should have been in jail by now. I guarantee you, if I were the government counsel, I would have ensured they could face jail. These are all fabricated evidence. Because investigation reports, copies were given to them with documents. 7 annexures were given. A counsel saying that my earlier counsel was a nut, that's not done. You can never abuse a counsel. All of us are capable or incapable according to what we do. A past counsel should never be referred to in your life. Because you are alienating your professional colleague. That way what you have done, if next time I'll come, I'll file an affair against you. We lawyers are not immune from prosecution. You cannot be a party to create this kind of fake evidence. This entire evidence was fake. Because when they were given show cause notice, or they were heard, they were given all annexures, what is the investigation report. The entire copy was given to them, where these findings were against them. Now they wanted to rebut those findings by creating these kind of documents. Honorable Tribunal wanted to give them relief. Let me tell you, they were inclined to give relief. But only when this evidence was shown, their conscience said, no, this is too much. And now this certificate, goods handover to whom? Ecom girl says you have to see kisko goods handover kiye gaye the. Unless you read full judgment, its imports you can never understand. So no, don't do AI and Google this paragraph बकवासबाजी बिल्कुल मत करो. जो जजमेंट आपको रिलाई करनी उसको सारा पढ़ो, फिर उसकी एविडेंस बनाओ. Emails are of no consequence. I can give you Supreme Court ruling. WhatsApp is of no consequence. It's not a piece of evidence. और सर्कुलर रीडिंग में तो सब कुछ ठीक होता है. तुमने यहाँ भी गलत कर दिया. हाँ जी? नहीं रिलीफ तो नहीं. Honorable judges were initially inclined. Then I thought, okay, wait, let's read. And they had fully read, but they had not seen the evidence. अगर ये evidence नहीं लिखाती तो relief मिल जाता इसको. शायद मिल जाता. Anyway, thank you. Let's go for हाँ जी. बैठो भाई एक मिनट. मैंने एक्सपोर्ट फेक बोला ही नहीं. एक्सपोर्ट तो एडमिट किया हमने. मैंने किया ही नहीं. एक्सपोर्ट तो हमने एडमिट किया है.
नो ऐसा है. आपने शायद सुना नहीं. मैंने भी क्वेश्चन इनसे यही पोज किया था. मैंने ओरिजिनली यही क्वेश्चन इनसे पोज किए थे कि वेदर यू चैलेंज द एक्सपोर्ट्स आल्सो. ही सेड नो. मैं कहा when exports are genuine, then the goods must have been purchased. His answer was, these are not the same goods which have been exported and which have been purchased.
Friends, we will be back after half an hour.
I request SP sir to please come on this stage. SP sir, please.
Friends, we will be back after half an hour. Please come fast.
Well, friends, there are more than 100 people expected to join us. But our chairman, Mr. Canelo, has to go in Parliament to the meeting with the Prime Minister, so he has to be there. I didn't expect he'll come at 9:30, but he called me. He's coming at 9:30. For this group today, the first hour is very emotional. There is no legal discussion here. What you are going to experience, it may be the first time in the history of this country. What you are going to witness today, you may have never ever witnessed in your life. Maybe you will never witness again. As I rise today to speak, my legs are shaking. My language may falter. I'm short of words. Because a person I'm going to describe you today, he cannot be described in words. We call him a living legend, Mr. Rashimi Jain. What we are doing today is not a show of business, nor he requires any marketing. But as a group, as per our ethos, as per advice of our chairman, we want younger generation to have a sense of gratitude to people who have mentored them, who have taught them, who have, imprisoned us in their love, in their honor, and they have seen us grow. Many of us have lived under his umbrella, which is very big heart he has. Therefore, let's stand up and welcome Shri S.K. Bhatia sir. Yes, friends, today I speak about Shri S.K. Bhatia sir, who has been a teacher, guru, mentor for all of us for the last 5 decades. I've been a student in a college. At that time, we were students, we didn't care much. But when I also have put into this practice accidentally, I never wanted to be a lawyer. And then I realized what I am up to. I may not have expressed my feelings to him ever out of egos or out of ignorance. But today when I look back and see what this man has done for this tax community, for all of us, is something I will tell you, it is beyond imagination. This group is his creation. Along with his friend, my best friend, his best buddy, Raj Batra, we created this group. And Mr. Bhatia's mandate to all of us was to continue the education spread and train youngsters without any discrimination. That is, without discriminating between advocates, chartered accountants, company secretaries, or other professionals. And we tell you, sir, we have continued. Sorry. As a person, as a group, there is no prize or award or praise that we can give him to resonate with his contribution in our lives. Still, the core team of this group, headed by Shri Parveen Khandelwal, under his guidance, have risked our choice to celebrate your personal, professional, and social life. I know, we all know endless cases in our bar for last 5 decades where your efforts helped save lives of people. If you come to know that somebody has a cancer or a kidney failure, he took the lead, collected lakhs of rupees, ensured the person was saved. Whether he was to go to Bombay or Calcutta for anywhere for treatment, we were directed to help them. And we all together in Sales Tax Bar helped his efforts. And our kids, at least my kids, they have grown with his name. My daughter Sheetal was mentored by him for last 10, 11 years in the beginning, where he gave, without ever meeting her, on every Diwali, some gold piece of gift that she still has intact. That is the life which he has created. That's what we all should learn. After 20 years, people should talk about us like this. Yes, we are Mr. S.C. Bhatia's legacy, and we shall continue it with more vigor and more effort. As professionals, we learn the legal principles which English people gave us, common law jurisprudence. But in S.C. Bhatia, we learned life's jurisprudence. What is life about? He is not a man who is like us, who shows off, who drives fancy cars or wears designer clothes, watches, or shows off his money or shows off his knowledge. His humility, his humbleness, his kindness is par excellence. I have not experienced a person in my whole life, including my own family, who has been so kind and lovable, even to people who in politics were his opposition. He has never discriminated. The second person I know in this is Mr. Parveen Khandelwal, who comes here and guides us every time out of whatever time he can take off for us. You know, even for this Moot tribunal, I'm sharing something very personal. He goes to Chitrakoot. He's a very avid worshipper of Lord Ram. He told me, send me files. I would like to spend time reading files in Chitrakoot so that we can guide people. That is the passion this man has for all of us. Such passion, zeal, and perseverance is the rarest of rare that he is teaching all of us. Sir, a very big salute to you. For teaching us commitment and passion and profession in law. His integrity, I have lived with. That's why I tell with pride, I don't bribe people ever. This I've learned from him. Life doesn't give you guarantees. Don't expect. You cannot stop a flow of the river. That will be unnatural. But what life teaches you is, get ready for the storms which you can't see. Subtle love, passion. He taught us, work hard, you can do it. And here I am in front of you, I have done it. I feel very proud of you, sir. We were under your mentorship. You know, we have Mr. Praveen Khandelwal, our chairman. I spoke to him early morning around 6 o'clock, around a week ago, we want to do this. He also choked. This is one of the best ideas you're going to circulate in the country. Our seniors we must feel grateful to them. And he told me that you do it so very well that people cherish this memory forever. And sir, I think we are doing that way. And to celebrate this day, our team has constructed some utility backpacks. Can you show this bag on screen, please? When you carry this bag, see the message in the front. The same message which you have here. You know, when you carry Hanuman Chalisa, Ramchari Chalisa in your pocket, so when you carry this bag, this man's blessings shall be with you forever. Never ever lose this bag. This is not a money question. It carries emotions of hundreds of professionals who designed it. And together we all of us, we are going to give Shri Rashimi Bhatia a Lifetime Achievement Award from, and he deserves a standing ovation. The clap should deafen his ears. Let's continue to clap for him. And this is the message I would like to give to all the youngsters. Try to follow this path. Hard work is difficult. It will last very long till end. I am 69. He is approaching 80. Our hard work has not let us down. We have made more money than most of the people who bribe. At least I have made much more money. And that's hard work. And that's what we want to teach from this group. The ethos, passion and knowledge. This group will continue, and we have a clear direction from our chairman, Mr. Khandelwal, that this tribunals of this work must never stop, come what may. That's the message Mr. Khandelwal has given us. So, Rashimi Bhatia sir, we all bow down before you today for all, and we love you. Thank you.
I recall my days 31 years ago when I was posted as Additional Commissioner Sales Tax. But there were few people whom I used to lean on. When he told me that it is to facilitate Mr. H.C. Bhatia, I couldn't stop myself. In that respect, ये हमारे भी गुरु हुए.
I request Prakash Kumar ji to come.
Thank you very much, DGST team, to invite me, especially Mr. Verma. when he told me that it is to facilitate Mr. H.C. Bhatia, I couldn't stop myself. The way lots of people came and told about that he was their teacher or mentor, I recall my days 31 years ago when I was posted as Additional Commissioner Sales Tax before VAT. And that's what many of you may not be knowing, because my association after 98 was not there with the department. So I was in GST, and from that is much, much later. When I joined, I didn't know much about tax. And I had to dispose of appeals, first appeal, which was at that time 5 lakhs and above. And I was the only appellate authority. Though I had a very good person to assist me, but there were few people whom I used to lean on, especially to understand the nuances of law. Especially how do you distinguish what the honorable judges of High Court or Supreme Court has said. And it was Mr. Bhatia and also Mr. Batra, late Mr. Batra, who used to help us, help me personally. So in that respect, ये हमारे भी गुरु हुए, और आपका बहुत बहुत धन्यवाद. Not only that, in fact, our late Mr. B.P. Misra, he was commissioner at that time. Whenever he had to discuss some important case filed against the department, though he was not our lawyer, he was not our counsel, the only person he used to rely on was Mr. Bhatia. So thank you, Mr. Bhatia, for helping us, especially me when I was a completely newbie to tax. And thanks to that, 4 years there, most of my orders were upheld by tribunal at that time. So thanks again, Mr. Bhatia. आपका बहुत बहुत शुक्र. I recall my day.
I request SV sir to please come on this stage. SV sir, please.
Well, friends, there are more than 100 people expected to join us, but our chairman, Mr. Kandelwal, has to go in Parliament. It's a meeting fixed by Prime Minister, so he has to be there. I didn't expect he'll come at 9:30, but he called me. He's coming at 9:30. For this group today, the first hour is very emotional. There is no legal discussion here. What you are going to experience, it may be the first time in the history of this country. What you are going to witness today, you may have never ever witnessed in your life. Maybe you will never witness again. As I rise today to speak, my legs are shaking. My language may falter. I'm short of words. Because a person I'm going to describe you today, he cannot be described in words. We call him a living legend, Mr. H.C. Bhatia. What we are doing today is not a show of business, nor he requires any marketing. But as a group, as per our ethos, as per advice of our chairman, we want younger generation to have a sense of gratitude to people who have mentored them, who have taught them, who have, imprisoned us in their love, in their honor, and they have seen us grow. Many of us have lived under his umbrella, which is very big heart he has. Therefore, let's stand up and welcome Shri H.C. Bhatia sir. Yes, friends, today I speak about Shri H.C. Bhatia sir, who has been a teacher, guru, mentor for all of us for the last 5 decades. I've been his student in a college. At that time, we were students, we didn't care much. But when I also have put into this practice accidentally, I never wanted to be a lawyer. And then I realized what I am up to. I may not have expressed my feelings to him ever out of egos or out of ignorance. But today when I look back and see what this man has done for this tax community, for all of us, is something I will tell you, it is beyond imagination. This group is his creation. Along with his friend, my best friend, his best buddy, Raj Batra, we created this group. And Mr. Bhatia's mandate to all of us was to continue the education spread and train youngsters without any discrimination. That is, without discriminating between advocates, chartered accountants, company secretaries, or other professionals. And we tell you, sir, we have continued. Sorry. As a person, as a group, there is no prize or award or praise that we can give him to resonate with his contribution in our lives. Still, the core team of this group, headed by Shri Parveen Khandelwal, under his guidance, have risked our choice to celebrate your personal, professional, and social life. I know, we all know endless cases in our bar for last 5 decades where your efforts helped save lives of people. If you come to know that somebody has a cancer or a kidney failure, he took the lead, collected lakhs of rupees, ensured the person was saved. Whether he was to go to Bombay or Calcutta for anywhere for treatment, we were directed to help them. And we all together in Sales Tax Bar helped his efforts. And our kids, at least my kids, they have grown with his name. My daughter Sheetal was mentored by him for last 10, 11 years in the beginning, where he gave, without ever meeting her, on every Diwali, some gold piece of gift that she still has intact. That is the life which he has created. That's what we all should learn. After 20 years, people should talk about us like this. Okay, yes, we are Mr. S.C. Bhatia's legacy, and we shall continue it with more vigor and more effort. As professionals, we learn the legal principles which English people gave us, common law jurisprudence. But in S.C. Bhatia, we learned life's jurisprudence. What is life about? He is not a man who is like us, who shows off, who drives fancy cars or wear designer clothes, watches, or shows off his money or shows off his knowledge. His humility, his humbleness, his kindness is par excellence. I have not experienced a person in my whole life, including my own family, who has been so kind and lovable, even to people who in politics were his opposition. He has never discriminated. The second person I know in this is Mr. Parveen Khandelwal, who comes here and guides us every time out of whatever time he can take off for us. You know, even for this Moot tribunal, I'm sharing something very personal. He goes to Chitrakoot. He's a very avid worshipper of Lord Ram. He told me, send me files. I would like to spend time reading files in Chitrakoot so that we can guide people. That is the passion this man has for all of us. Such passion, zeal, and perseverance is the rarest of rare that he is teaching all of us. Sir, a very big salute to you. For teaching us commitment and passion and profession in law. His integrity, I have lived with. That's why I tell with pride, I don't bribe people ever. This I've learned from him. Life doesn't give you guarantees. Don't expect. You cannot stop a flow of the river. That will be unnatural. But what life teaches you is get ready for the storms which you can't see. Subtle love, passion. He taught us work hard, you can do it. And here I am in front of you, I have done it. I feel very proud of you, sir. We were under your mentorship. You know, we have Mr. Praveen Khandelwal, our chairman. I spoke to him early morning around 6 o'clock, around a week ago, we want to do this. He also choked. That this is one of the best ideas you're going to circulate in the country. Our seniors we must feel grateful to them. And he told me that you do it so very well that people cherish this memory forever. And sir, I think we are doing that way. And to celebrate this day, our team has constructed some utility backpacks. Can you show this bag on screen, please? When you carry this bag, see the message in the front. The same message which you have here. You know, when you carry Hanuman Chalisa, Ramchari Chalisa in your pocket, so when you carry this bag, this man's blessings shall be with you forever. Never ever lose this bag. This is not a money question. It carries emotions of hundreds of professionals who designed it. And together we all of us, we are going to give Shri R.C. Bhatia a Lifetime Achievement Award from, and he deserves a standing ovation. The clap should deafen his ears. Let's continue to clap for him. And this is the message I would like to give to all the youngsters. Try to follow this path. Hard work is difficult. It will last very long till end. I am 69. He is approaching 80. Our hard work has not let us down. We have made more money than most of the people who bribe. At least I have made much more money. And that's hard work. And that's what we want to teach from this group. The ethos, passion and knowledge. This group will continue, and we have a clear direction from our chairman, Mr. Khandelwal, that this tribunals of this work must never stop, come what may. That's the message Mr. Khandelwal has given us. So, S.C. Bhatia sir, we all bow down before you today for all, and we love you. Thank you.
I request SV sir to please come on this stage. SV sir, please.
Well, friends, there are more than 100 people expected to join us, but our chairman, Mr. Khandelwal, has to go in Parliament to the meeting with the Prime Minister, so he has to be there. I didn't expect he'll come at 9:30, but he called me, he's coming at 9:30. For this group today, the first hour is very emotional. There is no legal discussion here. What you are going to experience, it may be the first time in the history of this country. What you are going to witness today, you may have never ever witnessed in your life. Maybe you will never witness again. As I rise today to speak, my legs are shaking. My language may falter. I'm short of words. Because a person I'm going to describe you today, he cannot be described in words. We call him a living legend, Mr. S.C. Bhatia. What we are doing today is not a show of business, nor he requires any marketing. But as a group, as per our ethos, as per advice of our chairman, we want younger generation to have a sense of gratitude to people who have mentored them, who have taught them, who have, imprisoned us in their love, in their honor, and they have seen us grow. Many of us have lived under his umbrella, which is very big heart he has. Therefore, let's stand up and welcome Shri S.C. Bhatia sir. Yes, friends, today I speak about Shri S.C. Bhatia sir, who has been a teacher, guru, mentor for all of us for the last 5 decades. I've been a student in a college. At that time, we were students, we didn't care much. But when I also happened to join this practice accidentally, I never wanted to be a lawyer. And then I realized what I am up to. I may not have expressed my feelings to him ever out of egos or out of ignorance. But today when I look back and see what this man has done for this tax community, for all of us, is something I will tell you, it is beyond imagination. This group is his creation. Along with his friend, my best friend, his best buddy, Raj Batra, we created this group. And Mr. Bhatia's mandate to all of us was to continue the education spread and train youngsters without any discrimination. That is, without discriminating between advocates, chartered accountants, company secretaries, or other professionals. And we tell you, sir, we have continued. Sorry. As a person, as a group, there is no prize or award or praise that we can give him to resonate with his contribution in our lives. Still, the core team of this group, headed by Shri Parmeen Khandelwal, under his guidance, have risked our choice to celebrate your personal, professional, and social life. I know, we all know, endless cases in our bar for last 5 decades, where your efforts helped save lives of people. If you come to know that somebody has a cancer or a kidney failure, he took the lead, collected lakhs of rupees, ensured the person was saved. Whether he was to go to Bombay or Calcutta for anywhere for treatment, we were directed to help them. And we all together in Sales Tax Bar helped his efforts. And our kids, at least my kids, they have grown with his name. My daughter Sheetal was mentored by him for last 10, 11 years in the beginning, where he gave, without ever meeting her, on every Diwali, some gold piece of gift that she still has intact. That is the life which he has created. That's what we all should learn. After 20 years, people should talk about us like this. Yes, we are Ms. Rashimi Bhatia's legacy, and we shall continue it with more vigor and more effort. As professionals, we learn the legal principles which English people gave us, common law jurisprudence. But in Rashimi Bhatia, we learned life's jurisprudence. What is life about? He is not a man who is like us, who shows off, who drives fancy cars or wear designer clothes, watches, or shows off his money or shows off his knowledge. His humility, his humbleness, his kindness is par excellence. I have not experienced a person in my whole life, including my own family, who has been so kind and lovable, even to people who in politics were his opposition. He has never discriminated. The second person I know in this is Mr. Parveen Khandelwal, who comes here and guides us every time out of whatever time he can take off for us. You know, even for this Moot tribunal, I'm sharing something very personal. He goes to Chitrakoot. He's a very avid worshipper of Lord Ram. He told me, send me files. I would like to spend time reading files in Chitrakoot so that we can guide people. That is the passion this man has for all of us. Such passion, zeal, and perseverance is rarest of rare that he is teaching all of us. Sir, a very big salute to you. For teaching us commitment and passion and profession in law. His integrity, I have lived with. That's why I tell with pride, I don't bribe people ever. This I've learned from him. Life doesn't give you guarantees. Don't expect. You cannot stop a flow of the river. That will be unnatural. But what life teaches you is get ready for the storms which you can't see. Subtle love, passion. He taught us work hard. You can do it. And here I am in front of you. I have done it. I feel very proud of you, sir. We were under your mentorship. You know, we have Mr. Parveen Khandelwal, our chairman. I spoke to him early morning around 6 o'clock, around a week ago, we want to do this. He also choked. This is one of the best ideas you're going to circulate in the country. Our seniors we must feel grateful to them. And he told me that you do it so very well that people cherish this memory forever. And sir, I think we are doing that way. And to celebrate this day, our team has constructed some utility backpacks. Can you show this bag on screen, please? When you carry this bag, see the message in the front. The same message would you have here. You know, when you carry Hanuman Chalisa, Ramchari Chalisa in your pocket, so when you carry this bag, this man's blessings shall be with you forever. Never ever lose this bag. This is not a money question. It carries emotions of hundreds of professionals who designed it. And together we all of us, we are going to give Shri Rashimi Bhatia a Lifetime Achievement Award and he deserves a standing ovation. The clap should deafen his ears. Let's continue to clap for him. And this is the message I would like to give to all the youngsters. Try to follow this path. Hard work is difficult. It will last very long till end. I am 69. He is approaching 80. Our hard work has not let us down. We have made more money than most of the people who bribe. At least I have made much more money. And that's hard work. And that's what we want to teach from this group. The ethos, passion and knowledge.
वो परिवार हमेशा समृद्ध होता है जो अपने बड़ों का आदर करता है। लेकिन ये पहली बार देख रहा हूं कि एडवोकेट या चार्टर्ड अकाउंटेंट या प्रोफेशनल्स अपने परिवार के बड़ों का सम्मान कर रहे हैं। सुशील जी जीवन के उन सारे मापदंडों पर खरे उतरते हैं जिन मापदंडों के आधार पर आप सम्मान पूर्वक जीवन जी सकते हैं। लेकिन वो शिक्षक, वो पिता उस समय प्रसन्न होता है जब उसको दिखाई देता है कि मैंने जीवन में जो कुछ दिया वो किसी के काम आया।
So people like S.C. Bhatia are God's messengers for us.
आज के इस बहुत ही शिष्ट और विशिष्ट कार्यक्रम में
सर ये भी वैसे चल गया।
सर यहाँ आ गए जी। जहाँ हमने भारतीय परंपरा को जीवित होते देखा है, हमारे परिवार के मुखिया आदरणीय श्री H.C. भाटिया जी का सम्मान हुआ। वो परिवार हमेशा समृद्ध होता है
Members who are outside the gate, please come inside.
स्पेशल काउंसिल जैसे ही होता था 16-17 केस किए थे डिपार्टमेंट के, आते नहीं थे वहाँ जहाँ लगा नीता वाली मेरे खिलाफ होती थी तब भी स्टे में 30%, 35%, 40%। पहले को बोलते नहीं थे, हम तो बिना बोले रहेंगे नहीं, पैसे तो मैं लेता नहीं था। 1 रुपए थी मेरी फीस एक पर।
Welcome back after the post-lunch session. Next item number is item number 3, Ahuja Enterprises. Sorry, item number 4, Ahuja Enterprises. Our youngest advocate against his first ever appeal independently. He deserves a round of applause. The question he has raised is about 180 days payment issue. Admittedly, the payment not made within the statutory time of 180 days and the appellant directed to reverse the ITC. He has made out a strong case of interpretation of law and has prayed that the tribunal to hold on the proceedings till the High Court of Delhi decided the matter which is pending. A very innovative approach to appellate jurisprudence and for all of us to learn. Please welcome Tanishq Ahuja.
He is better than his father, I guarantee you that.
Please, Your Honours.
Yes.
Jonas, may I start? John. Hello. Hello. Your Honor, today, the appellant today came before to the tribunal against the order passed under by the learned Joint Commissioner of Appeals. The main issue in my appeal was the order. The proper officer passed an order on 5/1/2025 stating that I have not paid. I have made a payment of rupees 20 lakhs. I have purchased a goods of rupees 20 lakhs, but I have not made the payment within 180 days. Your Honor, may I please state that I have also applied an agreement of a contract of payment, which is at page number 20. If my Your Honor, please come to page number 20. On page number 20, at point number 4 of the contract, this is a contract between a buyer and seller, basically me and a party. The point number 4 says that buyer shall make the full payment of the purchase price to the seller at the end of financial year. And this contract was made on 1st day of April 2023. Then obviously my obligation to make the payment was after 180 days. Now may I request your honors to please read the section 16, proviso of section 16. May I start? The proviso says that provided further that where a recipient fail to pay to the supplier of goods or services of both other than the supplier on the which the tax is payable on reserve charge basis, the amount towards the value of such supply along with taxable thereon within a period of 180 days from the date of invoice of the suppliers, an amount equal to the input tax credit availed by the recipient shall be paid in such a manner may prescribed. Your Honor, there is written a word fail to pay. Now, I would like to state that what is the meaning of the word fail to pay? Fail is not like I have an obligation of paying within 150 days and I don't make a payment within 150 days. That is a fail to pay. Fail to pay comes into play when there is an obligation over him. In my case, there is no obligation of paying within 180 days. My contractual obligation is after 180 days. Then how can the department says I have failed to pay my reversal? Then how I am supposed to reverse that credit, ITC? Your Honor, there is a judgment. There are few judgments of Karnataka High Court and many others which states the meaning of the failure. Failure means that there is an omission on the part of the person to do something which is possible for him to do. Now, if in my case, if you see, my possible to make a payment was after financial year.
Mr. Tanishq, we have gone through your agreement also, and we understand what you are trying to say, that you are strictly abiding by the contract which was executed
Yes, Your
between
Honor.
your vendor and your appellant.
Yes, Your Honor.
Correct? But I would like to draw your attention on section 16(2) read with rule 37.
Yes, sir. Yes, Your Honor. Not section 16(2), notwithstanding anything contained in this section, no registered person shall be entitled to credit of any input tax in respect of any supply of goods or services or both to him, unless A. He is in possession of tax invoice or debit note issued to a supplier registered under this act. Second, clause AA, the detail of the invoice or debit note referred in clause A has been furnished by the supplier in the statement of outward supplies, and such details have been communicated to the recipient of such invoice and debit note in the manner of specified under Rule 27. On clause B, he has received the goods or service of both. Explanation: for this purpose of this clause, it shall be deemed that the registered purpose has received the goods, or the case may be services, where the goods are delivered by the supplier to a recipient or any other person, the direction of such registered person whether acting as an agent or otherwise, before or during the movement of goods, either by way of transfer of documents or title of goods. And second is where the service are provided by the supplier to any person in the direction of and the account of such registered person. BA says that the detail of ITC is in respect of said supply communication to such registered person under section 38. And the last is C and D are C is subject to provision of section 41. The tax charged in the receipt of such supply has been actually paid to the government, either in cash or through utilization of ITC. And last is he has furnished his return under section 39. Your Honor, I would like to say that Rule 37. Reversal of ITC in the case of non-payment of consideration. It is a heading. A registered person who has availed the ITC on an inward supply of goods or service or both, other than the supplies of which tax is payable on reverse charge basis, but fails to pay to the supplier thereon, the amount towards the value of such supply, whether wholly or partly, along with the tax payable thereon within the time limit specified in the second proviso. To subsection 2 of section 16 shall pay or reverse an amount equal to the input tax credit availed in respect of such supply, proportionate to the amount not paid to the supplier, along with interest payable thereon under section 15, while furnishing the return in form GSTR 3B for the tax period immediately following the period of 180 days from the date of issue of invoice. Your Honor, there always is stated that there is a fail to payment. And on the other hand, I would like... makes the payment of amount towards the value of such supply along with tax payable thereon.
Whether this input credit is ever denied to you?
No, it was never.
It is. Why it is deferred? What is the intention of deferring it?
So they can basically take and then they can avail it, let it back to us.
We'll like to seek views of DR, then I'll come to you.
My lords, first of all, we should know input tax credit is a concession given by state. Yes. It's not a fundamental right, nor is it an absolute right. It's a statutory right given by. So what I'm saying is ITC is a concession given to you by the state, and they can regulate the same. When you read 16.2, only as a only. Now, when you go to 16.2, sir, it starts with notwithstanding. Notwithstanding is a non-substantive clause, that is, any benefit given to you in any other provision of the Act, this will overrule. Therefore, and especially when they added a proviso, the function of a proviso which explains the main provision, right? So therefore, it is not subject to any other agreement to the contrary.
But my learned friend, I would like to say we are relying on the section only. But in our section, each word can change the meaning of the section. And if you see the word failure to pay, that will only apply to me when I have an obligation. It is not.
We can. What I'm telling you, whether the ITC has been denied to you permanently?
No.
No,
No, Your Honor.
right?
But interest is charged on that.
Why interest is charged? Why? See, what is the intention of the legislature?
The intention
that when a sale is made, irrespective of the fact that I receive the payment or not, I ought to pay tax in the subsequent month before 20th, right? And the government gets the money. In lieu thereof, you get the ITC. Now you have availed the ITC without making the payment to the supplier.
Yes, Your Honor.
right?
But
For any law, the states are empowered to frame rules and procedures.
I will come to that.
How are they relevant? How the Article 14 is applicable here?
I will come to all of that. See, whenever, first of all, I will come to DPSP. Whenever an act is made, you have to, the state or the legislature. Act is made. But
How is Article 14 invoked here?
right to equality is challenged, my.
Not equality is applicable to all the dealers, not to you alone.
But it is not. It is applicable to those dealers who are making.
Obviously, with the class of dealers, so the Article 14 is not hit. How the Article 19 one? Is it the state of trade?
Right. Article 19(1)(2) grants me right to profession or anything. I have my right to trade, but there are many kinds of business which have credit period of one over than 1 month.
You are quoting some things in your appeal. You must be aware, you must be responsible for whatever you are mentioning.
Yes, Your Honors.
You are mentioning that it is violative of Article 14.
Yes, Your Honors.
Article 19(1).
Yes, Your Honors.
Learned DR has explained you.
But Your Honors, if I would like to bring one thing into this.
Number one. Number two, as I've told you that for administrating any provisions of any law, the states are fully empowered to frame rules and procedures, and henceforth the provisions of section 16 subsection 2 envisages as under. As per section 16(2) CGST Act, a registered person can claim an input tax credit on goods and or services received from supplier.
Yes, Your Honors.
This is subject to condition that the taxpayer has paid for the goods and services and tax payable on them within 180 days of the issue of invoice.
Yes, Your Honors.
However, in case of non-payment within 180 days, the ITC claim will be reversed as per Rule 37. Correct?
Yes, Your Honor.
The law never denies nor prohibits you from availing input tax credit. The only condition is that you need to make payment within 180 days from the date of issue of invoice.
It makes exclusive.
Exclusive.
It's not subjective.
But now, Your Honors, if
You
the-
need to reverse the input tax credit.
To any other thing. So that it has been already cleared on the very initial.
Go back to basics.
Yeah.
Supply.
Supply is basically supply of goods. Someone has supplied me the goods.
No.
Supply is not defined in the act.
Okay.
Supply is for a consideration.
That's what I am coming to. As per section 24.
Consideration is supply, inward or outward.
No. Go to section 25 of Indian Contract Act. Any agreement without consideration is a void agreement.
But Your Honors, if someone is there are many agreements which are made on loans also. On loans, and many agreements are based on face values.
But we have to talk to your specific case. What can happen outside, we don't know.
Loan is a part of consideration.
Loan is not a part of consideration, but there are many contracts where in a buyer and seller are in a good relationships. Buyer takes the goods and he promises that he will pay after a certain period of time. That is in a many cases.
Property in goods will come to you when?
Sorry?
Property in goods will be transferred to you when?
When the goods are purchased by me, when the consideration is paid.
With the consideration.
But
correct?
Correct.
So here the consideration has not been paid and you want to enjoy the input tax credit also. We are telling you, you will enjoy the input tax credit only and only if you make the payment within 180 days, or if at a later date, then there is no time limit.
Your Honor,
Then there is no time limit. You may make the payment after 2 years also. After 2 years also you can get the input tax credit.
Yes,
There is
sir.
no time limit thereafter.
Any contract between two parties cannot override law.
Yes, Your Honor.
Violence to the statutory provision is null and void.
But sorry to interrupt, but whenever a contract is made, until
No,
and
this contract has to follow the law.
This
Law doesn't have to. Now you are saying that law should follow your contract.
Contract should have followed a law. I
Then-
agree, but
then-
whenever a contract is made, it is allowable when it is a legal contract.
No, why? Who told you?
Only
I have a contract with you because you will murder me, murder my wife.
that is not a legal contract. That
No,
is
this
what
is
I
all
am
legal.
saying.
You have to pay me still.
The
Only
contract
those agreements that are enforceable at law are contracts. A contract in violation of public policy, in violation of a law, is void ab initio.
Yes.
So you can say, I will never pay you. Or you will say when my son will be born, he'll become 18 years, then I will pay you. So that's also a contract. Article 14, 19, no article is offended at all in these cases.
But what about
And
privity
anyway,
of
this is not a
contracts?
forum to discuss constitutional matters.
But what about privity of contracts?
Why?
In morning only, in a case, you said that in Augusta Trading Company, that you said that in a contract, any third party cannot come in between. But in here, buyer is the
That
first
was
party.
for the payment. I didn't say that. I said you cannot appropriate payments. It's not allowed.
That was a different matter in which there were 12 vendors and payment was going only and only in 4 accounts.
Yes, Your Honor.
Correct? So in that case, in that reference, Mr. Verma has mentioned that. So it is not that you cherry pick the things and paste it wherever you want to do.
Here in any case, we are not denying your contractual privity. We are not discussing contractual privity. It's a contract. You have a contract. But you cannot write in the contract, I will violate GST law, still claim money.
Yes, Your Honor.
180 days is a valid provision. All high courts have held this valid. Supreme Court is pending.
High Court have not held that this valid.
High Court has not given stay in any case. I have filed 2 writs in Telangana, there is no
in
stay.
High Court, all the cases, there was never a
You
point
have
in that-
relied upon various high courts, you have mentioned in your appeal also, but you have not mentioned even a single citation. Which high court matter you are referring to, and show us the interim order if there is any.
Your Honor, this particular issue has never gone to High Court till now.
Delhi High Court is there, 2 cases are pending. 3. There are 3 pending in Delhi High Court.
Pending. They are pending right now.
That's why
You are saying that it has not gone. You are giving a contradictory statements here. On one side you are saying it has never gone. No, that you are saying they are lying pending. So you first make sure whether they are lying pending or they have never gone.
What I meant to say is, Your Honor, this legal issue isn't pending right now before Delhi High Court. Yet no response has came, but this is not even denied by Delhi High Court.
No, but there is no stay.
No interim order, no stay. So how you can rely on, you can quote those things and take a shelter of those cases.
Tanishq, once you challenge a provision, writ will be entertained at every cost.
But the writ was not cancelled on admission basis.
No, that's why I am saying no.
It was admitted on admission.
I can file 40 writs, 40 people can have 40 writs on the same issue. Where is the bar? Only once they pass order, you can't file a writ. And for example, Article 2 to 6 have no connection with Section 16. Here you are in a statutory appeal. Writ courts have all the powers in the world. This tribunal is bound by the rules made by a statute. They are an authority created by a statute. Therefore, this 180 days is very difficult to argue on legal front. You can't have a contract in violation of law. That's not possible.
This appeal is dismissed.
But Your Honor, I would like to request that if this order is dismissed, then the High Court is already pending in this case. I would like to.
Have you gone to High Court?
We have not gone to High Court.
So whenever that decision will come, you can.
That is only I am asking to write.
We cannot keep the things pending till then.
I am not
Had there been an interim order, we would have also kept the matter in abeyance.
Honest,
But since there is no interim order, we cannot keep it in abeyance.
I am not asking to keep it in abeyance,
Here.
Your Honor.
Bolo.
Your Honor, I am not asking to keep it in abeyance. I am just asking to add a line in the order that if the High Court comes in favor, I can come back to this tribunal.
Yes.
Then you deposit the full money?
Yes,
You deposit the full money now.
We are.
The order will be passed that you will be depositing full money within how many days?
Within any date that the court may.
Within 15 days.
Sure, Your Honor.
And if a favorable order comes from Delhi High Court,
then I will.
Then you can come back and argue your appeal and take.
Well done. This is the legal strategy.
Page 22. Yes, Your Honor.
There are
No, my lord, I think his first appeal. Let him enjoy the first appeal.
One thing more, but that is a lesson for it. That is a lesson for two.
I have also noticed.
Yes. You have copied the same thing from your father's appeal, I believe.
Yes, yeah. Yes, yeah.
I also noticed. I was about to say that.
How many adjournments are allowed under section 107, Tanishq?
3.
And how many opportunities were given to you under 107? 6.
Your Honors.
And you never appeared there also.
But Your Honors, I never appeared, but...
So, all these things ultimately take your case away from...
You have written adjournment sought for. Where is the applications?
He has not, no, he has not filed
That is written in the order itself, that the adjournments are sought. It is written in the order itself. I am just saying that every time the adjournment was sought, that means compliance was made. I was not completely non-responsive.
On this issue, you have to work more. Courts view it very seriously when you don't respond to notices or don't appear. You can destroy your case on merits based on this ground itself. Courts take it very seriously if you don't respond to notices.
Yes, sir.
डिपार्टमेंट के चपरासी का नोटिस भी आप उसको जवाब देना चाहिए आपको.
Yes, sir.
Well done. Let's give a round of applause. His first appeal.
Thank you, Your Honors. Thank you, sir.
कौन से है? हैं? अच्छा.
Item number 4, RV contractors argued by
गुंजन जैन.
item number 5, RV contractors argued by CA Gunjan Jain from Indore and government counsel. Very interesting question.
आप आ जाओ. हमें तो कोई objection नहीं है.
Very interesting question for this new tribunal. Tax charged and paid under a mistake of law. Government deducted tax wrongly paid to the appellant as the services were not liable to tax as alleged by the
अरे
law.
क्या हो गया माइक को?
The appellant files refund after. The appellant filed refund after 2 years from the relevant date, alleging mistake interpretation of law and quoting Article 265 of Constitution of India. Revenue alleges no case made and refund application were dismissed at time barred. Very crucial and interesting question of law. Let us here sitting on the edge.
Before he starts, this is an unexplored area on refund issue. Most of us know under 54(1), only 2 cases cash refund is allowed. Zero rated or SEZ. Right? Cash refund is not allowed in terms of law in any other issue. Zero rated and what it was structured SEZ. Now this is a case where tax is paid under a mistake of law. This word is not written anywhere in GST Act. What is mistake of law? Right? That is supposing you think some item is taxable. You pay tax. Later on Supreme Court says this one never taxable. You have paid tax. So once you have paid tax, you have issued a tax invoice. That is, you have taken the tax back from the buyer. So you have no case for refund whatsoever. That is why above 2 lakh they take a certificate of theory of unjust enrichment. The theory of unjust enrichment was espoused by Supreme Court in 9 judges judgment 8-1 in Mafatala Industries versus Union of India. The theory still holds good. Now you also have a 2 years of relevant date. For these issues, relevant date is also not defined. So when you seek refund under these circumstances, 3 hurdles have to be passed. First, you have to bring within 54(1) before the expiry of 2 years. That limitation is sacrosanct. Court says it's a may word, shall word, whatever, but so far is 2 years mandatory period. right? Now when you have to bring within 2 years and relevant days late is not defined, then what happens? Number 2, you have to prove that you have not passed on the burden. When we say passed on the burden, you issued an invoice, you have debited the customer, burden has been passed. That customer never pay you. Because under section 9, liability is on you to pay tax on a taxable supply. Whether buyer pays you or doesn't pay you, that's immaterial. Third, you have to prove that first it was a tax-free. It's a tax-free, and we made it taxable under a mistake of law. Mistake of law, you have to bring on record to prove that how was it a mistake of law. A subsequent Supreme Court judgment doesn't make it a mistake of law. Because refund arises when you did the transaction. Now you can't say after 10 years Supreme Court says it was tax free, now you will claim refund after 10 years. The answer is no. Then fourth, you have to prove that you are not unjustly enriching yourself by claiming this refund. So you are going to see a new exploration of a concept of refund based on section 72 Contract Act, mistake of law. That is where this mistake of law is defined. So here for 20 minutes, he has 20 minutes to 25 minutes to speak on this issue. Yes.
Good afternoon, my lords.
And Gunjan is a CA from Indore. He has flown all the way from Indore to discuss his appeal. Let's clap for him.
My lords, first of all, I would like to acknowledge that.
And he is one of my good students.
I am under a wrong attire as of now. I have been told, and I know also this, so I apologize for this. In the morning, I was wearing something white and a blazer, but some coffee spilled on the airport, so that's why I had to change in the bag, and I'm wearing this only. So kindly apologize. Do not consider it as an act of disrespect. A very good afternoon to the members. I am Gunjan Jain, practicing chartered accountant, appearing on behalf of the appellant versus RV Contractors against the order passed by the first appellate authority dated 8th February 2025. The impugned order here by us has rejected the appellant's refund application of 13,10,000 rupees on the ground that it was filed beyond the limitation period as stated in section 54. I would request your honor to please consider some facts before we get forward to the case in hand. The first fact is the appellant is engaged as a government contractor, government service contractor engaged in building and constructions of the government houses. The transaction in discussion is based upon the contract executed in nature of an all-inclusive tax of government contract. The invoice raised in March 22 and the tax upon the same was paid by returns of 3B filed in November 22. These returns were filed belatedly due to the fact that appellant did not receive the payment from the government contractor, and hence due to a working capital crunch the returns were filed belatedly. Upon intimation by the government authorities on 15th of December 2022, we came to know that the tax was not at all leviable on the first place on the said transaction, which went against the opinion which we had taken from Messrs. ABC and Consultants, in which he told us that the tax was payable. The tax was paid under a mistake. Now, since the tax was discharged from the hand of appellant in November 22, as per the point above, if the same is deemed fit to be refunded by honor, it will not tantamount to an unjust enrichment in favor of the applicant because I have already passed on the tax burden to the government office. We would also want to emphasize on the matter that both the appellant and the respondent in the case are of the same opinion that the tax was not levied on the transaction. I had received a letter from the government who is demanding back the tax that they have paid to me. I have also sent the refund application to the government demanding the tax that to be paid back to me. So we both are on the same grounds and telling that the tax is not leviable on this particular transaction. Now to put our case forward, there are two cases over here. First of all, the AO has misinterpreted the definition of the significance of the relevant date in the matter. The relevant date in the section 54A to H, our case is fit for the subsection H over there, where the date is any other case, in any other case the date of payment of tax. The date of payment of tax in our case was December 22. The November returns were filed in December 22. The refund application was filed on 10th November 2024, thereby making it a case of under 2 years. Second, keeping this fact aside, Now there are two sections which govern the refund, section 54.1 and section 54.3. Under section 54.3 there are two specific cases which are governed by 54.3. First case is being zero rated supplies and second case is refund of ITC on inverted duty structure. Our case is not covered in any of these two topics. It is a case of section 54.1 where it is very plainly described. The section uses the words the applicant may file under an application if it is gone under section 54.1. Here the role of Article 265 comes into play, because since it is very clear under 265, it's a single one-line article. No tax shall be levied or collected except by the authority of law. And the courts have at times held in all such cases of Messrs. Cosmo Energy, Delhi Metro Rail and Mafatlan Industries that limitations cannot override the right to refund in case involving of unlawful and an invalid collected tax. This right arises from the constitutional protection and the principle of unjust enrichment, and hence the honorable bench, if may consider rejecting this, will tantamount to an unjust enrichment to the government exchequer instead of the appellant. Further, the appellant hereby requests to answer two queries. First, whether the application of the appellant has been filed within time limits of 54. Second, if no, then is the government exchequer entitled to keep monies that do not form a part of its revenue only upon a technicality of time limit over a transaction that was not taxable at the first place, and benefit itself over a wrongdoing of a taxpayer? Thank you.
This is a pure question of law and facts mixed together. Law is more important than facts here. Let's talk of section 54.1, 54.2 relevant date. Relevant date says, in the case of goods exported out of India where a refund, etc., it goes on. Then point H says, in any other case, the date of payment of tax. When we say in any other case, this has to be harmoniously construed to the above contentions, right? Per se, in my opinion, 54 does not allow refund based on mistake of law, right? But yes, few rulings have happened. Now the case of my friend is, he has not been able to explain facts properly. He made a sale in October 22, December 22, December?
Yes, no, March 22.
March 22, where he showed this sale as taxable. And this he had done after taking an opinion from a consultant, right? Now I have gone through the opinion is silent. On what did he give opinion? The opinion was as vague as the case is. The opinion on what? What was the transaction? Under which entry, what is that entry meaning for, and how this entry was related to the works contract he did. All that is missing completely. It's just in the air because some opinion was taken. Similarly, when after their audit, the government department wrote them a letter, that letter is also equally bad. They don't know under what notification. Now, government contracts and services have 200 entries, many notifications, right? Now, when he raised the bill, and my friend said he has passed the burden to government, so refund is ruled out. Whether government pays or not to him, this is not my baby. You have issued an invoice, mentioned in your 3B returns, you have to pay tax, right? Because you have to wriggle out of section 9 first, whose liability was to pay tax? On suppliers?
Yes.
You are a supplier, you pay tax.
I paid tax.
Now government after 7, 8, 1 month say, no, this was not payable. Government already paid you.
Yes.
Full payment has been made to you.
Yes.
Right? Now government says, you give this money back to us. How do you have a locus standi to argue this matter? You have to answer on this. Look, how this appeal is maintainable here? You have taken the money from the government. Government has paid you. 54 does not debar recipient from claiming refund. 54.1 and 54.2, that is the difference. My lords, 54.1, 54.2,
3.
51, 54.2, 54.1. 54.1 deals any person claiming refund.
Yes.
Any person means person is defined in section 2, it includes recipient. 54.2 says there's a proviso, provided that a registered person. Then if you go to 54.3, that's also registered person. So when you say in any other case, this refers to 54.1. Otherwise, all situations mentioned in explanation in subsection 2 are dealing with registered persons. Right? So government has paid you, the government says not taxable. How can you come in appeal in this?
Because the government is asking me to refund the amount and adjusting against my future bills.
No, then let the government come.
But government is asking me for the money, na, which he has paid. Government is asking me for the money.
Then you should have said, I have paid to government. It was taxable. You never said it's not taxable.
So,
okay, but let's agree with it. Government says you can also claim refund. I have no issues. Right? Now, where did you prove it's a mistake of law? If you want to come into Delhi Metro or Cosmos case, you have to prove a mistake. In those situations, they proved there was a mistake of law with documentary evidence. Here, your opinions show absolutely nothing. What was the transaction? The Honorable Tribunal has to be convinced it was a tax-free transaction.
The transaction was of a service which included services made to a government agency.
कहाँ लिखा?
Contract में दिया ना
नहीं कहाँ लिखा? नहीं आप अपनी अपील में देखो ना कॉन्ट्रैक्ट में क्या कॉन्ट्रैक्ट में तो बहुत सारे काम आपने किए. You are hit again on one more issue. Your contract is inclusive of tax.
Page number 44, copy of contract has been annexed.
हाँ तो it doesn't matter. आपने जो आपने सर्विस किया कौन से नोटिफिकेशन में एग्जम्पशन दी उसकी कौन सी एंट्री में एग्जम्पशन
Your service is exempt or not, that you have to display. Where have you displayed that?
Honorable Tribunal not going to give you money because you want to say that I'm going to give you 23 lakh rupees. Now listen again. When you deal with exclusive or inclusive of contracts, interpretations are totally different. You quoted a rate. That's it. Government paid you.
I have quoted that the government has accepted the contract.
Your contract has a clause of arbitration. Did you go to arbitration?
I can if needed.
No, that's your option. I'm asking you.
Yeah,
Why didn't you go to? It's a matter of arbitration. Unless you prove, then you have not made a prayer. If this money is given to you, you will give it back to the government.
But the case does not inquire arbitration. Once the DRC 07 is issued, I cannot go into arbitration matters as of now.
No, that was your option. You applied. I'm saying when you apply for refund.
But the total consideration for 20 crore rupees is
you have taken this money from government?
Yes.
You said?
Yes, I have taken the money.
Now supposing refund is given, whose money is this?
This money is now mine and I'll be giving it back to the
government. No, you are nobody. This money cannot be given to you.
Who is, but the channelized is...
Then you should have written, I will hand over this money to government. And government should accept your letter, yes, this appeal we are aware of. If the ruling is in our favor,
yes,
ruling is in our favor, this will be passed on to you. Then you were referring Article 265.
Yeah.
Mafatlal you have not read.
Sir, I have read only the important facts.
Not only. Mafatlal is 110-page judgment.
No, I know that, but I have read only
after this para, there is another para where Justice Jeevan Reddy interpreted Article 265. My lord, they said the argument put forward by Article 2 money is mine. He says if this is the interpretation, this economy will collapse. He says this money cannot be given, this belongs to the state for the development work. And it's a majority judgment 8-1. So Justice Jeevan Reddy wrote the 8-1 judgment. So you can't pick up a cherry and say now it will blossom in my favor.
But government cannot penalize, the two governments cannot penalize the
we're not, government is a taxpayer here.
Yes, but
so where is going your two governments?
No, but the one government is from which one doing the contract who's asking the money.
In the earlier regime, there is a procedure to form committees. You should have gone to committee, but you are not a government. Government to government committee बन सकती है. आपके साथ किस बात की committee है भाई? Therefore, in the present form, in my view, your appeal is not maintainable. Till you make out a case that this is a mistake of law, this was a taxable entry, and these are my invoices, this work was done, and this work flows from the contract, and there's a government letter, you will not pay you, they want money back. There is no legal steps taken against you by the government so far.
Not as of now.
कुछ भी नहीं हुआ. Then there should have been an affidavit explaining these facts that this, in case the Honorable Tribunal finds that this money is returnable to me, this money can be transferred directly to them. Why do you want money yourself? It's not your money. आपको तो पैसा मिल गया गवर्नमेंट से, जो आपने 3B में जमा कराया आपको तो मिल गया.
मिल गया था.
But my lord, what I am saying is that we should ask him to refile this appeal, giving all this information.
I have prepared a different order. Because now this 265 also plays a crucial role.
Yes, yes.
Secondly, जो section 72 of Indian Contract Act, so the money which has been given by mistake or by coercion, so that belongs to the person who has given it, and it must given back.
Yeah.
But that way you are right, because he has to establish that this has happened due to mistake of the law.
And the money has to go back to the person who has paid. He has not paid tax.
Yeah.
He has charged the tax. He has been paid tax by the government.
The government has started recovering process
Yes.
from them.
So now let it go to the government. But let him refile the appeal, bring his government here next time.
Now at this stage, because we have to conclude this matter,
Yeah,
so the only way with us is that we can refer it back to the.
No, I can refile the appeal
You
if my laws
please
now.
amend your appeal.
Yes, I can amend my appeal and refile it if you.
Refile it with fresh grounds and all.
Sure, sure.
And in the meantime, collect all relevant information.
Information as explained to you by Honorable Dia.
Thank you.
Well done, Gunjan. Difficult case, because all cases are difficult today. Even 180 days also, we grappled us. Tanishq Ahuja.
Item number 6, Agra Enterprises, argued by Advocate Monil Agarwal and Advocate Mukesh Agarwalji from Agra. Sorry, Mukesh Khandelwalji. Payment for exports, whether mandated to be received in convertible foreign exchange currency as per DGST Act, and if not received, can be refunded. Refund be stopped, or where refund not issued at all, can such export be taxed in terms of section 16 subclause 3 proviso to DGST Act? Pure question of law. Let's hear them.
Now the case here is again a very difficult case to handle in terms of appeals. It's not easy. They have also confused the matter in such a big appeal. Case is simple. There was an amendment in 2022 in section 16, even for export of goods, you have to receive payment by a foreign exchange, right? This they added a proviso. But like export of services, there is no proof to be required before you get refund. And there are provisions, if you are delayed, RBI can seek waiver, whatever, but only the waiver happens, that happens. So if you do not get payment within a certain time, you have to pay back the tax with interest. Because when you export it, you zero rate it. जब zero rate किया, अब वो export में आपका माना ही नहीं, आपने condition fulfill नहीं की, तो अब क्या होगा उसका? Will this be interstate sale and taxed? There can be no other way. So this issue is on, am I right? Basically this issue. Well, let's hear you, sir.
Your Honor, can we proceed? Your Honor, appeal has been filed, aggrieved by the order of the first appellant authority as well as by the proper officer, where our refund application in respect of zero rated transaction of supply of goods was rejected on the basis of payment not received. And further, the tax liability was also imposed on the total export sale. Your Honor, our dealer does business of manufacturing and sale of EV chargers, which are sold interstate at the rate of 5%, and along with it also does resale of EV chargers, which are exported against LUT in same condition as purchased. The good exported against zero rated were totally purchased from JM Auto Limited Agra, a reputed auto manufacturing part company, and the good purchased were in pursuance of import order from the importer of UAE. And the same goods has been exported and all export document has been submitted. Our refund application for the fourth quarter of assessment year 2023-24 was filed to claim refund of accumulated ITC in respect of export of goods without payment of tax. And secondly, which was rejected by the proper officer as well as by the appellant court. Along with the rejection, they also assessed the tax on our export sale. The fact of our case is that our refund application RFD 01, which was filed on 15th January 2025, was accomplished by complete document as prescribed under Rule 89 of the DGST Act, and a notice RFD 08 was issued by the proper officer, in which main point taken was no proof regarding payment received was annexed with refund application. And regarding this, he mentioned in this notice, he proposed to reject our refund claim and proposed to raise a demand of 5% being our EV charges with interest. We replied and we brought to the notice of the proper officer that Rule 89 does not lay down the condition that payment of export should be submitted along with the refund application. But our written reply was rejected, and the proper officer, by order dated 22nd March 2025, rejected our refund application, stating that he is unable to process this refund. So the refund amount to the extent is hereby rejected under section 54(6) of the DGST Act, and furthermore he directed us to deposit the tax on the total turnover of the export. He imposed the tax amounting to rupees 5 lakhs and the interest of 1,23,000 on our total export sale, and also rejected our refund of rupees 5 lakhs. Agreed by the order of the proper officer, we filed the appeal before the appellant court, and the appellant court also rejected our appeal by order dated 15th May 2025. He mentioned in the order that payment for export has not been received as per circular issued under provision of FEMA, and as per FEMA time has long been expired. A period of 30 days is over in terms of section 16(3), first provision of IGST Act. So the order of the Joint Commissioner appeal, against the order of the Joint Commissioner appeal, we have filed the appeal before the Honorable Court. In the order, he has mentioned the provision of section 16 subclause 3. Whereas in the provision of section 16 subclause 3, there is no such limitation has been mentioned, where it has written that in absence of payment not being received, the applicant cannot be given refund. If the court allow, I can read the provision of section 16 subclause 3, where it is written that provided that the registered person making zero rated supply of goods shall, in case of non-realization of the sale proceed, be liable to deposit the refund so received under this subsection along with the applicable interest. So from the reading of the section 16 subclause 3, it is very much clear that it specifies the case where the dealer has already been issued the refund. In our case, the refund has not been issued up till now. No, refund has not been issued. We have filed the refund application.
It has been rejected.
Application of refund is rejected.
Our application for refund is rejected.
03.
Partly allowed, partly.
No, sir.
Nothing.
Application of refund is totally rejected on account of non-payment of export proceed.
Non-receipt of payment.
And the order has been given saying that we have violated the provision of section 16 subclause 3 of IGST Act. And I want to interpret the section 16(3) subclause 3, where it is very clear कि it applies where the refund has already been granted. So the order mentioning the provision of section 16 and rejecting our refund application is highly unjustified. I like to bring to the attention of the court that the refund application was filed as per provision of section 54, where it is prescribed that application for refund shall be accompanied by documentary evidence to establish that refund is due to the applicant. The document in this regard are prescribed in Rule 89 subclause 2. As per Rule 89 subclause 2, the above application shall be accompanied by following documentary evidences to establish that refund is due to the applicant. And all these documents were submitted with my application as required, but it was not considered by the proper officer nor the appellant court. Rule 89 2B specifies that application for refund RFD 01 shall be accompanied with the following documentary evidence. This is provided in Rule 89. Documents specified is a statement containing the number and date of shipping bill or bill of export and the number and date of relevant export invoices in the case where refund is on account of export of goods. We have done export of goods, sir. That there is no precondition of submission of payment proof in respect of export sale while applying for refund in respect of export of goods under LUT, so the refund rejection under RFD 06 as well as appeal order passed is highly unjustified. Rule 89 also does not lay down the precondition that payment of export proceeds should be done along with the refund application. So the order passed, the very basic of the order was we have violated the provision of Rule 89 and we have violated the provision of Section 16 of IGST Act. But as per plain reading of both these things, it is very much clear we have not violated any such provision of Section 16 or any Rule 89. And the clarification in respect of Rule 89 and the document that we have to submit along with the refund application has been given time to time by the Commissioner through various circular. I have mentioned circular number 37 dated 15th March 2013. So whatever confusion it had been there while reading the section and rule, it has been cleared here where they have made the table. In the table they have specified that all the types of refund. I have mentioned my case where the type of refund specified is refund of unutilized ITC on account of export without payment of tax. And the declaration statement specified in the box, it said that declaration under second and third proviso, undertaking, statement 3 and statement 3A, along with the supporting document that are GSTR 2A, statement of invoices, self-certified copies of invoices if the invoices are not shown in 2A, and there is no such condition where it has been said that BRC should have been filed with export of goods. BRC is specified where export of services are being done. We have done export of goods, sir. So the very basis of the order of the proper officer as well as of the appellant court is not understandable. The provision of Rule 89 as well as Section 16 is highly interpreted, wrongly interpreted. Sir, though from the fact already submitted, it is clear that the payment of export proceed is not the precondition for claiming refund for export of goods. Yet, as the payment has been received now, and an application to admit additional evidence before the Honorable Tribunal is also being filed with the appeal, in which the following additional evidences are enclosed: copy of BRC and application given to the Reserve Bank of India in compliance of FAD Master Direction 16 dated 1st January 2016. The second issue which has been raised in the appeal order is imposition of tax on the total export sale. So the tax liability at the 5% was imposed on good exported of rupees 1 crore. I like to know from the court whether the order where the demand is to be created can be issued in order under RFD 06. RFD 06 an order which is given in case where the refund application is filed under RFD 01. If any demand, any recovery is to be made, it has to be made under section 73, 74, read with rule 142 in DRC 07. If I have violated any such provisions, so department was free to impose any tax under section 73 or 74, and they should have created a demand under DRC 07. But no such provisions was followed. Simply, demand was raised in the refund rejection order itself. So the demand raised in the order is highly unjustified, and I request the court, exporters should not be harassed for penalized due to rigid instance or particular form of documentation, sir. The principle of proportionality and fairness must be upheld in tax administration, sir.
That's enough. Huh?
We are quite.
That's enough. हो गया, बस हो गया. Your Honor, exports are interstate supplies. Section 5 levies tax. Exports are not tax-free. The only definition of exports being zero-rated, the only consequence is that for input tax credit, they will be given refund. There is no other functionality of exports in this GST law. Let's go through section 16.3 proviso. Section 3 says a registered person making zero supply shall be eligible to claim refund of unutilized ITC on supply of goods and services both without payment of integrated tax. They have also done LUT क्या है ना आपने?
Yeah, against LUT.
Under bond as well in accordance with provisions of section 54 of CGST Act and rules subject to such conditions, safeguards and procedures as may be prescribed. Immediately thereafter, now there is a proviso. Provided that the registered person making zero-rated supply of goods shall, in case of non-realization of sale proceeds, be liable to deposit the refund so received under this subsection along with applicable interest section 50 of so and so within 30 days after the expiry of time limit prescribed under the Foreign Exchange Management Act for receipt of foreign exchange remittance in such manner as may be prescribed. Now, my friend is harping refund received. This is not a case of where refund was issued. But what is the legislative intent here? Within 90 days, you have to, within 9 months, you have to get a payment as per FAMA. RBI circular is there, right? They have not got. They were supposed to deposit automatically within 30 days on their own without a demand notice. That is the mandate of this proviso. It says, so received and check subsection along with applicable interest. Now they say we did not get refund. So did not get refund, so your exports will not be taxed. That is, there is no export done. Once you have violated a condition which is a condition precedent to claim zero rating of transaction, you have not fulfilled. The export goes. They have not quoted any provision of rules where payment comes, can they get refund after 9 months. RBI has been given power to waive off these conditions. They cannot seek extension from RBI. In the rules and section, there are provisions. But we are not concerned. There is no waiver coming from RBI. There is no provision quoted how to get that. The only technicality which they have been able to raise, where I will concede with them, that this order for demanding tax should not be in RFD 06. But that's a technicality. It is only for the recomputation of statistical purposes. The case can go back. But my friend has not been able to say whether this is not a condition. He is confusing with 2.6 export of services or export of goods. Export of service, BIC is mandatory. There also now there are a lot of leverages being given by the courts. But here is very clear. And this was an amendment made. Earlier it was not mandatory. And we are not asking BIC. We are asking, did you get payment? Once you yourself admit payment has not come, now you filing additional evidence by payment has come, then the order on the day it was passed was not wrong. Now it is for the proper officer to say whether he wants to admit this evidence of payment or not now. They have not quoted any rules to me. They should apprise the tribunal under what rule now they can show the payment and get the refund. And then there is a demand created, you are deposited 10%?
Yes.
You are deposited 10%?
Yeah, yes, sir,
10% is deposited by them. I think if they have received the payment, I will concede, let the order go back with the direction that this RFD 06 cannot be used to levy tax liability. Well noted this point. Otherwise, there is nothing, we could have done anything in this tribunal. I think that's a fair order. Let them go, let them get relief.
Your Honor, the show cause notice given by the proper officer should be a relevant notice. In the notice they have said the no proof of payment received was annexed with refund application. When the Act does not provide us the condition in a limitation that we have to attach the payment proof, then why the issue was raised in the notice?
You should have always filed a reply if not
Yes,
required.
yes, yes.
No, that's not a bad show cause notice.
The issue was
It's
raised.
a show cause notice, not an order.
Yeah. The notice was issued on only this issue. Rest all the export documents were submitted and no objection in respect of any document was pointed. No. Only single objection was raised. No objection as regard.
Beyond SCN, and the deficiency has not been raised in SCN.
No, sir, let's see, SCN, sir. Which page you show cause notice?
Sir.
Which page? Even then, has to go back. If the limitation, they will redo it.
No, sir. I disagree with you.
Page
sir.
number 30.
If SCN cannot be improved, SCN cannot be issued again.
Let us see, sir. Absolutely. Page number 30.
Page number 30, sir. If you permit, I can read.
No, I'll read myself. Page number 30 there है कहाँ है?
30. No, sir, center of the page. The numbering is in the center of the page.
You have not properly drafted your,
नहीं, page number 30 तो कोई लिखा ही नहीं मेरे को दिखा ही नहीं यार.
Yeah, this we have.
नहीं यानी पीने मैंने.
One sentence has been completed in just without giving any space, any comma. There are so many, not
Because
one place. At every page you will
sir,
find.
actually the soft copy was sent to him. In the hard copy I have got, you can see that everything is according.
Result of your soft copy only.
Yeah, I know.
See, go to page 21. Every discussion into nobody can at one
Sir,
go.
that was a soft copy provided. Sir,
cannot read it.
I'll try to not to repeat it next time. But in the hard copy, everything was proper. Every sentence was proper.
I appreciate your honor. Show cause notice is incorrect.
Show cause notice is incorrect. So this appeal needs to be.
Appeal accept. Let the proper officer do whatever he has to do without your directions.
Sorry?
Without your directions, he can do whatever he wants to do. Proper officer. We have limitation. We can reissue a show cause notice.
No, we will not send it back to the.
You need not give a direction. I'm saying
Yes.
if law permits us to do it, we'll do it again.
No.
On this issue, appeal is accepted. Only on this show cause notice issue.
Any demand raised against this show cause notice needs to be quashed.
No, sir. There
needs to be quashed.
Now there is a second issue. There is a second issue.
Yeah, second issue we will discuss. But
there is a.
no, let's come to the second issue. The first issue is quashed.
No. Second issue. That means you are saying that refund should be given to them. Are you saying refund should be given to them now? There is a demand.
See, when the foundation laid is
I
wrong.
appreciate you, Honor.
So on what basis you can withhold
So
the
that means now you say that the demand is quashed.
Yeah, demand is quashed.
There is no direction to
No,
refund.
no.
That's okay. I
Yeah.
fully agree.
Yeah.
Let you go back.
Thank you, sir. Thank you.
Fully agree. Well done. Well caught.
सर
They will reissue.
एसपी सर से मैं
They will reissue show notice. They will exclude this period.
सर मैं पूरे हाउस को जो है बताना चाहता हूँ कि हमारे माननीय अग्रवाल बेसिकली जो है ग्रेजुएट इन इंजीनियरिंग हैं और थर्ड जनरेशन के एडवोकेट हैं और आपकी आज इन्हें ब्लेसिंग्स मिली, ये हमारे लिए बहुत कुछ है।
कोई बात नहीं, अगली बारी इनको बक्स कॉन्ट्रैक्ट पे लाएंगे। हाँ हाँ Payment has not come. Nothing. Write to the government for a policy change. We can't change law. In this case also, there is no case on merits. For the show cause notice उसका छापा, वो रेणु शर्मा का show cause notice इसमें छप गया. वो केस रेणु शर्मा का है. गलतियां तो है.
But once the refund is disallowed here and the order is passed, then I will not be eligible for the refund later on.
You can reserve this. You can reserve your application with the appropriate authority.
What will happen when this order goes back? Right? Show cause notice is not quashed on merits. It's quashed on jurisdiction. The reasons are wrong. They will reissue a show cause notice if time permits.
But he cannot make the application again.
One. No, his application will remain. If he wins after this, तो ये period exclude हो जाएगा. वैसे भी इसको he does not make a fresh application. Department will issue a fresh show cause notice. So then he can claim अगर कोई rules में इसको मिलता है, जब payment आती है आपको मिल जाता है, उसका interest लगता है आपको.
आपको डिससेटिस्फाइड लग रहे हैं सर। मान लीजिए पोर्टल पे अगर ये आपने पार्ट क्वेश्चन
डिमांड खत्म हो गई.
डिमांड खत्म हुई
बस.
लेकिन जो रिफंड एप्लीकेशन थी वो तो खत्म हो गई, यहीं आज ही खत्म हो गया। अब ये दोबारा कैसे डालें?
नहीं रिफंड एप्लीकेशन खत्म नहीं हुई.
एप्लीकेशन लाइव है। अदर अकाउंट ऑफ
कंटीन्यूअस लिटिगेशन में चल रहे हैं ना, उन्होंने अपील करी, उनके बाद सेकंड
तो अगला कौन सा है भी जल्दी करो चलो.
Sir, item number 7, Diwan Enterprises, argued by Advocate B.V. Diwanji. Permission to produce additional evidence on an issue not argued before the lower authorities. A totally new case made out with documents. Interpretation of relevant date for the purpose of calculation of limitation. Can the tribunal allow such application for production of additional evidence on an issue which is not raised before by the applicant?
Mr. B.B. Diwan is our advisor to the group. So whatever you are, this is his basically creation. He is a senior government counsel with the DGST Department, High Court. But here is first time.
My lord, I am honored to appear before this bench first time. May I proceed, my lordship?
Video.
Thanks, lordship. The appeal has been filed within the limitation period. The appeal has been signed by the authorized person. There is no demand and hence no pre-deposit is required. The power of attorney has been filed. The application for placing additional evidence under Rule 112 of the DGST rule, dealt with the Rule 45 of the Goods and Service Tax Appellate Terminal Procedure, bracket, Rule 2
025 has been filed at page number 7 and evidence at page number 10. The applicant is an old man and the proprietor of the firm. The applicant had made a zero-rated transaction wherein a refund amount of rupees 4,50,000 become due. The appellant filed an application before the proper officer for refunds due as per zero-rated invoice dated 1st November 2022. The application was filed on 26 December 2024 and the same was dismissed at time barred. In view of the limitation placed under Section 54 of the DGST Act, which mandates that the application for refund may be filed before the expiry of 2 years, and hence there was a delay of 56 days only. Feeling aggrieved, the appellant preferred an appeal before the first appellate authority and pleaded him to call the records from the custom as to when ship leave. This request was made by the counsel at the relevant date for exports made through ship by the date when the ship left. Since the proprietor himself could not do it and these records were not available with him to short time, that the appellate authority not only did not give time but also did not pay any attention to this argument of the counsel for the appellant. Resultantly, the appeal too was dismissed by the learned first appellate authority upholding the orders of the proper officer. Now the appellant has approached this honorable tribunal. An appeal has been filed which is pending before for disposal. The information regarding ship departure date has been obtained and the details are as per annexure at page number 10 of this petition, and the thought the exports invoice was dated 1st November 2022. The ship carrying these goods left for the port only on 29th December 2022. As per EGM, Hanji. No, sir, sorry, sir, it is a typing error. I have a one spare copy.
अच्छा मेरे में 22 ही लिखा है.
The ship carrying these goods left for the port only on 29 December 2022. As per EGM, copy enclosed and annexure at page number 10. And if this evidence is admitted, then the application for refund under Section 54 of the DGST Act is well within time. That is to say, the same has been filed before the expiry of 2 years. The applicant thus prays that the Honorable Tribunal may plead to admit this additional evidence on record under Rule 112 of the DGST rule, read with Rule 45 of the GST Tribunal Rules 2025 on the ground that the appellant was prevented by sufficient cause. The proprietor, being an old man, did not know anything about such documentation. That the appellant authority should have provided him sufficient time to bring this evidence on record, especially when this point was argued before him, but did not take the same into account. Yes.
I think his application is well drafted additional evidence. I will have no objection. And this case can go back in view of 54(2)(a) subclause 1. Yes.
Why you are saying that it should go back?
Now see, this is they have filed a photocopy. Somebody has to verify this. Verification is not a part of the tribunal. You can allow subject to verification, I have no issue. Subject to verification is to be allowed. Let him appear for proper officer respect to verification. Other things may also to be seen.
It is obtained from the department. Thank you.
Well done.
Thank you, sir. Thank you.
You know, this is also a case where we should, as lawyers, we should know. Many times our appeal to dismiss a refund application are dismissed as time barred. Okay, no, this time barred, we don't want to entertain. You have to explore, can that application be brought within limitation? For example, in this case, had he not known the relevant date is when the ship or sails or leaves or whatever, I mean, he would have been out of the 4,50,000 gone. So therefore, whenever you get this order where refund is dismissed at time barred, understand what is that transaction. And then go through relevant date definition. There are so many relevant dates. So do you fall within one of this, and then you draft an appeal. In this case, he won because he must have gone through it.
Item number 8, Delay Enterprises, argued by CA C.K. Gupta ji. Interesting case, a question of law. The refund was withheld by the proper officer on the direction of the commissioner. Aggrieved party filed an appeal before the first appellate authority, which was dismissed due to not maintainable as the refund was withheld by the commissioner. Again, a crucial point to discuss, whether the first appellate authority was right in dismissing the appeal on non-maintainability.
This is the most important appeal of today on jurisdiction. You have the definition of adjudicating authority in section 2. You have the definition of appellate authority. Right? Refund under 54(5) has to be sanctioned by the proper officer. And that is defined in section 2, subsection 98. If your refund application for one reason or the other goes to a special commissioner and he issues a refund order or sanctions it, whether he issues the order directly or issues the order through proper officer, then can we say this is an order passed by a special commissioner, not by the proper officer? And if first appellate authority is a joint commissioner, can joint commissioner hear the order passed by special commissioner? That is the issue in this case. Yes, Tanishq.
My lord, with your permission, I take up my appeal case. Please refer to my brief synopsis. The question of law before this honorable tribunal is very crucial for implementation of the Act, as most of the orders on refund on file are passed by the officers who may be higher in rank than the first appellate authorities appointed for, or they may be of equal rank. If such a procedure is followed, then the appellant respectfully says that this would lead to impossible situations, and the very purpose of section 107 giving statutory right of appeal to the appellant may be negated by the authorities below. My lord, this appeal is very crucial, and two questions of law arise before this honorable court. Number 1, withholding of refund by the proper officer. Number 2, maintainability of appeal before the first appellate authority. My lord, the applicant has applied for refund of rupees 22,50,000 of unutilized ITC for zero rated supply of export. My lord, export is not disputed. Kindly note, export is not disputed, and ITC also is not disputed. My lord, RFD 01 was filed on 2 January and RFD 02 was issued on 13 January. My lord, refund sanction order in RFD 06 must be issued within 60 days, but the proper officer issued RFD 06 on 28 March. That is the delay of 26 days. This is a gross violation of GST laws, and some direction should be issued to the department by this Honorable Court. My Lord, after the issue of RFD 06, later on, before the refund was to be credited to the bank account of the appellant, the department alleged that there were some reports that were considered adverse by the commissioner, and the commissioner directed the proper officer to withhold the refund under section 5411, and the order for withholding was issued by the proper officer without any reason and without any supporting documents. Please note, order was issued without giving proper opportunity of being heard. This is gross violation of principle of natural justice. My Lord, these reports and documents, as aforesaid, were never made available nor confronted to us, and nor our explanation sought on any of the issues raised by the commissioner. This is against the settled principle of natural justice and makes the order on file by the commissioner patently illegal and unsustainable in the law. My Lord, the refund was withheld by the proper officer under section 5411. This section is not applicable in our case. If you see the conditions of 5411, these are not applicable. My Lord, RFD 06 final refund sanction order was never subject to matter of an appeal or further proceedings under this act or any other proceeding pending as on that date. So 5411 is not applicable. My Lord, after issue of RFD 06, the department cannot withhold the refund. Department has to give the refund in my bank account. So it is without jurisdiction. The refund along with interest must be issued to the registered person immediately. I request the Honorable Court to impose some cost on the department for the harassment to the registered person. After issue of RFD 06, refund must be credited to the bank account of the appellant. My Lord, second point. The first appellate authority observed that this appeal against the order of the commissioner conveyed by the proper officer may not be maintainable. Hence, the appeal was dismissed by the first appellate authority. Section 1071 states that any person aggrieved by any order passed under this act by an adjudicating authority may appeal to such appellate authority. My Lord, adjudicating authority has been defined under section 2(4). Means any authority appointed or authorized to pass any order under this act. Appeal against the order of the adjudicating authority lies before the first appellate authority. Hence, the appeal of the first appellate authority is legally maintainable as per the law. My Lord, Commissioner is also appointed under this act, and the Assistant Commissioner is also appointed under this act. Our proper officer was Assistant Commissioner. The first appeal lies to the first appellate authority, that was Joint Commissioner. So, how the department can say that this appeal is not maintainable? It is very well maintainable as per the law. And the allegation of the department is not valid, and the order of the first appellate authority is liable to be set aside. My Lord, my prayer, in the light of the foregoing submissions, sir, main appeal, page number 8. Main appeal, grounds of appeal, page number 8. In the light of the foregoing submissions, the appellant most respectfully prays that his Honorable Tribunal may be pleased to allow the present appeal in entirety, set aside and quash the impugned order passed by the first appellate authority and declare the interpretation of such provisions for the future guidance of the appellant and all the litigants in general. Pass such an other order or further orders in favor of the appellant as may be deemed just, equitable, and proper in the facts and circumstances of the case, in the interest of natural justice. It is further submitted that all relevant factual documents have been duly placed on the record. In the interest of affording a fair and reasonable opportunity, it is also prayed that the matter may kindly be settled here itself in accordance with the law and principle in the nature of principle natural justice.
That is why now, Your Honor, as I understand, the nature of appeal is from a junior officer to a higher officer. Even,
I'll stop you here.
yes,
Let's go to the order.
yes.
Page number?
Order page number 10. Proper officer.
This one.
And the page number 11 is for first appellate authority order.
This order, which is
Passed by Joint Commissioner.
passed by, where it is mentioned, it is passed by Joint Commissioner.
Which one, sir?
This
My lord,
order
please-
at page number
please-
10 is
Please see
passed
page
by
number 11.
assistant.
Page number 11. It is passed by the Joint Commissioner.
No, first I am coming to page number 10.
Okay.
The
proper
original order withholding.
Okay.
So this is passed by Assistant Commissioner,
Yes, sir.
Zone 10,
Right.
Zone 9, correct?
Yes.
So how this Assistant Commissioner becomes a superior authority, number one, though I am not I'm not in that controversy with you, whether he is a superior or junior officer, because appellate authority is altogether a different authority as administrative authorities, number one. But in this particular case also, if you are going by the ranks and the designations, then also this order is framed by Assistant Commissioner.
Yes, sir. We'll explain that position to you.
And the appellate authority is Joint Commissioner Appeals, though he is also a appellate authority as per Act.
Yes.
Correct? So I fail to understand how and why this controversy is there, which we are discussing.
Can I start now?
Yeah, please.
Let's, my lords, can you read section 291? 2 subsection 91.
Section 291.
Ah. (291) defines the proper officer. Proper officer in relation to any function to be performed under this act means the commissioner or the officer of central tax, or that is state tax, who is assigned that function by the commissioner in the board. Right? He is a proper officer. Let's go to appellate authority, section 28. Appellate authority means an authority appointed or authorized to hear appeals as referred to in section 107. Right?
Now let's come to 107.
Yes, sir. Yes, sir. Let's read adjudicating authority. That's also defined. Subsection 4. Adjudicating means, it's a means definition. So it's not inclusive, all are means definition. Any authority appointed or authorized to pass any order or decision under this act, but does not include the board, etc., 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 etc. Right? Now we come to the refund issue, section 54.
No, let's go to 107 first.
No, sir, first section 54, then we go to 107. We'll be able to appreciate better once we read 54. We will read 54(5) only. We will not take much time on this. If on receipt of such application, the proper officer is satisfied that the whole or part of the amount claimed as refund is refundable, he may make an order accordingly and amount so. So it is the proper officer who has to pass a refund order. Right? Now this is not a refund order. This is a refund rejection order. Let's pick up 5411. We're only reading a provision. I'm not linking it with the appeal. 5411 says, where an order giving rise to a refund is the subject matter of an appeal, which is in this case, or further proceedings, or where any other proceedings under this act is pending, and the commissioner is of the opinion that grant of such refund is likely to adversely affect the revenue in the said appeal or other proceedings on account of malfeasance, that is wrongdoing, or fraud committed, he may, after giving the taxable person an opportunity of being heard, withhold the refund till such time as he may determine. Right? So the assistant commissioner cannot withhold the refund. He has no authority. He has to send the file to commissioner. Commissioner says withhold. Now commissioner's order he is conveying to you.
Has he mentioned this fact?
Yeah, but we'll go through the order also. So let's understand the scheme first.
My lord, here I want to say one thing. We are reading subsection 11, 5411. It says where an order giving rise to a refund.
You hold on this point. Let's understand the scheme first. You argue, don't worry.
Okay, again
you will again argue, don't worry about it. I know what you want to say. Right? So 5411 is this. This case arose in Radha Swami's Industries case, where section 83 order was passed by the joint committee, by the concerned person on the direction of commissioner. When they went to Himachal Pradesh High Court in 226, they said, no, this is appealable matter, we will not entertain. When case went to Supreme Court passed strictures against Himachal High Court. He says this order was passed by commissioner. How can appeal be maintained before a lower authority? You had all the right to hear this thing, 226 petition. Because order of the commissioner, where will they go to tribunal? There is no tribunal. Tribunal to hai nahi. I'm quoting at bar. These are the sentence the Chief Justice wrote in that matter. Now similarly, before we go into facts of this case, if we come to a prima facie conclusion that this order was passed by commissioner, the assistant commissioner only acted as a conduit to pass the order. Refund rightly stopped or wrongly stopped, we are not into it.
Regarding that Radha Swami case which you are mentioning, was that order signed
Passed by commissioner.
Was signed by commissioner or?
No. It was conveyed by joint commissioner based on commissioner approval.
Same
facts.
Same facts.
Yeah, same facts.
There is no deviation.
Absolutely. Same facts. I'm quoting at bar. So what more?
That's
You
right.
can read also on phone.
I'm not saying. I'm just.
Yes. In fact, there is a noting attached in the order itself printed.
Correct.
पूरा उन्होंने handwritten noting उसमें डाली है. उन्होंने बोला this joint commissioner was conveying the order passed by commissioner. He did not pass the order. He has no authority to pass the order. So 5411 assistant commissioner no authority to pass the order. It's only commissioner.
Milord, I want to intervene.
एक मिनट अरे सुनना सबर कर ले यार. You interfere, take time. We are discussing. So now when 5411, if we come to a conclusion this order is passed by commissioner and conveyed by assistant commissioner, then this is not an order passed by assistant commissioner. Therefore, under 1071, appeal before joint commissioner cannot lie. Joint commissioner cannot sit in appeal over the decision of the commissioner. Then a functional bias will come. Well, can he say that your order is wrong? He is his delegate. Number one. Well, let me complete. Right? Now, when the case went to joint commissioner, he is a part of commissioner delegate. Now, can he sit in order of the commissioner? That is why under central, appeal goes to additional commissioner or even commissioner appeals. In state GSTs, in Delhi, you don't have these issues. In center, case will never come. Additional commissioner, if there is a commissioner appeal also. Right? But in this case, even if there was a commissioner appeal, still appeal will not lie to commissioner. Same rank officer cannot hear. Though there are few high court judgments these days it can happen, but Supreme Court is very clear on this issue. Very, very clear. So the facts of the case are, he applied for a refund. RV 06 was given. Before the payment was to be given to bank, here came the inquiry. We have done inquiry about this party, the bogus hai, jo bhi hai, whatever. Therefore, commissioner has taken the order to stop the refund. Whether 5411 rightly invoked or not, that's a different question. That's Honorable Tribunal has to consider. So this order was of the commissioner. There is no way a joint commissioner can sit in appeal over the order of the commissioner. That's a deficiency in Delhi GST department because there is no commissioner appeal here. So now we come to 107. Any person, now I will prove why he cannot hear appeal. I will prove you from 107. Any person aggrieved by any decision or order passed under this Act or the State Goods and Services Act by an adjudicating authority. We have read definition of adjudicating authority. Commissioner is not an adjudicating authority because he has delegated his powers to such an appellate authority as may prescribe within 3 months from the date. So, who is the prescribed? Joint Commissioner? Joint Commissioner is Chandresh ji?
Joint Commissioner.
Appeal Joint Commissioner aati hai Delhi mein?
Yes, sir.
Okay. Now, read 1072. That will clinch the issue that order Joint Commissioner is absolutely correct. The Commissioner may, on his own motion or upon request from the Commissioner of State, so and so, he can review and file an appeal. Will Commissioner file an appeal against his own order? Is it possible? He can't be aggrieved by his order. And Your Honor, same is 1122. If you go back to 112, there is the same power there. Then there is section 108, suo motu revision by power. Can a commissioner suo motu revise his own order? He can suo motu review. He cannot suo motu revise. So the whole scheme of the Act says that the commissioner's order have necessarily to come to tribunal. But there is another issue. The appellant loses his first right of appeal. Tribunal is the second appellate authority. So if these refund cases are passed by commissioner and litigants have to come to tribunal, their first right stands forfeited. That's a very serious lacuna in the state GSTs. In center there is no such issue. Now let's go to his facts. I will pick up page 2, third para, page 12. Yes, Your Honor, page 12. He says, I have heard the counsel at length and also gone through the grounds of appeal. In my view, keeping in view the nature of proceeding under section 1071, I do not subscribe to the view that commissioner can be deemed to be an adjudicating authority, though there is no specific exclusion in the definition of adjudicating authority in section 2.5 which we have read. However, when section 1071 is interplayed with section 1072 and construed harmoniously, in my view, the legislative intent is clear that only officers to whom the powers are delegated could be adjudicating authorities. Commissioner has not adjudicated delegated this power of refund to him in any order or circular. Otherwise, Commissioner himself being adjudicating authority, as the argument of counsel for appellant is, how would the review of the order under section 11072 being appealed so and so? In view, I hold that this appeal against orders of the Commissioner conveyed by the proper officer, as is evident in his impugned order dated 2/4/5, may not be maintainable before me. Now, if we agree, if the Honorable Tribunal finds favor with this order, in view of the legal thing we have discussed, now the case of my friend is, the Tribunal has to adjudicate the refund now. Yes, now you can speak.
Miller, the proper officer has issued the order and he is the assistant commissioner. There is a procedure in the department. The file goes to higher authorities and then it comes back to the assistant commissioner, to the proper officer. And the proper officer issues the order. How the department can say this order is of commissioner? This is not the order of the commissioner.
Yours is not a case of Chandresh, your case not of refund. Your refund has been stopped by commissioner under 5411.
Yes, sir. सर मैं आ रहा हूँ.
हाँ नहीं, पर जो आप बोल रहे हो वो ये इशू है नहीं इसमें. इस इशू एक इशू इस केस में नहीं है. आप
नहीं, मेंटेनेबिलिटी वाला इशू.
हाँ तो 5411 में मेंटेनेबिलिटी है.
लेट्स डिस्कस.
वो फैक्ट आपके फेवर में अलग हैं, लेकिन पहले आप इस पे बोलिए. आप
5411 मिलोड. RFD 06 was issued. There is no dispute on the export. There is no dispute in the ITC, and RFD 06 final sanction order for the refund was issued. Now, section 5411 says, where an order giving rise to a refund, RFD 06, is a subject matter of an appeal. No, it was not under appeal at the time of issue of 06 or further proceeding. There is no further proceeding, or where any other proceeding under this act. No other proceeding was pending under this act. So 5411 is not applicable in my case. And the department is saying the commissioner has come to some conclusion that something adverse has been received, some documents have been received. When I have received the... Okay. So this 5411 is not at all applicable in this case. Now you decide. At the time of issue of 06.
He is going into merits of 5411. We are not discussing 5411 merits of his case.
Sir, yes sir. 5411. Where an order giving rise to a refund. Where an order giving rise to a refund means RFD 06 is the subject matter of an appeal. At that time there was no appeal or further proceeding, no other further proceedings, or where any other proceeding under this act, no other proceeding under this act was pending at the time of issue of 06. Refund must be credited to my bank account. And moreover,
again is mixing two issues. First is maintainability. If this Honorable Tribunal thinks the appeal is maintainable, then the merits cannot be gone into here. See,
that course only you have taken us to 5411.
Yeah, that's on merits. Whether it's rightly invoked or not, that's also we will come on. This is rightly invoked.
No, no. Because you have yourself mentioned that as per 5411, the commissioner.
Only commissioner can do it.
But under which circumstances? That has where the order giving
My lord, that's what I'm saying. That's on merits. Whether he's rightly invoked or not, that we will discuss. We are first discussing whether this.
So in this particular case, this 5411 goes away. It has no interplay.
No,
with-
my lord, how can it go away? It's not so easy.
It has no interplay.
No. Why is not interplay? He has passed order based on 5411 order. So you can quash his order, remand it back. We have no issues. But here is out.
No, how
you
you
say that 5411 is he has passed an order in section 54. That order could be
No, that
absolutely
is
wrong.
under section 54.
11.
So 11
He can withhold only under 5411.
No, 11 is only where an order giving rise to refund.
Your Honor,
is
once again
subject
we are
matter of an
discussing
appeal.
merits of the case. We'll discuss this. We'll
but
discuss
I'm
this
saying-
first. My lord, we will discuss this.
I am asking you one thing, that where an order giving rise
My
to
lord, this is one ground. There are 4 other grounds on this. My lord is reading only one ground. There are 4 others. Allow me to speak. There are 4 other grounds.
Please tell me.
Yeah. First issue was whether this is an order conveyed by Assistant Commissioner based on order of Commissioner 5411, which is a fact. In the Shokas note, they have written.
I am saying that 5411 doesn't come in the picture till there is something in appeal.
My lord, only if you allow me to speak. Have patience with me, please. It's not easy question. Allow me to speak. Give me 5 minutes. Let's read the withholding or refund order. So what order has been passed? Refund has been withheld. It is not an adjudication order passed. Refund has been withheld. That is the heading of the order under 5411. Now we can read the second last para. Before the refund could be disbursed in the bank account of the taxpayer as per application details, some adverse reports were received. The field visits were directed. These are the proceedings that are going on. Directed to verify the bona fide of purchases made by the taxpayer. Due to verification of his purchases, field visits are planned by the GSTOs. It has been found that taxpayer may not be entitled to refund as sanctioned. In view of the above, the file was reviewed by the Commissioner State GST and he has ordered withholding of the refund. So order is passed under 5411. It is not an order of Assistant Commissioner. This is the first issue which we want to say. Now let's come on merits.
Now let's see whether this order could have been passed under 5411 or not.
Now coming, Your Honor. That's the merits. That's what I'm saying. That could be wrong. I'm not saying that's right or wrong. First is that the Joint Commissioner order was right. He is hearing appeal against order passed by Commissioner. He is not going to merits of the case.
Okay.
He said, I cannot hear this case. And he cannot. It's not possible for him to hear the case. Now let's come to 5411. That is also a correct order. Now let's come to 5411. Yes, Your Honor. उसके बाद रिफंड रुकता है 5411. हाँ तो दैट्स नंबर से ऑर्डर नहीं ऑर्डर रुकता ही तब है. क्या बोलते हैं वेयर एन लिसन क्या बोलते हैं वेयर एन ऑर्डर गिविंग राइज टू रिफंड. तो ऑर्डर हैज बीन पास्ड ओनली देन यू कैन स्टॉप. हाँ तो उसने पैसे दिए ही नहीं, बैंक से दिए ही नहीं ना. नहीं बिल्कुल ठीक है. मैं आई योर लॉर्डशिप. मुझे बोलेंगे. Yes, we'll go. Now we'll discuss 11. First part I'm not discussing because order is passed by commissioner. There is absolutely no doubt in my mind. Where an order giving rise to a refund, so RFD 0 is an order giving rise to a refund, whatever they are 2350 lakh, is a subject matter of appeal. Right? At that time it was not a subject matter of appeal. This is what my lord says. Then the word is or further proceedings, input tax verification going on, that's a proceeding. It has nothing else.
No, my lord.
अरे
At
wait,
the time of 06, there was no proceeding.
अरे वेट, हाँ उसी की बात कर रहे हैं यार, बस बोलने तो दो. मुझे पता है आपको जो आपने क्या बोलना है, मुझे पता है, फिक्र नहीं करो, मुझे सब पता है आपने क्या बोलना है. और we are discussing a law for the benefit of, we are not discussing our case. In appeal or further proceedings or where any other proceedings under this is pending, again a verification of his bona fides of purchases, and commissioner is of the opinion that grant of such refund is likely to adverse the revenue, affect the revenue in the said appeal or other proceedings on account of malfeasance or fraud committed, he may, after giving the taxable person opportunity of being heard, withhold the refund till such time as he may determine. My fair deal with the tribunal will be, he has not, commissioner has not fulfilled the ingredients of 5411. Wait, you know, right? 5411 ingredients are not fulfilled. He has not heard him, right? He has not said there is a malfeasance or fraud, right? But his order could be wrong, right? But this tribunal cannot ask a joint commissioner to sit in the order in appeal of a commissioner. That is not possible, right? So we are only on this point that this order is not maintainable. Joint commissioner order is right, appeal is not maintainable. Now the only way which I think of the honorable judges may think of the course of action is, let this case go back to commissioner. How did you pass this order? And a direction should be given to commissioner in this case. How can you pass this order? Who will hear your appeals? Tomorrow there was a deputy commissioner, assistant commissioner.
No, but he has to make him abreast about the conditions which has given.
Absolutely, Your Honor. Absolutely, Your Honor. That's why I'm saying he has not fulfilled 5411. That's merits. Yeah. But to say that joint commissioner's order is incorrect, that is no.
No, joint commissioner order is not incorrect.
But 5411 is not properly invoked. Absolutely right. I'll be fair with it.
That's what I'm saying.
No, but it's not a question of appeal and all that. There is a proceeding pending, it's absolutely right. But the later part he is not heard, no opportunity given, no malfeasance or fraudulent. We can do Renu's case next time.
We'll keep this matter also pending for the orders. Let us dwell on it more. So this order will be in the next tribunal. First on the board will be the pronouncement of order.
In the meantime, you please allow me to permit to give you judgments, more judgments.
That will be pronouncement. It is reserved for pronouncement of order for the next tribunal.
मेरे को बोलने नहीं दिया, मुझे बोलने नहीं दिया.
अरे डिसमिस तो नहीं होगी, आपने यही बोलना था जो मैंने बोला, आपके आप ही बोला है, आपने और क्या बोलना था? रिफंड जहां नहीं मिल सकता आपको.
Sir, my lord, the government counsel is misguiding the tribunal.
Oh my God.
My lord, if you see the definition of adjudicating authority, order of the adjudicating authority lies before the first appellate authority. How you can say this is the order of the commissioner? Proper officer order is not a order of the commissioner. Direction तो मिलती है, जो भी procedure adopt किया जाता है, but that is not the order of the commissioner. It is the order of the proper officer.
अरे 5411 का ऑर्डर कमिश्नर ने पास किया, उसको बोला इस पेट्रोल रिफंड कर दो, फाइल पे उसका ऑर्डर है.
सर आज तक हमें जो है ये नहीं बताया गया कि क्या प्रोसीडिंग हमारे अगेंस्ट एडवर्स हैं, क्या डॉक्यूमेंट्स हैं. इस अपील को फाइल करने के बाद आज भी गवर्नमेंट काउंसिल ने वो पेपर्स अवेलेबल नहीं कराए.
पेपर मैंने सुनने देने भैया, प्रॉपर ऑफिसर जाके मांगो.
Sir, you are representing the revenue.
I'm not supposed to give you any papers. Your case, you prove it.
Chandra ji, inspection.
Members,
You should have applied for inspection and got the proper documents.
since the time is running fast, we are adjourning the court for the day, and rest of the matters will be taken up in the next Moot Tribunal.
I request Mr. Bhatia to say a few words about what happened today.
अरे बैठिए से बैठे हैं, बैठिए साहब, आइए आइए.
मेरे खिलाफ वकीलों को भड़काते हैं, कह रहे पकड़ा.
Sir, before you speak, I request you to please give memento to our new consuls. First one is Mukesh Khandelwal ji and Monil Agrawal ji. CA Gunjan Jain ji. Advocate BB Diwan ji. फोटो ले लो युगल, फोटो ले लो एक एक करके सबकी. पहले फोटो ले लो.
वर्मा जी कहाँ हैं?
आप करो सर.
अरे आ जाइए सर. उन लोगों को अच्छा लगेगा मुझसे ज्यादा.
आपके ज्यादा, मैं तो आपके आपकी ज्यादा हैंडसम हूँ.
युगल सभी की फोटो आनी चाहिए. अगली बार मेरे को कन्वेनर रहना है.
रश्मि की तो देखिए भैया, आज का तो रूप देखा आपने आज.
हाँ. सीए गुंजन जैन जी फटाफट आइए और अपना मोमेंटो लीजिएगा. एडवोकेट दीवान जी. एडवोकेट तनिष्क आहूजा. एडवोकेट तनिष्क बीवी दीवान जी. बीवी दीवान जी अपना मोमेंटो ले लो यार. अरे एक एक करके पहले फोटो तो लेने दो उनको. सारे इकट्ठे ले लो यार. तनिष्क. तनिष्क का रह गया सर. इससे पहले कि मैं गुप्ता जी को वोट ऑफ थैंक्स के लिए बुलाऊं, वो है नहीं. इससे पहले कि गुप्ता जी को वोट ऑफ थैंक्स के लिए बुलाऊं, भाटिया जी से रिक्वेस्ट करूंगा आइए और अपना आज के सेशन के बारे में कुछ रोशनी डालिए सर.
आज के सेशन के लिए जितना भी कहा जाए कम है. इनफैक्ट वर्ड्स इसको डिस्क्राइब ही नहीं कर सकते. आज सारे दिन के अंदर जो कुछ हुआ है इसको सिर्फ महसूस किया जा सकता है. और किसी भी रियल कोर्ट से, चाहे वो हाई कोर्ट हो चाहे वो ट्राइब्यूनल हो, उससे कम नहीं थे आज के सारे सेशंस. हमारे जो दोनों जजेस हैं, जिस तरह के पॉइंटेड क्वेश्चंस आप लोगों ने पूछे हैं, हाई कोर्ट में भी जब कोर्ट के अंदर हम होते हैं उस वहाँ हाई कोर्ट में भी कई बार इस तरह के पॉइंटेड क्वेश्चन नहीं पूछे जाते जो आप लोगों ने पूछे हैं आपके लिए. और जो अपेलेंट्स काउंसिल थे, हम सब जानते हैं कि किस तरह के अपेलेंट्स को उनको रिप्रेजेंट करना पड़ रहा था. और इसके बावजूद जो उन्होंने स्टैंड लिया, इट वाज रिमार्केबल. चाहे नरेंद्र आहूजा जी के लिए कहें, नहीं चाहे रश्मि के लिए कहें, और सीके गुप्ता जी ने तो वर्मा जी को एक बार कॉर्नर ही कर दिया था. पर एक चीज़ मैं कहना चाहता हूं कि जब आप ये देखें कि कहीं एक आप ऐसा ग्राउंड ले रहे हैं विच गोज टू द रूट ऑफ jurisdiction of the authority to pass that order, then you should stick to that mainly and insist the court to first decide that jurisdictional issue. Because if on the ground of lack of jurisdiction or on account of want of jurisdiction the order has to fall, then you don't have to go to merits. क्योंकि कई बार merits के अंदर आप फंस जाते हैं. अब मान लीजिए जैसे आपने शुरू में कहा था, बाद में वर्मा जी ने बताया कि नहीं वो सेक्शन 74 का भी नोटिस आपको मिला था. Supposing he has carried on the proceedings, given you all the opportunities, given you relied upon documents, you have replied to those documents also, but because notice under section 74 is a jurisdictional notice. पुराने टाइम में कहा जाता था कि so far as assessment is concerned, assessment के लिए तो assessing authority has the inherent jurisdiction to frame the assessment. But जब reassessment की बात आती थी तो बहुत सारे, there are umpteen number of cases which say that if so far as reassessment is concerned, unless the condition precedent is satisfied, which is issuance of a notice, and if that notice has not been issued, then reassessment has to go. The same principle, according to me, would apply to section 74 also, because there you are alleging fraud, suppression of facts, concealment. So these are jurisdictional issues. This is a jurisdictional section. Unless the condition precedent, which is issuance of a notice under section 74, because we also know, by now we all know that assessing authority, assessing officer or adjudicating authority cannot go beyond the show cause notice. And if the show cause notice itself has not been issued, then the order has to go, howsoever strong or howsoever strong that order may be, howsoever meritorious that order may be. तो अगर इस तरह का कोई इशू हो तो सिर्फ उसी को कंफाइन करें. पर जिस तरह से रश्मि ने या आपने रिप्रेजेंट किया, हेड्स ऑफ टू बोथ ऑफ यू, तानिश उनका, हाँ मैं 10 मिनट के लिए गया था. अच्छा, बहुत अच्छी बात. भाई बेटा किसका है वो तो देखिए ना. अच्छा, ऐसा ही होता है जब बच्चा अच्छा कर रहा होता है सब लोग कहते हैं हमारा है, हमारा. हाँ, फिर कहते हैं उसने पढ़ाया नहीं, सिखाया ही नहीं, फिर तो ये कहा जाता है अगर अच्छा नहीं करता तो. और एक दो चीज़ें जो मैंने ऑब्जर्व, और वर्मा जी का तो मैं कहा ना इसका तो नाम ही बदल देना चाहिए. और वो शायद सही कह रहे थे, बिल्कुल सही कह रहे थे कि जब इनको एक ट्रिब्यूनल मेंबर ने कहा कि आप तो जो है क्रिमिनल के हाँ लॉयर होना चाहिए था आपको. जिस तरह से इन्होंने द वे ही डग आउट दोज डॉक्यूमेंट्स एंड रिलाइड अपॉन, नहीं तो ये लग रहा था कि ये भी केस जीते हुए हैं, वो भी केस जीती हुई हैं, और ये इन्हीं को क्रेडिट जाता है कि इस तरह की मेरिटोरियस अपील्स को भी डिसमिस करवा दिया इन्होंने. और जो सीके गुप्ता जी ने कहा हमेशा ये होता है, जो अपेलेंट्स काउंसिल होंगे वो हमेशा यही कहेंगे, मदर द गवर्नमेंट काउंसिल इज ट्राइंग टू मिसलीड द कोर्ट. ये एक पेट सेंटेंस होता है सबका. एक मेरे को पर ये शुरू से चला आया. अच्छा, जो वर्मा जी ने शुरू में एक बात कही थी प्रॉपर ऑफिसर की, उसके बारे में सिर्फ एक मैं कमेंट करूँ. यस, देयर कैन बी ओनली वन प्रॉपर ऑफिसर क्वा एन असेसी. देयर कैन नॉट बी 2 और मोर प्रॉपर ऑफिसर्स. जैसे आपने वर्मा जी एग्जांपल दिया था कि ऑर्डर पास कर दिया स्पेशल कमिश्नर ने, हु इज़ ऑल्सो द अपेलेट अथॉरिटी, ही इज़ नॉट द प्रॉपर ऑफिसर. हमें वी केम अक्रॉस ए केस वेयर for the same year, for the same amount of refund, one order was passed by the jurisdictional officer and one similar order was passed by the special commissioner also. That is under challenge before the High Court, and where one of the grounds is that yes, there cannot be 2 proper officers. पर मैं ये समझता हूँ कि जितना आप लोग जितने भी आए हैं, मेरे को पता चला कि बहुत दूर दूर से भी लोग आए हैं, राजस्थान से भी आए हैं, इंदौर से भी आए हैं, और जगह से आए हैं, यमुनानगर से आए हैं. बिल्कुल उसके साथ मैं कह रहा हूँ कि जो कुछ यहाँ आपको सीखने में मिलेगा या मिल रहा है, किसी भी सीनियर से सीनियर आप काउंसिल के ज्वाइन कर लें, उसके अंडर काम कर लें, वहाँ भी इतना सीखने को नहीं मिलेगा जो यहाँ आपको सीखने को मिल रहा है और मिलेगा आपको. सिर्फ एक दो चीज़ें जो मैंने नोट की कि कोर्ट के अंदर ना प्रोनाउंसिएशन भी ज़रूरी होता है. एक तो सबसे बड़ी चीज़ कि हाई कोर्ट के अंदर आजकल हमारी आदत है कि हम यस के बदले यस सेकंड में या बोलते हैं. ये जजेस को भी बिल्कुल अच्छा नहीं लगता न काउंसिल्स को बोलना चाहिए, न जजेस बल्कि इसको डेप्रिकेट करते हैं इस तरह के उसको। और एक और था दिमाग के अंदर, हाँ, जब हम प्रोवाइजो को या दो सेक्शंस को कंजंक्शन के अंदर, मैन वी आर रीडिंग टू सेक्शंस इन कंजंक्शन, मैंने एक नोट किया, सिर्फ ये बहुत छोटी छोटी चीज़ें हैं, बट प्रोनाउंसिएशन के बारे में हम लिख देते हैं, कह देते हैं प्रोवाइजो रीड विद, स्पेलिंग चाहे READ है, रेड विद होगा, रीड विद नहीं होगा। कई बार हम लॉ को या थोड़ा सा हमें प्रोनाउंसिएशन का भी ध्यान रखना चाहिए, हालांकि मैं मानता हूँ कि हम लोग जो है ना अपनी हिंदी वाली इंग्लिश बोलते हैं, पंजाबी वाली, हिंदी वाली, इस तरह की, और शायद इस तरह की इंग्लिश अगर अंग्रेज़ों के ज़माने में बोल रहे होते तो बहुत पहले वो हिंदुस्तान छोड़ के चले गए होते। आप सबका बहुत बहुत इतनी पेशेंस के साथ बैठने के लिए और सबको सुनने के लिए। इस तरह से मैं देख रहा था जिस तरह से आप लोगों ने सुना है और जो आपके रिएक्शन थे, मैं इसलिए जब बाद में आता हूँ, लंच के बाद आता हूँ, पीछे इसीलिए बैठ जाता हूँ कि लोगों के क्या रिएक्शन आ रहे हैं, कोशिश करता हूँ कि वो आई ट्राई टू रीड देयर रिएक्शंस। आप सबका बहुत बहुत धन्यवाद है यहाँ आने के लिए, और सबसे बड़ा धन्यवाद हम सब की तरफ से वर्मा जी का होना चाहिए, जजेस का होना चाहिए, और जो पार्टिसिपेंट्स हैं उनका होना चाहिए। थैंक यू ऑल।
अभी रुको भैया, अभी पैसे मिलने हैं।
रुको।
अभी रुको, अभी बैठो।
Members are requested to wait for only 5 minutes more, please.
अभी तो क्लाइमैक्स है बहुत जबरदस्त।
It's time to announce the prizes, and I request SV sir to announce the prize money and winners. Prize money तो मुझे मालूम है।
Well, friends, thank you so much. Even at this time, we have large number of people. Watch this YouTube again and again. The arguments put forward in the morning 3 cases are very good arguments. Though they had the worst cases possible, they could have never won, but they almost won. Had I not been there, the honorable judges would have given them relief.
Yes.
Surely about. And then you have, he's my guru, Mr. S.C. Bhatia was my teacher. When you are such people giving words of wisdom and such handsome and full of wisdom judges, we are bound to do well, all of us. These appeals will be uploaded on the website by Madam Rajmani by tomorrow evening. You can draw this. But when you go back, live with it for a day. That is why you should feel these walls that you came to this Moot tribunal. दीवारें भी आपको कुछ कहती हैं। नए घर में जाते ईंटें हो तो दीवारों को मजा नहीं आता। जब दीवारों में ऐसे रंग चढ़े होते हैं, लोग बैठे हों, the feeling is different. And try to be honest with your brief. Don't get scared. They were trying to scare me, misguide. I don't get scared of anybody in life. But when you speak this language, you instigate the other party to do well. If you have a weak case, take date and get out. By speaking this aggressive language, it doesn't help. Either side, this side or that side, it doesn't help. But government counsel has no stake. You guys have a lot of stakes. Therefore, try to be humble. Humility pays in law. I've never seen Kapil Sibal abusing anybody. Harish Salve gets aggressive, not Kapil Sibal. Mr. Bhatia also used to get aggressive, but his aggression was not personal. And I have been a most aggressive lawyer myself all over the country. But I have never tried to abuse the process. Right? To even also, when they grill me, I don't feel offended. This is their job. I'm also doing a job. Be a good listener. That's a very difficult proposition. A lawyer must listen. You can never learn 54. You read it 100 times, you cannot understand. When you listen to these arguments, the judges, the lawyers, other wisdom things, you learn more. Try to remain smart. a lawyer should not be a lazy-like character. And always remember, we are officers of the court. Respect to the chairs should never be undermined at any cost. As long as you have judges sitting in the chair, they are in a temple. So you are sitting in a temple. Don't abuse anybody. And never abuse your colleagues. Cases may be referred to you because the client thinks you are a better lawyer than the earlier lawyer or whatever. But no, that language is not called for. And today I am so happy that one person could pinpoint a mistake in Shoka's notice, that of Moni Lagalwal. And he gets the first prize only for this issue. So you get 8,000 rupees cash you will get. Second prize, in a biased manner, I'll give it to Mr. Tanishq Ahuja. He had a very small point, but imagine the victory has won, you may not have noticed. What he did, nobody did. He told the honorable judges, I'll deposit money, give me liberty to approach back to you. If tomorrow 180 days the issue is decided in favor of assessee, he doesn't have to bother. He simply has to put an application, interrogatory application with a whatever stamp, and refund is given. So he gets second prize, and the third prize goes to my friend BB Diwan. This was his first appeal, and he did very well. It was first appeal, and he argued well, he spoke very well. I was very worried whether he will speak well or not, because I've never seen him arguing in tribunal. So one prize is biased because of Tanishq Ahuja, because he's my son. But Narender, Rajmani, Rashmi, Chandresh has to still learn a lot. Being aggressive doesn't mean being abrasive. You should never be abrasive. You will gain nothing by being abrasive in law, because you lose your control of your thought process. Never be abrasive. Be aggressive, but make a law point. When judges are reading, when judges are querying, you should never interfere. No senior lawyer interferes when judges talk. We have no right. So what happens when we trouble them? Their own thought process goes for a6. And then most of the time, if they were going on a positive direction, they may triple back. So once you have to go to become a tribunal lawyer, humility, your voice, your paper preparation should be very good. Gunjan Jain argued very well, but this was an appeal given to him. I don't think in our bar any lawyer can draft even appeal on this issue. Any lawyer in our bar. It was such an issue of mistake of law. But maybe he didn't know much about intricacies, and I'm telling him to refile this appeal for next tribunal. Next tribunal will be in the month of August. We'll announce the date, and that will be on works contract and government services. This is the biggest litigation area is going to happen in this country is works contract. लाखों करोड़ का infrastructure है. Arbitration है इसमें बड़ा कुछ है. So we will try to hold one lecture in between the Moot tribunal. I will take up a day session on works contract issue also, because I think I know a little more on this issue because I work only in this line. And before we end, let's clap for our honorable judges, Honorable Chairman Dr. Rakesh Kumar ji, Honorable Member KP Singh Saab, and sir, we bow down before you. Thank you so much for your time and for your wonderful wisdom. We are grateful to you, all of us. And DGST Group will stand with you ever, for always. Thank you so much.
Now it's time for the formal vote of thanks. आइए गुप्ता जी formal vote.
पैसे बांटो.
किसको कितने देने हैं?
And for your information, this prize money was sanctioned by Shri S.C. Bhatia out of his love for this group. This money is not, I am not giving from my pocket. So Rajmani, I kept this money safe. Yes, sir.
First, second, third मेरे पास है. ले लेना आगे. फिलहाल मेरी जेब में. अरे जिनको जो बात है उनको तो दो भाई. हाँ तो इनको तो दो. चाय पी के जाएंगे.
Members.
वर्मा जी के लिए भी होनी चाहिए स्टैंडिंग ओवेशन भी और क्लैपिंग भी.
What a fantastic moot court is today. on behalf of Delhi GST Professional Group, we are thankful to our respected both the judges, Dr. Advocate Rakesh Kumar ji and CA KP Singh ji, for delivering such wonderful judgments in all the appeals before them. This time it was two-member bench. The workload on the judges was much high, but they have taken it very well. Thank you, sir. We are also thankful to Advocate S.C. Bhatia, sir, for their continued support and blessings on this group. Thank you, sir. What to say about SV, sir?